ನಾನು ಹೀಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ, ನಾನು ಕಳಿಸಿಲ್ಲ. KCR ಏನು? KCR ಏನು? ಇಯರ್ ಬಾಕಿ.
ಯಾವ ಇಯರ್ ಅಂತ ಮಂಡೆಗೆ ಆಗುತ್ತೆ ಸರ್ ಅಟ್ಲೀಸ್ಟ್ ಅದು.
ಅಲ್ಲೇ ಮಂಡೆಗೆ ಆಗಲ್ಲ ಸರ್, ಹೇಳಿದ್ನಲ್ಲ ನಾನು.
ಅದು ನೆನ್ನೆ ಲೀಸ್ಟ್ ಆಗಿತ್ತು, ರೀಚ್ ಆಗ್ಲಿಲ್ಲ.
ಒಂದು ವಾರ ಬಿಡ್ತಾರಲ್ಲ, ಅಲ್ಲಿ 1 ವೀಕ್ ವೇಟ್ ಮಾಡಲೇಬೇಕು. ಆ ಥರ ಇದ್ರೆ ಹೋಗಲ್ಲ, ಮಿಸ್ ಆಗಲ್ಲ. ಇನ್ನೇನಕ್ಕೆಲ್ಲ ಇವತ್ತು ಕೊಟ್ಟರೆ ಇನ್ನು ಫೈಲೇ ಹೋಗಿರಲ್ಲ ಸರ್, ಅದು ಫೈಲ್ ಹೋಗ್ಬೇಕು.
ಅರ್ಜೆಂಟ್ ಇದೆ ಸರ್, ಅದು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದೀನಿ ಆಗಿಲ್ಲ.
ಸರಲ್ಲ 1 ವೀಕ್ ಅಂತ ಬರ್ದಿರ್ತೀವಿ, 1 ವೀಕ್ ಮುಂಚೆನೆ ಪೋಸ್ಟ್ ಆಗ್ಬಿಡತ್ತೆ.
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಇದೆ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಇದೆ.
1 ವೀಕ್ ಆಗ್ಬೇಕು ಅದಕ್ಕೆಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ವೀಕು ಪೋಸ್ಟ್ ಆಗಲ್ವಲ್ಲ ಸರ್ ವಿತೌಟ್ ನೀವು
ಕೊಡ್ಬೇಕು. ನೀವು ಈಗಲೇ ಒಂದು ಮುಂಚೆನೆ ಕೊಟ್ಟರೆ ನೀವೇ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ
ಏನ್ ಮಾಡೋದು ಸರ್. ಡಿಸೈಡ್ ಮಾಡೋದು
ಸುಮ್ಮನೆ ಇರ್ತೀರ, ಆಗಲ್ಲ ಅಂತೇಳಿ. ಆಗತ್ತ ಬಿಡತ್ತ, ಆಮೇಲೆ 1 ವಾರ ವೇಟ್ ಮಾಡಿ ನೋಡಿದ್ರೆ ಕೊಡಲ್ಲ.
ಅಲ್ಲ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು, ಆಗತ್ತಲ್ವಾ?
ಏನ್ ಹೇಳಿದ್ರು, 1 ವಾರ ಆದ್ರೂ ಆಗಲ್ಲ ಅಂತ.
ಮಂಡ್ಯಗಾರ ನೋಡಿ ಸರ್,
ಮಂಡ್ಯಕ್ಕೆ ಬರಲ್ಲ ಸರ್, 1 ವೀಕ್ ಪೋಸ್ಟ್ ಆಗಲ್ಲ
ಸರ್. ಒಂದು ಟ್ಯೂಸ್ಡೇ ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇಗೆ
6 ಮೇಲೆ ನನಗೆ ಬೇಕಾಗಲ್ಲ. 1 ವೀಕ್ ಆದ್ರೂ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಕೊಟ್ಟಾಗ ಮಾತ್ರ ಬೇಕಾಗ್ತೀನಿ, ಇಲ್ಲ ಅಂದ್ರೆ
ಕೊಟ್ಟಿರಲ್ಲ.
ಇಲ್ಲ
2:30
ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಕೊಟ್ರೆ ಇಲ್ಲ, ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಬರೋದಲ್ಲ.
ಏನಿದೆ ಸರ್ ಇದು?
ವೆಕೇಟಿಂಗ್ ಅಯ್ಯೇ ಹಾಕಿದೀವಿ ನಾವೇ.
ಸೀನಿಯಾರಿಟಿ ವೈಸ್ ಎಷ್ಟೊಂದು ಜನ
24 ಸರ್, ಯಾವಾಗ ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಸರ್. ಹಾ ಅಲ್ಲ, ಮೆನ್ಷನ್ ನಾ ಮಾಡ್ಲಾ ಒಂದ್ಸತಿ, ಮಾಡ್ಬಿಟ್ಟು ಒಂದ್ಸತಿ ಕೊಡ್ತೀನಿ, ಬರ್ತಿದ್ರ.
ಹಾ ಮಾಡಿ. ಇನ್ ಸ್ಯಾಟಿಸ್ಫ್ಯಾಕ್ಷನ್.
ಹಾ ಅಷ್ಟೇ. ನಾಳೆ
ತಗೊಳ್ಳಿ.
ಅದೇ ಇದೊಂದು ನಾವು ನಾನು ಯಾವ ವಿವರಣೆ ಇಟ್ಕೊಳ್ಳೋದಿಲ್ಲ. ನಾವು ಮಾಡೋ ಕೆಲಸದ ಮೇಲೆ ಮತ್ತೆ ಕೇಳ್ತಾ ಇದ್ರೆ ನಮಗೂ ಇದಾಗ್ತದೆ. ನಾವು ಹೇಳಿಲ್ಲ ಅಂತ ನಮ್ಮ ಹತ್ರ ಹೇಳೋದು ಕೆಲಸ ನೀವು ಕಳಿಸಿಲ್ಲ ಅಂದ್ರೆ ನಾನು ಕಳಿಸ್ತೀನಿ, ನನಗೆ ಗೊತ್ತಿರಲ್ಲ ಎಷ್ಟು ನಾವು ಬರ್ದು ಕಳಿಸ್ತೀನಿ ಅಂತೇಳಿ. ಮಾತ್ರ ಪೋಸ್ಟ್ ಆಗುತ್ತೆ, ವೆಡ್ನೆಸ್ಡೇ ಇಲ್ಲ ಕಳಿಸ್ತೀವಿ.
Then make a number submission in there.
Fresh matters, preliminary matters you can give.
Ma'am, this is your lordship in this respect.
Matters, preliminary matters you can give.
I have filed one IAS in vacating of the stay, my lord.
Please give.
May I submit in this, your lordship, in this case, in 2021, I am the option purchaser in this case, your lordship. 2021, I have purchased the property, made the entire sale consideration, your lordship. They applied for then stay was granted by this in 2021. Again in 2020 dismissed, then sale deed was executed. Then again, February 24, it was dismissed.
What you want now?
Stay, vacate the stay, ಅದು ಏನಾಗ್ತದೆ ಸ್ವಾಮಿ, ಡೈಲಿ vacate the stay. ಡೈಲಿ ಬರ್ತಾ ಇದೆ ಸ್ವಾಮಿ, ಡೈಲಿ 40
Reach ಆಗದೆ ನಾವೇನ್ ಮಾಡಕ್ಕಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಬೇರೆ, your lordship, from 21 I am suffering, your lordship.
It can't be taken out of listed, yes.
Your lordship, this.
Yes. Huh? You have filed a application for early hearing. You have filed an application for early hearing. Please give it. Please give it. Yes.
My lord, it's
Yeah, Chief Counsel mentioned.
Lord, there is the urgency is for this, my lords. Pertaining to Vakkaligiri Sangha elections, Vakkaligiri Sangha Executive Committee meeting where no confidence motion is moved. Lords, they say that 2 of the Executive Committee members are suspended. One of the Executive Committee members approaches the court and seeks for permission to participate in the proceedings. Caveat is filed. The caveator counsel says, I am not available today. We file an affidavit saying that let the matter be taken up. These are the affidavits, sent it by mail, sent it by WhatsApp and all possible communications. He says he receives, he signs everything he does, he doesn't come. Court says, no, in the absence of the lawyer, I cannot take it. Meeting is on 9th. Court fixes the date on 12th. Even the court refused to give the hand summons in a suit. Now the injunction is sought for that I cannot be prevented from participating in the executive committee on the basis of a suspension which they alleged to have passed on 8/8/2024, which comes into light only yesterday.
Matters to be listed for preliminary hearing.
For preliminary hearing, my lords, but the reason why I am making a mention is meeting is on 9th. I am requesting for end of the list today, my lords. Meeting is on 9th.
ಆಯ್ತು ತಗೊಳ್ಳಿ.
Please, my lords,
Yes.
great.
My lord, writ petition by the decree holder, wherein,
Why are you mentioning? You please give it.
your honors, that
Please
the
call
case
out.
is listed
Please
tomorrow.
Yes. Serial number one.
List 2, serial number 9.
Yes.
Has become infractions. List 2, serial number 9.
29 memo filed, madam.
List 2, serial number 9.
One nimsham.
Learned counsel for petitioner has filed a memo dated 4/9/2024 stating that the small causes case
Yes, my lord, smart. Has been disposed of on, my lord.
number 1949 of 2016, from out of which the present petition arises, has been disposed of
On 30th.
on 30/5/2023.
Yes.
And therefore the prayer made in the petition has become infectious.
Please.
Full stop. The memo is taken on record subject to all just exceptions.
Master,
Accordingly, the petition stands disposed of in view of the other.
Serial number 7 is also.
ಕೊಡ್ರಿ, ಯಾಕೆ ರಿಂಗ್ ಮಾಡ್ತಿದ್ದೀರಾ? If you don't want, you keep it with you. Yes.
7.
Yes, please call out.
Serial number 7, my lords, has become infractuous. I filed a memo for withdrawal.
List 2.
List 2. Permitted to withdraw, my lords, as not pressed.
Same order. Memo dated 4/9/2024. ಏನು ಡಿಸ್ಪೋಸ್ ಆಗಿರೋದು?
My lords, the execution proceedings, this.
ಬರೆಯೋದ್ ಬೇಡ ಬನ್ರಿ, ಏನು ಬರೆಯೋದಿಲ್ವಲ್ರಿ ನೀವು ಮೆಮೋ ಅಲ್ಲಿ? ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೇಸ್ ನಂಬರ್?
Lords, I'll give that. Lords.
ಎಸ್.
ಮೆಮೋ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಮೇಲೆ 29 ಮೆಮೋ ಪೋಸ್ಟ್ ಮಾಡಿದ್ದೀವಿ. 31st ಬರಬೇಕಾಯ್ತು, ಮೆಮೋ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ so far. Matter is.
Please call out.
List number 1, for preliminary serial number 1, Madhusudan NK.
Yes.
Sir, pen ಇದೆ.
Allowing the application filed under order 26 rule 9 for appointing the surveyor to conduct the survey of the scheduled property. Where the suit The nature of the suit is for declaration and mandatory injunction. Wherein the petitioner hearing is the absolute owner of site number 51 and 52, which is carved out of survey number 91/1, which is situated in Kasaba of the Tumkur Nagar. Thereafter, the defendant, page number 19, wherein schedule A, it is a total extent of site number 51 and 52, which is measuring 40 into 60 minutes. The northern portion of the 51 site number has been encroached by the defendant here. Thereafter, they filed a written statement stating that they.
When the matter is set down for arguments, you have filed the application.
Now it is
That is
posted
the
for-
reason why the application has been rejected.
Now it is posted for DW2 cross-examination.
No. It is said it is set down for arguments.
After the 20th cross-examination,
Ah.
have filed an application. Thereafter, DW1 has been read the evidence. Same day, the cross-examination has been closed.
Hmm.
Thereafter, I have made an application for court commissioner appointment.
Hmm.
There was application for recall and reopen. Again, the cross-examination of DW1 is reopened.
Where is the, this is the order sheet. When have you filed the application?
Application dated 15/4/2023, madam.
Fifteen four 2023.
I have filed an application for.
Ah. 15/4/2023.
This,
DW1 filed
on the same.
IA under order 8 rule 1A.
Please, my lord, for additional documents.
IA is allowed and permitted the DW1 to produce documents.
But on same day, the cross-examination of DW1 has been closed. Thereafter, I made an application for appointment of the court surveyor to conduct the detailed survey and file.
No, that has happened on 24/3. 24/3. Hence DW1 cross taken as closed.
It's on the same day, they marked the document and DW1 cross-examination.
Defendant submit there is no further evidence to make for arguments by 15/4/2023. On 15/4/2023, you have filed the application.
Thereafter, I have filed a written argument also without considering the merit of the application.
Written arguments
I have filed the written argument.
for what?
Application for the application.
That is not permissible. You can't file written arguments for an application, sir. Not permissible. Yes.
Thereafter, the application has been
Uh,
rejected stating it is an belated application method. Wherein section
2018 suit,
16.
2018.
Because the only here is that, my lord, they are contending that they are the owners of 57.
Where is your application?
Annex F, my lord, page number 119.
What have you stated in the affidavit?
The portion of the land, north portion of the 51 site has been illegally encroached and they have put up the construction also, my.
ಅದೇನು B schedule property ಅಂದ್ರೇನು?
Rescheduled property is the encroached property by the defendant.
Huh?
Encroached property, so the encroached portion of the property, which measures east to west 40 and north to south 27.5 feet, has been encroached by the defendant.
Where is the schedule?
Page number 90, my lord, of plate
90.
90. Schedule A is the full extent of survey number, site number 51 and 52, my lord. Measures 40 into 60, my lord. This portion they have encroached, it's 40 into 27.5, that is rescheduled property.
The property, A schedule property is measuring 40/60.
Yeah, totally 50, that is site number 51 and 52, adjacent site, both are owned by the petitioner.
ಎರಡು ಸೇರಿ
ಎರಡು ಸೇರಿ sir.
40/60.
ಹೌದು. ಈಗ ಅವರು ಅದರಲ್ಲಿ 51 ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಅರ್ಧ ಪ್ರಾಪರ್ಟಿನ ಎನ್ಕ್ರೋಚ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಔಟ್ ಸೈಡ್ ಬೇರೆ ಕಡೆ ಇದೆ ಆ ಲೇಔಟ್ ಅಲ್ಲಿ. ಆ ಸೈಟ್ ನ ಬಿಟ್ಬಿಟ್ಟು ನಮ್ ಸೈಟ್ ಅಲ್ಲಿ
Layout, it's a layout formed by whom?
It is not a private layout. There is no registered document to.
It is not a sanctioned layout, not a sanctioned layout, revenue layout. ಬರ್ಕೊಳ್ಳಿ. Issue notice to the respondents. The petitioner is also permitted to serve copy of the writ petition along with annexures from the learned counsel representing the respondents before the trial court. Next para. Learned counsel for the petitioner submits that on 2023, additional documents were permitted to be produced by DW1 and the cross-examination was taken as closed on the ground that the plaintiff is absent. Please stop. The matter was listed on 15/4/2023 for arguments. On 15/4/2023, the petitioner plaintiff filed IA number ಏನಿದು?
A number ಕೊಟ್ಟಿದ್ದಾರೆ. They have stated that.
IA under order 26 rule 9 of CPC for appointment of a court commissioner. On 29/5/2023, the defendant filed objection. The matter was heard and disposed of on 28/6/2023. On 28/6/23, the court granted liberty to the plaintiff to file written arguments on the said application, and the case was reserved for orders. On 9/8/2023, the impugned order is passed.
23, I have filed a written argument.
On 13/9/2023, the impugned order is passed, rejecting the same only on the ground that the application was filed at a belated stage after the matter was posted for arguments. Full stop. Learned counsel submits that since the application was required to be filed immediately after completion of the evidence, the petitioner plaintiff has filed the application on the day when the cross-examination of DW1 was taken as nil,
State of.
on the very next date. On the very next date when the matter was directed to be listed for arguments. Full stop. Therefore, the court could not have rejected the application on that ground. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 13/9/2023 in OS number 72 of 2018 and all further proceedings thereto, till the next date of hearing.
Serial number 2.
I
YK
appeal
Narayan
for the-
Sharma.
I appeal for the petitioner, my lord. This is a matter, a suit for partition. Suit for partition is filed by the sister against the brother, after the death of the father. In that, the wife of the first defendant filed an application to implead herself as party because she has made additional construction on the house and also invested huge amounts and discharged the loan of the father. So she spent by selling her sites got from her parents. And so I am a necessary party, I am in possession, and I have also let out 2 portions like that. She filed an application. The defendant also filed a written statement saying that I am not having any income and the loan was discharged by my daughter by selling her sites. So all these things are stated by the defendant also. Now the application is dismissed for the purpose of deciding the real controversy between the parties, and finally to decide her presence is required. Otherwise, possession taking also difficult. It is suit for partition. The husband and wife, that's a brother and sister. So the necessary party or at least proper party to decide the dispute. That application is rejected. Against that, I want to be a party and to sail with the husband, and also decide my claim also be decided in the partition suit. It's a partition suit. That is why that all these things be decided. Part 1 Rule 10 application filed by me is dismissed. So to decide the entire thing comprehensively, it is required. And it is about 16 lakhs and odd she spent on the property.
Yes, what is the reasoning?
Reasoning is the husband is a party, not necessary. That's the main. There is nothing else.
Barkul. Issue notice to respond number 1.
Yes.
Plaintiff. Notice to respond number 2 is not necessary, since respond number 2 is the husband of the petitioner.
Yes, my lord.
And the defendant in the suit.
Yes.
Full stop. No relief is claimed against respondent number 2.
Yes.
Full stop. The petitioner is also permitted to serve a copy of the petition along with annexures on learned counsel for learned counsel representing respondent number 1 before the trial court. Next para. Learned counsel for the petitioner submits that a suit for partition and separate possession is filed by respondent number 1 against her brother, respondent number 2. Full stop. The petitioner herein filed an application to implead herself on the ground that
He has spent money on the property and constructed, repaired and other things. And discharged the loan of the father by selling her own property got from her mother.
on the ground that the petitioner has spent her personal funds for repairing the suit schedule property
And discharging the loan of the father also.
and for discharging the loans obtained by the father-in-law to the tune of rupees 16,25,000. Full stop. It is therefore the contention of the petitioner that she has certain rights independent of the fact that she is the wife of the defendant. Full stop. Therefore, comma, in your for protecting her own interest and seeking shares in the social property, comma, she becomes a necessary party to the proceedings. Full stop. However, the application has been rejected on the ground that the petitioner's husband is the defendant and he will take care of her interest. Full stop. Learned counsel submits that when the contention of the petitioner is that she has independent rights over the suit schedule property, comma, question of her husband representing her and protecting her rights, comma, would not arise. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated so and so.
Order stay alla,
OS
proceedings,
number
proceedings.
1225 of 2023 and for all further proceedings thereto, comma, till the next date of hearing.
Very well. Apply.
Serial number 3, Anand BV.
I am for petitioner, my lords. Plaintiff is the petitioner hearing. Filed a suit for permanent injunction in OS 215 of 2012. On summons, the respondents herein all filed, all were served, and respondent number 1, 2, 3 were appeared before the court, and respondent number 4 placed an ex parte. They did not contested the matter, hence the suit was decreed on 6/11/2014. On 24/1/2015, the respondent number 1 and 2 preferred a miscellaneous petition under Order 9 Rule 13. They claimed that only the criminal threat from me. Kindly see, criminal threat ittu anteli our contention. Kindly see the order of trial court at page number 45, my lords. Reasons assigned by trial court. It is the case of the petitioner that they concentrated on criminal case filed against the accused and hence they did not.
Number?
45, my lords.
This is an order passed in the miscellaneous petition.
Yes, my lords. Annexure E, my lords.
Vote to set aside the judgment and decree passed in so and so
the trial court dismissed the application. Filed by that they did not show the sufficient cause
All right,
alleged by the respondents herein.
all right.
But appellate court, without considering all those facts, kindly see at page number 63, my lords. The appellate court order at para 17, my lords. Admittedly, on the perusal of the certified copy of Exhibit P1 judgment, it indicates that the petitioner decree of the suit on dated 6/11/2012 and 6/12/2000 applied for certified copies. They obtained the certified copies of the judgment on dated 14/1/2000 and filed missed petition before the trial court on dated 27/1/2012. Hence, there is delay in filing in the petition. No doubt the petitioner are not placed any document should show that the petitioners are apprehended threat from the respondent. The appellate court come to the conclusion that they have not shown sufficient cause. Even though the appellate court has dismissed the order of the trial court and gave an opportunity to contest the matter. Hence, I have preferred this writ petition, my lords. They never show sufficient grounds was not shown by the respondents number 1 and 2. Even though the appellate court has passed an order.
Serial number 4, Mohammed Tayyib. Suit for eviction filed by the respondent.
Yes,
Petitioner is not property, suitable property belongs to the family of the petitioner. 1991, respondent has received a
respondent filed suit for
suit for eviction.
eviction.
It is
Ah.
The property belongs to the family of petitioner. In 1991, the respondent has received a title under the fraudulent sale deed, 1991. And because family came to know about the fraud of the respondent.
Huh?
So the property was not handed over, the position was not handed over the suitable property to the respondent. And since 1991, before that also we are in the position, from the 1991 onward, till today we are in the position on. To overcome from this dispute, he has filed this suit for eviction without producing any document which shows semblance of any existence or any relationship between the respondent and petitioner. In spite of that, he has filed a IA for the payments of rent loss, and that IA has been allowed. For that, against that order only and before this honorable court.
Yes.
The order is an official e-law.
Yes.
Could you kindly see my written statement? It's on
Yes.
page number 26, the 11th.
What are the grounds that you have raised?
I'm raising ground that Lordship, we don't, the relationship. There is no document is produced by the respondent to show the relationship that we are in the tenant. And even till today, not even a single payment is made by us as a tenant. And no document was produced, and the relief which he has asked as a final relief, that the court has granted as an interim relief. Can you see the prayer in the plain Lordship? Page number 24, Lordship. The prayer in the plain. The second prayer is to direct the defendant to pay a sum of rupees 1,48,000. As an interim relief, the same has been granted without deciding the factual aspects of the matter. The impleadment order operating portion of the impleadment order, page number 9, that arrears of 1,67,000 is been directed to pay to the respondent. And we have denied the relationship, Lordship, in our written statement. And the original property belongs to our family. We are in the position from the day one.
Any judgment you want to rely upon?
I want to rely on one judgment of our Lordship. Kindly pass over the matter because I have serial number 19. Along with that, I will conclude the argument.
Pass over. You should come prepared, sir.
But not in station.
Yes.
Serial number 5, Bhargav ji. For the petition.
Yes.
Of the plaintiffs in OS number 3025 or 2011.
Petitioners are,
The plaintiffs in OS number 3025 or 2011.
are you sure?
Yes, sir.
You have said your objectors.
Objectors in the another suit. We have filed suit prior to the suit filed by the respondents hearing. For facts and submitting.
Hmm.
We were the plaintiff petitioners for the plaintiffs in OS number 3025 or 2011. All these respondents were the defendants in the said suit. Initially, the said suit was filed for permanent injunction. The fourth respondent hearing, mother of the fourth respondent hearing was the original owner of the property. We have been in possession and enjoyment of the property since she has abandoned the property for the more than 35 years. That was the case before the trial. And the defendants number one, respondents number 1 and 2, who are the defendants?
You are put in possession
We are put in position of the.
How? As a tenant,
It's a permanent licensee,
as a tenant,
as a, not as a licensee.
which
She
means
abandoned the property, permitted her to occupy the.
you are paying license fee.
Nothing was paying.
Then
Permitted to occupy the premises, she went back to Chennai, he left the property. But that is not the case, your lordship, just for giving the fact before your lordship and submitting this on. So we have filed the suit for injunction against other defendants who are trying to encroach upon the property. When the said suit was pending, the respondents 1 to 4 hearing, 1 and 2 have filed another suit. That is your other mechanism, that is arising, that is the execution petition arising out of.
they are the children of that fourth respondent.
No.
Huh?
They are third persons. Third person has filed a suit as if one of the brother executed, said to have executed a first petition is brother. And sister-in-law said to have executed a agreement to sell in favor of the first respondent. And they have filed a suit for specific for months against the second, third respondent. We compromise ಮಾಡಿ 1 ತಿಂಗಳು consent degree ತಗೊಂಡ್ತಾರೆ. ತಗೊಂಡು ಆದ್ಮೇಲೆ they filed an execution petition against me to execute the order since we are in possession of the property. Then what happened, your lordship, I amended the plate which was in the suit which was filed earlier from there to declare that I are the owners of the property as an adverse possessee. And apart from that, declare that the judgment and decree passed by the in other suit, compromise decree, for which we are not the parties, not binding on. Your lordship, my suit was decreed partly, only to the effect that the defendants are all these respondents or defendants in the said suit were restrained from peaceful position in my property. And another relief, the judgment and decree is passed in the other suit, compromise in the compromise decree as a result of compromise between the party, right? Within 1 month, the said suit was disposed of. That is not binding on me. When such being the matter, that judgment is operating against the respondents hearing. Against that, both we have filed, the defendants and the respondents, petitioners both have filed the appeal before the court. Appeal is pending. We have agreed with the rejection of prayer so far of adverse position. We prefer the appeal. And the respondents hearing have filed the appeal, agreed with the other relief which are granted in favor of it. When such being the matter, the execution petition is still pending, and though another coordinate court has declared that decree is not binding on, still the execution proceeding is proceeding. We filed an application on the ground that the decree is already passed, holding that the judgment and decree is not binding on. Therefore, the proceeding has to be stayed till disposal of it. But the learned judge has rejected the application on the ground that ಎರಡು appeal ಅಲ್ಲೇ ಇದೆ, ನೀವು ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳಿ.
You have not sought for any such stay before the
stay only. We sought
before the appellate court.
appellate court ಅಲ್ಲಿ now.
Why have you not sought for stay?
No, the different suit.
You have filed an appeal.
Appeal not against that suit.
Sir, you have also sought for a relief that decree will not be binding on me.
Yes, sir.
And you say there is already a decree passed in your favor.
That relief is granted for me.
Therefore, in that view of the matter, If any execution proceedings are allowed to be continued,
Execution proceeding is not.
you could have asked for, no, you could have asked for a stay of further proceedings in the execution case before the appellate court. That is what is the reasoning of the.
Reason given, that is incorrect reasoning, reason that
Yes.
we cannot seek the stay of execution since that the execution petition arising out of different suit.
Sir, there is a decree in your favor in respect of that suit.
Yes, my lord.
Then
No.
are you not entitled to seek?
Not in respect of that suit. ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಇಂದ ಸ್ಟೇ ಮಾಡಿ ಇದು ನಲ್ ಅಂಡ್ ವೈಡ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ ನಮ್ ಸೂಟ್ ನಲ್ಲಿ. ನಮ್ ಸೂಟ್ ನಲ್ಲಿ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಇಂದ ನಲ್ ಅಂಡ್ ವೈಡ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
Correct.
Null and void ಆದ್ಮೇಲೆ that execution proceeding cannot be proceeded.
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು.
ಇದರಲ್ಲಿ
You had the right to seek such a prayer at the hands of the appellate court. ಅದನ್ನೇ ಹೇಳಿರೋದು ಅವರು.
that my.
Please do it. You can still file an application, get it stayed there.
Can you say already evidence is recording?
Yes.
We proceeded with the execution. Permit me to.
Instead of filing this writ petition, you could have filed an application there
Your
in the
lordship-
RFA.
Your lordship, one my doubt is that, my lord, can I seek an stay of execution?
Sir,
petition
you
unless-
have sought for a prayer in respect of that suit and you also got a decree, you say.
Yes.
If that is the case, if there is a decree passed in your favor saying it will not be binding on you, can you not ask for a order of stay of the execution proceedings? It is permissible, sir.
The limited purpose, your lordship may kindly grant 4 weeks stay and file an application before the other court in an appeal and could be disposed of. Otherwise, if the execution court will proceed with the matter, already evidence is prepared.
Now notice has to be issued to whom?
So all the respondents.
Huh?
All the respondents.
Some of them are judgment debtors.
Yes, my lord, all the respondents are judgment debtors.
Respondent number 3 is decree holder, sir.
Respondent
So
number-
one of them is a decree holder, isn't it, in that suit?
That is for first respondent.
Huh?
Putlakshmi is another suit, she is the decree holder, represented by a legal representative. She is no more.
Decree holder, 1 and 2 are decree holders.
Oh, you 1 and 2 is stakeholder circle. It is 1 and 2.
Issue notice to response number 1 and 2. Learned senior counsel appearing for response number 3 and appearing for the petitioner submits that respondents number 3 and 4 are judgment debtors and objector, and no relief is claimed against them in this writ petition. Full stop. Therefore, dispensation of notice is sought insofar as response number 3 and 4 are concerned. Full stop. At the risk of the petitioners, notice to response number 3 and 4 is dispensed with. Next para. Learned senior counsel appearing for the petitioners submits that the petitioners have obtained a judgment and decree in their favor in OS number
3025/2011. That is page 17, judgment I have produced. Operative portion is
in OS 30.
25/2011. Operative page 120.
Page 70, na?
70 start ಆಗುತ್ತೆ operative portion.
3025 of 2011.
120 ನಲ್ಲಿ operative portion of the judgment.
That judgment and decree passed in OS number 3786 of 2011 dated 1/7/2011 is not binding on the petitioners. Full stop. Nevertheless, the decree holders therein have proceeded to seek execution of the decree in execution case number 1671 of 2011. Full stop. the petitioners herein filed an application as objectors and sought for stay of all further proceedings in view of the decree passed in their favor. Full stop. Nevertheless, the impugned order has been passed on the ground that the petitioners would have sought for such a order of stay at the hands of this court in the regular first appeal filed by them. Full stop. Next para. When this court expressed its prima facie opinion that the petitioners would have filed such an application and obtained such directions of stay, learned senior counsel praised that the petitioners will file such an application before this court in the pending RFA, but in the meanwhile, this court should pass orders to protect the interest of the petitioners. Next para. Accordingly, there shall be an ad interim order of stay of all further proceedings in execution case number 1671 of 2011 for a period of 4 weeks to enable the petitioners to file necessary application in RFA number in the regular first appeal filed by them before this court. Full stop. Yes.
6. Tobias Bavikatti.
Regular case of two wives, Malad.
Huh?
Two wives claiming that they are husband of the one deceased Malaya. And also one more suit has been filed by one Malaya, saying that she is the wife of the deceased Malaya. The Your family to the impute order in Eviction 8. Two applications are filed, IA number 7 and IA number 11. One IA number 7 was filed by the deceased Your Lordship would get it at page 10. Page 10, interim application, I number 7. There one Malaya, he had filed a suit. One Malaya had filed a suit against the Najama, which a lot of the that the lecture B at page 38. Court number 233 of 2012. He filed a suit against Najita Najama, seeking my lord for a direction. Your lordship would get it.
Directing the defendant to execute a registered sale deed.
Of the suit property more fully described in the memorandum of understanding dated 10/11/2008 and nominal sale deed 24/12/2008. Otherwise, this honorable court to execute the registered sale deed in favor of the plaintiff, grant the cost of the suit and such relief. We were the owner of a site, my lord, measuring about 1,200 square feet. What happened, my lord, during the year 2008, one lady claiming herself to be Saubhagya. His wife claiming also Saubhagya and another lady claiming to be Saubhagya and having 3 children. 5 maintenance application suit, my lord, for maintenance and one violence case. Those proceedings are going on. What happened, my lord, then on the advice of his friend to say that she might claim attachment of the property, he enters into a sale with the friend's wife, that is Puttalandama. That is the sale deed was not executed.
He enters into
A sale deed with his friend's wife, so that later on they could recover the property, and the second lady who's claiming to be his wife would not have access to the property.
Hmm.
That was how the entire transaction
Hmm.
took place, my lord.
Hmm.
And then when the suit was pending, my lord, on 31st March 2018, Malaya passed away. Now, when Malaya passes away, my lord, there are two sets of that is the family claiming to be the wife of Malaya, wife and sons. And that, my lord, one of them files after his death, file ID number 7, my lord, under order 22 rule 3. A lot to be dated at page 12, my lord, page 30.
Huh?
Page 30, the application filed by one Saubhagya and her children, that is, the page, Sesharaja and Mona.
Page 30.
No, 1.
13 is the order, isn't it?
I'm just trying to see for your lordship, the applicants who are there in IA number 7 and IA number 11, the two sets of families. So IA number 7.
Both of them filed applications. Both the families applications separately. Yes.
IA number 7 is filed under order 22 rule 3. That is Alaya, deceased person, Saubhagya, Latesh, Sesharaju and Mona Kumari.
Yes.
That is one section. The other one is IA number 11, which was filed by, under order 1 rule 10. By again Saubhagya Menon and Lokesh Kumar, Vijendra Kumar.
So this is not the same Saubhagya as, huh?
IA number 11, my lord, we are claiming to be, the petitioner herein is claiming to be the wife of Malaya, that she is not the wife. So, my lord, during this procedure, my lord, when the applications came to be filed, the learned trial judge, my lord, holds a complete inquiry. Inquiry where is about 32 documents are marked by in under IA number 7 and 64 documents are marked in IA number 11. my lord.
Hmm.
And after passing an order, he passes an order declaring, my lord, that this IA number 7, which is filed by that Saubhagya and those children are the legal heir, my lord, of the deceased Malaya.
Hmm.
He declares that they are the legal right
Ah.
and children, and also, my lord, here they also declare that IA number 11, Yogesh Kumar and Lokesh are the sons of deceased Malaya, but this Saubhagya and another Vijay Kumar are not the wife and the son. And actually, this IA number 11, they are the legal right. But the trial court, in an application and order 1 rule 10 and order of 22 rule 3, passed an order for declaration, saying declaring they are the wife and they should continue because they have to get the share of the property.
Yes.
That is what we want.
Hmm.
And also one more suit has been filed. If I can leave it to your lordship at page 8. At page 8, I have mentioned, my lord, lordship can see there's one more suit pending, OS number 21 of 2019, against Saubhagya. And 5 others, that is Saubhagya others.
ಅರ್ಜಿ 11 ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯನ್ನು ಭಾಗಶಃ ಪುರಸ್ಕರಿಸಲಾಗಿದೆ ಅಂದ್ರೆ what is the meaning?
Partly allowed.
Saying?
It's a whole family from IA number 7. And in IA number 11, 11, it takes only 2 of them. 2 sons, then they are the
Who are already parties in IA number 7.
IA 7 is different, IA 11.
Correct. Where is that reasoning? Which portion of IA number 11 is allowed? ಮುಂದುವರೆದು paragraph 25.
25, para 25.
Yes.
ಮುಂದುವರೆದು ಈ ನ್ಯಾಯಾಲಯದ ಮತ್ತೊಂದು ಅಭಿಪ್ರಾಯ ಏನಂದ್ರೆ ಈ ದಾವೆ ಮುಗಿದ ನಂತರ ವೃದ್ಧ ಮಲ್ಲೆಯನ ಕಾನೂನುಬದ್ಧ ವಾದಿಸುದಾರರು ಯಾರು ಮತ್ತು ಯಾರ್ಯಾರು ಎಷ್ಟು ದಿಸೆಯನ್ನು ತೆಗೆದುಕೊಳ್ಳಬೇಕೆಂದು ಅರ್ಹರಾಗುತ್ತಾರೆ ಎಂಬ ಬಗ್ಗೆ ಮಧ್ಯ ಅರ್ಜಿಯನ್ನು 567 ಅವರ IA ನಂಬರ್ 7 ಅರ್ಜಿದಾರರು ಮತ್ತು ಮಧ್ಯ ಅರ್ಜಿ 11 ಅರ್ಜಿದಾರರು 1C ಮತ್ತು 1D ಅವರವರು ಪ್ರತ್ಯೇಕ ಹಿಂಸಾ ಪ್ರಕರಣ ದಾಖಲು ಮಾಡಿ ತಮ್ಮ ಕಾನೂನುಬದ್ಧ ದಿಸೆಯನ್ನು ಪಡೆದುಕೊಳ್ಳಲು ಅರ್ಹರಾಗಿರುತ್ತಾರೆ ಎಂದು ಈ ನ್ಯಾಯಾಲಯದ ಅಭಿಪ್ರಾಯವಾಗಿದೆ. Only about 100 documents are marked.
Many things have been said about this Yogesh Kumar. He's a law graduate. Bhagashah andre, what is the meaning? What has happened?
Declare that they are the heirs and the
ಮಧ್ಯಕಾಲೀನ ಅರ್ಜಿ 7ರ ಅರ್ಜಿದಾರರಾದ 1ರಿಂದ 4 ರವರು ಮತ್ತು ಮಧ್ಯಕಾಲೀನ ಅರ್ಜಿ 11ರ ಅರ್ಜಿದಾರರಾದ 1C ಮತ್ತು 1D ರವರು ಈ ದಾವೆಯಲ್ಲಿ ವಾದಿಯ ವಾರಸುದಾರರಾಗಿ ಮತ್ತು ಪ್ರತ್ಯೇಕ ಪಕ್ಷಗಾರರಾಗಿ ಸೇರ್ಪಡೆ ಮಾಡಿ ದಾವೆಯನ್ನು ಮುನ್ನಡೆಸಲು ಅವಕಾಶ ನೀಡಿದೆ. 1C and 1D. Yogesh Kumar. 1D. 1C ಮತ್ತು 1D. Vijendra Kumar.
Here both are declared to be the legal heirs and not Saubhagya and Lokesh Kumar. And one more aspect, Mela, a declaratory suit has been filed, OS number 21 of 2019, against both the Saubhagyas as by one Chikka Tarima. And she has sought for a declaration that she and her children are the legal heirs of the deceased Malaya.
Issue notice to the respondents. The petitioners are also permitted to serve copies of the petition along with annexures on the learned counsels representing the respondents before the trial court. Next para. Learned counsel for the petitioners submits that after the death of Sri Mallaya, the plaintiff, 2 applications were filed. One in IA number 7 and another in IA number 11. There are 2 sets of parties in the 2 applications claiming to be the legal heirs of late Sri Mallaya. Full stop. The trial court has conducted a full-fledged inquiry and the parties have tendered. How many documents each of them have tendered?
In IA number 7, my lord, 1 to 32 documents have been marked. 1 to 32. Exhibits 1 to 32.
In INS, IA 7.
And in IA number 11, my lord, 1 to 64.
64. ಏನು ಹೇಳಿದೆ? Tendered several documents to prove that they are the legal heirs of late Sri Mallaya. Full stop. It is submitted that the applicants in IA number 7 have filed 32 documents, whereas the applicants in IA number 11 have filed
1 to 64.
64 documents. Full stop. On the basis of the said documents, the impugned order has been passed. Full stop. Nevertheless, learned counsel for the petitioner submits that the trial court has erred in passing the impugned order, whereby all the applicants in IA number 7, along with only 2 of the applicants in IA number 9, namely 1C and 1D, are declared to be the legal heirs of late Sri Mallaya. Full stop. Next para. Matter requires consideration. Full stop. Consequently, there shall be an ad interim order of stay of all further proceedings. In OS number 233 of 2012, till the next date of hearing.
Number 7, Veena PK.
Lord, between the parties, Lord, there was an arbitration dispute. The sole arbitrator, tribunal passed an awardment. As against the said award, my client that his petitioner herein before lordship is not happy. Therefore, he raised a dispute under section 34 of the Arbitration Act. While raising a dispute, my lord, there was a delay. Therefore, a separate application is filed. In that application, what issue is involved is, in view of section 31, subsection 5 of the Act, computation of delay, how it has to be commenced, whether a service of arbitrarial award or collecting an arbitrarial award by the advocate or party, which is necessary for the purpose of computing the delay. That is the way in which the section 31(5) language is applied. Anyhow, that is a matter to be decided by the commercial court in the pending suit. My submission is that my suit is in the 2022 suit. The other side have filed an execution in 2023 after I initiated the 34 application. Without 2022, since 2022, there are two applications were filed by us. One is, my lord, the condonation of delay. Another is, my lord, stay of the award passed by the arbitrator. Now, both applications are time to time it is adjourned for one reason or the other. Even today also, it is yet to be disposed of. In the meanwhile, my instructions I got it now is the application for condonation of delay is heard and it is posted for orders on 24th of this month.
21st of September.
24th of September. My submission to lordship is under section 16 of the Commercial Code Act. Every proceedings under section 34 to be disposed of as far as possible within 6 months. It's more than 1.5 years, it's already over. My application for stay is pending. One side, my lord, other side is executing, very anxious in executing the decree. I am also pursuing my application honestly, but I could not able to get any interim order. Therefore, my lord, my submission is the commercial court be directed to dispose of my pending application for stay as early as possible. And until such time, my lord, the execution proceeding where an attachment order is passed now, that have to be kept in abeyance. When the date your lordship says, my lord, on that day we will go there and argue the matter. This is the only relief I sought for in this writ petition.
Yes.
My lords, in this, the reason the trial court has not decided on the stay application is because of the pendency of the condonation of delay application. Now, my lords, the conduct of the petitioner before the trial court has been, they had filed the case, the appeal on 21/12/2022. Along with the main appeal, they had filed the condonation of delay application. The application your lordship will find is at page number 147. Along with the application, your lordship will find the affidavit. The affidavit has only one reason. I state that there is a short delay in filing the aforesaid petition under 34. It is most humbly submitted that the said delay in filing the petition occurred due to petitioner partnership firm undergoing some financial constraints and was gathering the required funds. Further, it took time to draft the petition as the documents were voluminous. This is all the reason that is given. The appeal is filed after 187 days once the award is passed. The reason which is given here during the condonable period which is given by the Honorable Court is 30 days after 90 days, which is within 120 days. Now they have not even filed it within the 120 days. They have filed it 40 days thereafter. And thereafter they come and say, the only reason they give is this. Now the court said, if that is the case, this application has to be considered. If a stay is granted or a stay application is considered prior to that, then my lord, the condonation of delay or the procedure which is to be followed.
Difficulty in considering the application and disposing it off.
My lords, insofar as the condonation.
If it is
Yes, my
if you feel it was so easy,
Yes.
there is a untenable reasons given in the affidavit.
Yes, my lord.
Let the court take a decision.
My only.
Ask the court to not take a decision on the application for condonation of delay, sir.
No, my lords, absolutely not.
Then-
My only request is the condonation of delay application may be disposed of.
Therefore,
Their prayer is the stay application may be considered.
Depends of the Supreme Court
Yes,
in this regard is, if you don't even allow a party to have his appeal considered, and if you allow the execution case to proceed,
Yes, ma'am.
it will be a travesty of justice.
Please, ma'am.
That is the.
I bow down. I bow down.
So therefore, that is the submission sought to be made by the learned senior counsel.
Let's, they
You
had
don't
requested-
even want to decide the applications, but you want to allow the execution case to proceed.
No, my lords, their submission
Therefore,
was,
he is saying
the stay application may be taken up and decided is what they had
let them
requested.
decide both the applications are, there is
Please.
no difficulty.
Please,
But till then,
Yes.
you should not press on the execution petition.
I will not.
Purple. Learned counsel, Srinandan K has entered appearance for the respondent. Next para. Learned senior counsel Shri M.R. Rajgopal, appearing for the petitioner, submits that the petitioner has filed an appeal under section 34 of the Arbitration and Conciliation Act, questioning the award passed by the arbitral tribunal. Full stop. However, the appeal was filed after the statutory period provided for filing an appeal, and therefore the appeal was filed along with an application seeking condonation of delay. Full stop. Another application was also filed by the petitioner seeking stay of the execution proceedings initiated by the respondents. Full stop. Both the applications are yet to be considered. Full stop. In the meanwhile, if the respondents are permitted to proceed with the execution case, comma,
Commercial execution 131 of 2023.
it will render the appeal filed by the petitioner useless. Full stop. The learned senior counsel would therefore submit that appropriate directions may be issued to the commercial court to decide the applications filed by the petitioner seeking condonation of delay and stay. And in the meanwhile, necessary directions may be given to the court considering the execution petition filed by the respondents, not to take up the matter till the applications filed by the petitioners are decided by the commercial court. Full stop. Next para. Learned counsel for the respondent submits that the reasons furnished in the affidavit accompanying the application seeking condonation of delay is so bald that the application is required to be rejected. Full stop. Next para. Having heard the learned counsels and on perusing the petition papers, and having regard to the innocuous prayer made in the writ petition, this court is of the considered opinion that the execution case filed by the respondents is required to be is required not to be considered till the applications filed by the petitioner seeking condonation of delay and stay is considered by the commercial court. Full stop. This will be in tune with the several judgments passed by the Honorable Supreme Court, wherein it is held that if an appeal filed by the party who suffered a decree is not considered, and in the meanwhile, if execution proceedings are permitted to be continued, and if the decree is executed, it will render the appeal useless and it would be a travesty of justice. Full stop. Next para. Consequently, The writ petition stands disposed of.
My lords, one small submission. Insofar as both the applications are concerned, my request is, insofar as the condemnation of delay, it's already been heard and it's been reserved for orders. My request is, both the orders need not be passed together. It may be heard separately, because if your lordship says both has to be heard, then they will start arguing that in the order on condemnation
I
of
will
delay
say,
may not
I
be.
See, if the delay is not condoned,
Yes,
which means the appeal also has to be dismissed,
yes,
isn't it?
yes, my lords.
That order will follow.
Yes, my lords. My lords, in case it is
If it is
condoned,
condoned,
yes.
then they'll have to take up the application for stay.
My lords, my difficulty is, assuming the condemnation of delay, they condone the delay,
Yes,
then I may have to come on an appeal.
yes.
Meanwhile, what will happen is, if your lordship says both the application has to be considered together,
Whatever it is, see, whatever it is,
yes,
instead of pressing for passing an order on the application for stay there, they are making the same prayer here.
yes, my lords.
And this court is of the opinion that unless appeal is considered, you should not be permitted to proceed with the execution case.
Yes, my lords.
Otherwise, what is the use of filing the appeal then?
My only request is, anyway, there is a stay which is granted by this honorable court.
Huh?
Anyway, a stay is granted by this honorable court insofar as the execution is concerned.
Yes.
Now, if the IA for stay is to be heard and then the order is passed, then it will be an order on both the condemnation of delay as well as the appeal. My request is that the order on the condemnation of delay be passed so that there is no delay in an order being.
I'm not stopping
That's
the
my-
court from passing orders. If it is already heard the arguments on IA for condonation of delay, let it pass orders.
But then kindly it may be recorded, my lord,
I'll make
because
it
they may
clear.
not delay it saying that IA for stay may
Yes.
be heard.
The writ petition stands disposed of with a direction to the learned '79th Additional City Civil and Session Judge, Bengaluru, bracket CCH-90, before whom the commercial appeal, commercial AP 135 of 2022,
Three or one could, 135.
to consider and dispose of the two applications filed by the petitioners for condonation of delay and stay. Full stop. If the commercial court has already heard the application on application for condonation of delay, comma, it is free to pass orders. Full stop. Nevertheless, comma, during the pendency of the appeal in commercial AP number 135 of 2022, the execution case filed by the respondent in commercial execution 131 of 2023 shall not be proceeded with. Full stop. The commercial court is also required to take into consideration the statutory period permitted for considering an appeal filed under section 34 and accordingly expedite the hearing and disposal of the appeal.
Much of, great.
Grateful.
8, Krishnamurthy V.
Two zero four zero three of 24 is challenging the order passed on IA number 14, where the commercial court has refused to reject the plaint on the ground of jurisdiction. But your lordships will take page number 28 notes for a minute. 20403. 28 at page 29, the last paragraph. 29.
WP 20403.
403 ನಲ್ಲಿ page 28 is the agreement.
Lease deed.
Lease deed.
Ah,
Dated 9/5/2014, ಅದರಲ್ಲಿ page 29 last paragraph. Whereas the lessee herein in need of land for constructing, for the purpose of constructing and running Kalyan Mandap and also allied commercial activities is requested the lessor to give the land on lease for which the lessor has agreed to let out the scheduled property, hence this deed of deed. That means this property is required to be put into commercial use in future. Therefore, I want this, please give it for lease. He says, yes, I am ready to give it for lease, 10 years lease is granted. Now, whether this dispute is cognizable by the commercial court is the question. This is that's the only issue. Lords, may kindly take the Commercial Courts Act.
Please see the IA minutes. That is not the issue.
It's a jurisdictional
Correct.
issue.
Please see, my learned friend is going one step ahead. IA is filed under Order 7, Rule 11D. Order 7, Rule 11D is rejection of plaint being barred by law.
stating that it is not a commercial.
No, please see the IA. No, it is not so.
Huh?
Our adunu helilla alli. Now he is improving upon. Please come to his application. My learned friend should take the application first.
I read out that particular portion.
IA 14, my lords, is at page 74.
But I just read out that relevant portion at page number.
74 is there, IA.
Page number 77, para 10.
11D.
Yes.
11D ಹಾಕಿರೋದು.
ಹೌದು, para 10 of the affidavit at para
Barred by law
77. ಆಯ್ತಾ, ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ. Page 10, para 10 at page 77.
Yes.
I submit that it appears from the statements made by the plaintiff in the plaint, the suit is barred by law as well as jurisdiction. Suit is not maintainable in law. Now I'll point out, notes as to why the suit is not maintainable in law, because it's a commercial court. Supreme Court says, if it does not fall within the realm of commercial dispute as defined under section 2C, question of the commercial court entertaining the dispute does not arise. There is a statutory bar. It is covered by judgment of the Honorable Supreme Court. Now your lordships may kindly take notes the provisions under section 2 of the Commercial Courts Act.
The petitioner is the owner or lessee?
Let's see.
Ah.
Now, what nature of disputes are cognizable by the commercial courts is what has already been spelled out. Notes. Kindly have a look at the section 2C. Of the Commercial Courts Act.
Yes.
But section 2C, commercial dispute means a dispute arising out of, let's say, come to clause 7. Agreement relating to immovable property used exclusively in trade or commerce. Now, what is this meant by used exclusively in trade or commerce was what fell for consideration before the Supreme Court. The question was whether a prospective user of a property which was not used as on the date of the agreement for commercial purpose can be a commercial dispute within the meaning of section 2C7 of the Act. Let me just pass on this judgment. It's para 11. On the other hand, the learned senior advocate, the response is relied on the decision of the Division Bench of Gujarat High Court in Vasu Healthcare, wherein a detailed consideration has been made. Conclusion reached therein by taking note of an earlier decision is that on a plain reading of section 21C of the Act, the expression used must mean actually used or being used. It further explained that if the intention of the legislature was to expand the scope, in that case, phraseology like likely to be used or to be used would have been employed. The verbatim consideration therein has been is here under so and so. Minutes, I'll just read this minutes. Therefore, if the dispute falls within the section, any of the section 2C, the dispute can be said to be a commercial dispute for which the commercial court has jurisdiction. It is required to be noted that before the learned commercial court, original plaintiff relied on section so and so, Commercial Courts Act only. The learned counsel appearing on behalf of the original plaintiff has candidly admitted and or conceded that the case does not fall within so and so the Commercial Courts Act. It is required to be noted that before the learned commercial code, it was never the case of the on behalf of the plaintiff that the case will fall within the realm of 2C7 of the learned commercial code. Despite the above, we have considered on merits whether even considering 2C7 of the Commercial Courts Act, dispute between the parties can be said to be commercial dispute within the definition of 2C of the Commercial Courts Act or not. Considering 2C7, commercial dispute means a dispute arising out of the agreements relating to immovable property used exclusively in trade or commerce. As observed here and above, at the time of filing the suit, even so pleaded in the plaint, immovable property or plots agreements between the parties cannot be said to be agreements relating to immovable property used exclusively in trade or commerce. As per the agreement between the party after getting the plots on lease from GIDC, the same was required to be thereafter developed by the original defendant after providing all infrastructure facilities. Subplotting it, the same is required to be given to persons like the plaintiff. It is the case on behalf of the original plaintiff that as the defendant number 1 has failed to provide any infrastructural facilities, develop the plots and thereafter file a civil suit post performance, the agreement has been filed. There are other alternative prayers also. Therefore, it cannot be said that the agreement as such is relating to immovable property used exclusively in trade or commerce. It is the case on behalf of the original plaintiff that in clause 7 of 2C, phraseology used is not actually used and not being used. And therefore, even if at present the plot is not used, even if it is likely to be used in future, is also not the case under 2C7 that shall be applicable, and therefore commercial court would have jurisdiction. The aforesaid has no substance. As per the cardinal principle, while interpreting a particular statute or provision, the literal strict interpretation has to be applied. It may be noted that important words used in the relevant provision are immovable property used exclusively in trade or commerce. If the submission on behalf of the original plaintiff is accepted in that case, it would be adding something to the statute which is not there in the statute, which is not permissible. On reading of the relevant clause, it is relevant that the expression used must actually mean used or being used. If the intention of the legislature was to expand the scope, in that case, the phraseology used would have been different as, for example, likely to be used or to be used. The word used denotes actually used, and it cannot be said either ready to use or likely to be used or to be used. Similar view has been taken by the Bombay High Court, Nagpur bench in so and so. Then para 12 is important, minutes. Though we are informed that the said decision is assailed before this court in special petition, we are inclined to agree with the view expressed therein. This is for the reason that the court, while examining the issue relating to exclusive land use, though in different contexts, has laid emphasis in the present land use so and so. Then I'll come to paragraph number 14. In that view, it is also necessary to carefully examine and entertain only disputes which actually answers the definition of commercial disputes as provided under the Act. In the instant case has already taken note, neither the agreement between the parties refers to nature of immovable property being exclusively used for trade or commerce as on the date of the agreement, nor is there a pleading to that effect in the plaintiff. Further, the very relief sought for in the suit is for execution of mortgage deed, so on and so forth. Note then para 15 and onwards, the concurring judgment refers as to why such suits should not be entertained. Notes at para 37 and 38. Notes a detailed discussion is made as to why certain suits which are not commercial suits should not be brought to the commercial suits to be fast tracked because there is an object. The dispute relating, that is what is mentioned in para 36 minutes. That the object of adding certain disputes in commercial dispute, there is an object behind it. Therefore, this bar should never be crossed. Then para 37, a dispute relating to immovable property per se may not be a commercial dispute, but it becomes a commercial dispute if it falls under subclause 7 of 21C of the Act, namely agreements relating to immovable property used exclusively in trade or commerce. The word used exclusively in trade or commerce are to be interpreted purposefully. The word used denotes actually used, and it cannot be either ready for use or likely to be used or to be used. It should be actually used. Such a wide interpretation would defeat the objects of the Act and fast tracking procedure discussed above. Notes, and then of course, now if your lordships were to take the plaint minutes at page 35.
Yes.
Not just one paragraph, not paragraph number 5. The plaintiff submits that after the purchase of the suit scheduled property, she got the suit scheduled property converted from non-agricultural to non-agricultural purposes for so and so by payment of the betterment charges, etc. Yes, betterment charges, the suit scheduled property stands in the name of the plaintiff. The next para. The lessee in need of the land for purpose of carrying out the business of construction of Kalyan Mandapa and other commercial activities requested the lessor to let out the scheduled premises, so on and so. So what is there in the lease deed is also what is pleaded. This is exactly what the Honorable Supreme Court dealt with. If the agreement or the plaintiff does not disclose that as on the date of the agreement, the property was actually used for commercial, the question of entertaining a commercial dispute does not arise.
So the landlord has filed the dispute
Yes, landlord has filed the dispute before the commercial court
for
for ejectment and for recovery of arrears of the rentals.
So you have taken it, you have put it to use for commercial purpose.
I have taken and subsequently put it for commercial use. But the question is, for being regarded as a commercial dispute, as on the date of agreement, it should have been used for commercial dispute. Lords, may kindly have a look at para 14 once again for a moment. What the Honorable Supreme Court says. The word used is for the purpose of it being regarded as a commercial dispute.
What are the facts there, sir?
Lords, in that case, Lords,
Yes.
may kindly see those. There also, the property had to be plotted and then it should have been utilized for commercial development. Here also, Lords, I had to put up the construction and thereafterwards I had to use it for commercial development.
No, what is the dispute brought there?
There, of course, Lords, that dispute brought is to secure the mortgage. Which is, your Lords will find.
Paragraph number 3.
Para 14 Lords itself speaks about the relief, para 14.
Even at para 8, last 3 sentences noditavu.
Para
8 ಅಲ್ಲಿ last 3 sentences in the entire plaint ಅಂತ ಸಿಗುತ್ತೆ. Or as on date of the suit.
In the entire plaint, there is no reference to the nature of the land or
Type of use.
the
to
type
which
of the use.
It was being put as on date of agreement to sell, sale, memorandum of understanding, or as on date of the suit.
Lord, this is only contentions, para 14 Lords.
Para 10 ಅಲ್ಲೂ ಇದೆ ಅದೇ ತರ.
Note that.
Para 10 ತಾವು ನೋಡಿ.
Paragraph 3 ಅಲ್ಲಿ facts are stated. Let us see.
Facts are stated. Please, Lords.
Para 3.
ಅಲ್ಲಿ ಬರೀ agreement, it was not being put to use. That's why their lordships interpreted.
That's what we'll see. What are the facts there? Yes.
The brief facts which led to the present situation is that the appellant herein executed an agreement to sell dated 14/2/2012 in favor of respondent number 2 in respect of the land which is described in the agreement. Respondent number 2 assigned and transferred his rights in the second agreement to sell in favor of respondent number 1 by executing an assignment deed in dated so and so. In view, respondent number 1 herein was purchased the lands which was subject matter of agreement from the appellant. Accordingly, the sale was made under the deed of conveyance of 2017. Since certain other aspects were to be completed regarding change relating to nature of use of the land for conclusion of the transaction, right of the appellant in the land was to be protected. In that view, MOU dated 3/11/2017 was entered into between the appellant and the respondent. Herein, as per the same mortgage deed was required to be executed by respondent number 1 herein in favor of the appellant. Accordingly, a mortgage deed was executed, but the same was not registered. In that light, the appellant filed a suit in commercial suit as so as to enforce the execution of mortgage deed. Consequently, the relief of permanent injunction, other related reliefs were also sought. It is in the said suit, summons was issued to the respondents who are the reference in the suit.
Therefore, that is not the case here.
Kindly have a look at para 14 minutes. If your Lords is free,
The
I don't
agreement
want to
has
say
been-
anything beyond it.
The agreement has been furthered. And in terms of the agreement,
Lords,
have
is may
taken the
kindly see para
property,
14.
used it for commercial purpose.
This may kindly see para 14. That is what, what we are now reading is what is narration of the facts as would have been contained in the petition. But the deduction on the facts or the findings on the facts is what is contained in paragraph number 14. Lords, this may kindly take para 14.
Yes.
In that view, it is also necessary to carefully examine and entertain disputes, which actually answers the definition of commercial disputes as provided under the Act. In the instant case, as already taken note, neither the agreement between the parties refers to the nature of immobile property being exclusively used for trade or commerce as on the date of the agreement, nor is there pleading to that effect in the plaint. Further, the very relief sought for in the suit is for execution of mortgage, which is in the nature of specific performance
It
of
is
the MOU,
important.
with
What is the
without
relief that was
reference.
sought is
Lords,
more
that is
important.
further. Lords, if your lordship
Yes.
were to, that is a further statement made. Further, the very relief sought in the suit is execution of mortgage, which is in the nature of suit for specific performance of the terms of the MOU, without reference to the nature of the use of immobile property in trade or commerce, as on the date of the suit. Therefore, if all these aspects are kept in view, we are of the opinion that the present facts the High Court was justified in conclusion arrived it in the order dated so. That's all my submissions.
But here it is being put to use for commercial purpose. The dispute brought now is regarding the arrears of
Arrears
rent,
of rents.
and it's a commercial purpose.
That's my
This
statement.
property, lords, they are running a chowdhury. This is, my lord, on the Mysore Road, Nice Road Junction, Kadamba Hotel, petrol bunk and a chowdhury. Rents are not being paid for 10 months more than, this court has only said there are 3 IAs. One IA by us saying from the date of filing of the suit till the date of the order, they should deposit the rents in the court, not to me. That is one which is allowed. He files, my lords, for rejection of the plaint. His case is made out separately here. Anyway, I'll leave it at, for 11D, he says it's barred. He now says the agreement itself is void. I have misled him.
There are two applications.
3 applications.
Huh?
One is by the plaintiff.
It is their application for rejection of the plaint.
And one more is the written one sixth defendant filed a written statement belatedly. Court says there is no mandate, it's a mandatory provision beyond 120 days. There is no provision to condone the delay. I cannot do it. That's, my lords, covered by the Honorable Supreme Court judgment, which says in commercial disputes, there is no question of condoning the delay in filing.
So far
the
as the
written
deposit
statement.
is concerned, my lords, your lordships may consider granting 12 weeks time to make the deposit. I'll make the deposit before the.
They are earning money and to deposit the rent in the
No,
court,
my
my
lords,
lords, 12 weeks.
Lords, 2 years, the whole difficulty is 2 years, we have shut down the entire business.
And the April all pass again.
Yes.
COVID time.
ಹೌದು 2 ವರ್ಷ ನಮ್ಗೆ ಏನು ಬಂದೇ ಇಲ್ಲ. And we maintain.
April all ಆಗಿರೋದು order. COVID ಆದ್ಮೇಲೆ,
Lords, we
lords,
have.
every week
No,
if
no.
your lordship just passes that road, that hotel which has the highest business does not want to pay rent.
Allah, that is the 7 rule 11 is one application.
711D ಒಂದು,
Huh?
711D ಒಂದು, ನಾವು ಒಂದು application ಹಾಕಿದ್ವಿ.
For seeking deposit of rent.
Deposit of rent in the court,
ಆಯ್ತು.
not with me.
ಹಾ.
Then, my lords, that was IA 13.
ಹಾ.
Then, my lords, IA 15 is by the sixth defendant
ಹಾ.
who had sought time condonation of delay in filing the written statement. That has been rejected.
That of course is covered by the judgment.
That's covered by the
Extension of time
judgment.
doesn't arise.
Barkal.
Please, may I seek your lordship's excuse.
May I also.
Yes, yes. Learned Counsel Shri Nagarajulu G has entered appearance for
Respondent number 1.
respondent number 1,
Please.
who is the plaintiff
Yes,
and
please.
the contesting respondent in these petitions. The other respondents are co-defendants along with the petitioner, and therefore there is no need to issue notice to the other respondents. Full stop. Next para. Since all the 3 writ petitions arise out of orders passed in commercial OS number 745 of 2023, the 3 petitions are heard together and disposed of by this common order. Full stop. Next para. Respondent number 1 filed the commercial suit Next should be page 35, my lords. Seeking directions to the defendants to quit, deliver and hand over vacant possession of the suit schedule property, pay arrears of rents of rupees 4 crores 94 lakhs 23,242 as on 31/7/2022 with periodical enhancement as agreed to in the lease deed dated 9/4/2015 with along with interest at the rate of 18% per annum. Semicolon. To pay rupees 36,72,500 towards service tax and GST of rupees 1 crore 25 lakhs 84,349 along with interest and for damages. Full stop.
First defendant has also filed the counterclaim. Huh? The first defendant has also filed the counterclaim, the petition here.
Yenanta?
Page 48.
48.
Seeking that the registered lease deed is void, unenforceable, and mandatory injunction to direct the plaintiff to execute the fresh lease deed for further period. Your lordship would get it at page 70, my lord. In writ petition number 20403, my lord.
Defendant number 1 filed
Written statement
and counterclaim. Seeking declaration that the registered lease deed dated 9/4/2015 is void and unenforceable. Semicolon. For mandatory injunction directing the plaintiff to execute a fresh registered lease deed in favor of the first defendant for a period of 25 years from 6/1/2023, by obtaining change of land use from industrial purpose to commercial purpose. Semicolon. For permanent injunction restraining the plaintiff bar defendant number 1 from interfering with the peaceful possession and enjoyment of the suit schedule property. Full stop. The petitioner, defendant number 1, also filed an application
Rule 11D, my lord, page 74.
in IA number 14 under order 7 rule 11 bracket D of CPC for rejection of the plaint as barred by law. Full stop. Defendant number 6 filed IA number 15 under Order 8, Rule 1 and 2 of CPC to recall the orders dated 22/3/2024, whereby the written statement filed by defendant number 6 was rejected, and to take the written statement on record.
On the ground, my lord, we filed the written statement. The court said that you did not file the IA and therefore the written statement could not have been taken on record. The sixth defendant under the impression that the time granted is within time, therefore it did not file an application. He filed a written statement. The court said that you are not filed the IA, therefore the written statement could not be taken. Later on, we filed IA to take the written statement on record, and therefore the court said that the time has already been elapsed and therefore we could not able to.
But then the learned senior counsel said it is covered by a judgment of the Supreme Court.
That's what is the narration by the
Semicolon. And the plaintiff filed IA number 13 under section 151 of CPC to direct defendant number 1 to deposit the admitted rent of rupees 10 lakhs per month from the date of filing the suit till date of disposal. Full stop. By the impugned orders, the commercial court has allowed IA number 13 filed by the plaintiff and has issued directions to defendant number 1, bar petitioner herein to deposit rupees 10 lakhs per month bracketly equivalent to admitted rent close bracket from the date of suit till the date of disposal of the suit. Within a period of 4 weeks from the date of the order, and to continue to deposit the rentals during the pendency of the suit. Full stop. IAs number 14 and 15 were rejected. Full stop. Next para. Learned Senior Counsel Sri D.R. Ravishankar, appearing on behalf of the petitioner, bar defendant number 1, contended the application was filed under Order 7, Rule 11, bracket D, having regard to the fact that the dispute brought before the court is not a commercial dispute, having regard to the fact that the suit schedule property was not used exclusively in trade or commerce as on the date when the parties entered into an agreement. Full stop. Attention of this court was drawn to clause 7 subclause 7 of clause C of subsection 1 of section 2 of the Commercial Courts Act, 2015. Full stop. Reliance was also placed on a judgment of the Honorable Supreme Court in the case of Ambalal Sarabhai Enterprises Limited versus KS Infraspace LLP and another, bracketly 2020, close 15 SCC 585. Full stop. Learned Senior Counsel submitted that having regard to the definition of the word commercial disputes as found in section 2 of the Act, and more particularly subclause 7 of clause C, the Supreme Court has held the expression inward comma used, close inward comma, must mean in mata inward comma actually used, close inward comma, or being used inward comma full stop. It was further explained that if the intention of the legislature was to expand the scope, in that case, the phraseology, likely to be used or to be used, would have been employed. Full stop. Full stop. Learned Senior Counsel submitted that in a concurring judgment, the Honorable Supreme Court has laid emphasis on the statement of objects and reasons of the Commercial Courts Act, 2015, and held that if the provisions are given a liberal interpretation, the object behind constitution of commercial division of courts, namely putting the matter on fast track and speed resolution of commercial disputes, will be defeated. Full stop. The object shall be fulfilled only if the provisions of the Act are interpreted in a narrow sense and not hampered
by the usual procedural delays plaguing our traditional legal system. Full stop. Next para. Per contra, learned senior counsel Sri K. N. Phanindra, appearing for the first respondent, plaintiff, submitted that the judgment sought to be relied upon by the petitioner is not applicable to the facts of the case on hand. Full stop. It was submitted that in the decision cited, the prayer was for execution of the mortgage deed, which is in the nature of specific performance of the terms of memorandum of understanding, comma, without reference to the nature of the use of the immovable property in trade or commerce as on the date of the suit. Full stop. It is submitted that in the present case, the relief sought is for recovery of rents, comma, which would mean that the defendants have put to use the suit schedule property for commercial purpose, and the rentals are also determined accordingly, comma, having regard to the fact that the suit schedule property is used for commercial purpose. Full stop. In that view of the matter, comma, learned senior counsel submitted that the commercial court has rightly rejected the application filed by the petitioner, bar defendant number 1, under order 7, rule 11 bracket D of CPC. Full stop. Next para. Next para. Having heard the learned senior counsels and on perusing the petition papers, comma, this court finds that there is substance in the submission made by the learned counsel for the first respondent plaintiff. Full stop. Insofar as the application filed by the petitioner, bar defendant number 1, seeking rejection of the plaint on the ground that the dispute brought before the commercial court is not a commercial dispute having regard to the definition, and more particularly subclause 7 of clause C, that as on the date when the parties entered into an agreement to lease out the property, comma, the property was not put to use as for commercial purposes.
has rightly been addressed by the commercial court. Full stop. This court is one with the learned counsel for the respondent. Number one. Since the nature of the prayer made by the plaintiff before the commercial court is for recovery of the arrears of rent. Full stop. The facts narrated in the plaint clearly shows that after the lease agreement was entered into, the defendants have taken possession of the suit schedule property and have put it to commercial use in terms of the agreement. Full stop. The lease agreement was entered into on 9/4/2015. And the claim of the plaintiff for arrears of payment of arrears of rent ಯಾವಾಗಿಂದ from which date?
Lots from
31/7/22 ಈ ಕ್ಲೈಮ್ಸ್ ಮೇಲೆ
as on ಅಂದ್ರೆ ಎಲ್ಲಿಂದ?
ಅದು ಕ್ಲೈಂಟ್ ಅಲ್ಲಿ ಏನು ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ ಹೇಳಿದ್ರು.
Even in page 44 also, my lord, arrears of rent as on 31/7/22 ಅಂತ
29/12/21, my lords, payments have been made.
Huh?
Till 29/12/2021, my lords, your lordships will find it at page 59, my lords. Payments are made. Thereafter, no payment has been made till date. Page 59, my lords.
29/12/2021.
Please, my lords, that was the last payment made, my lords.
So from 1/1/2022.
Please.
1/1/2022.
22, my lords.
From 1/1/2022. Full stop.
But if it is from 1/1/22, my lord, there cannot be 4 crores.
That is,
To 30
no,
months.
that is a matter of evidence.
Yes, my lord, trial.
Our claim ಇರಬಹುದು, but you will be able to prove, no, that much of arrears is not there. It is pointed out from the counterclaim filed by the petitioner herein that the petitioner bar defendant number 1 admits payment of rents commencing from 8/4/2015 to 29/12/2021. Full stop. Therefore, comma, the petitioner cannot contend that the suit schedule property has not been put to commercial use. Full stop. The judgment cited by the learned senior counsel for the petitioner is required to be considered in the light of the claim made by the plaintiff. Full stop. Having regard to the claim made for recovery of arrears of rent, comma, it cannot be disputed that the dispute brought before the court is a commercial dispute. Full stop. In that way, the matter, comma, this court does not find any merit in the writ petition insofar as application filed under Order 7, Rule 11, bracket D is concerned. Full stop. Next para. Insofar as the
Number 13.
insofar as IA number 13 is concerned, comma, where directions are issued by the commercial court to the petitioner defendant number 1 to deposit the arrears of rent at the rate of rupees 10 lakhs per month from the date of the suit till disposal of the suit, comma, the learned senior counsel for the petitioner submitted that a reasonable time may be granted to the petitioner defendant number 1 to deposit the same. Full stop. Next para. Insofar as IA number 15 is concerned, comma, the learned senior counsel appearing for the petitioner has fairly submitted that the issue stands covered by a judgment of the Honorable Supreme Court, which has been taken into consideration in the impugned order. Full stop. Next para. Consequently, the writ petition stands disposed of while permitting the petitioner defendant number 1 to deposit the arrears of rent as directed by the commercial court. Within a period of yesterday,
12, we have start 12 weeks. 12 weeks.
Order has been passed to deposit within
We have
4
paid
weeks.
1 crore 10 lakhs as a deposit also. The trial court has not taken note of all those things. And we have paid 1 crore 10 lakhs as a
That's
deposit.
better.
Therefore, my lord, therefore, we have not done any business for 2-3 years. because-
All that will be
Yes,
considered.
yes, my lord, that is for on merits, my lord. 12 weeks may kindly be granted.
My lords, order was passed for 4 weeks, my lords.
Within a period of 60 days from the date of receipt of a copy of this order, please. Ordered accordingly. Yes.
Much obliged.
When was that order passed?
April, my lords, April 24, my lords.
So that 120 days will come to an end when? April. ಆಗೋಗಿದೆ.
ಆಗೋಗಿದೆ.
ಆಯ್ತು.
Order was passed on
All right. Yes.
From
23rd April 24, my lords.
60 days from
All right.
this court order.
From the date of receipt of a copy of this order.
Yes,
Yes.
published.
Nine, Shankar K.
Let's appear for the petition.
To pay objection, Your Honor. Copy has petitioner. Copy has already been served. Filed KVA. Copy has not received.
Huh?
Copy of its acknowledgement has already been produced.
Prefer time
Regard to
to.
service of minutes, the copy is concerned.
ರೀ ಕಾಪಿ ಬಂದಿದ್ರೆ ಕಾಪಿ ಬಂದಿದೆ ಅಂತ ಹೇಳಿ ಟೈಮ್ ಕೇಳಿ ಕೊಡ್ತೀನಿ ಕಾಪಿ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಡಿ ಸುಮ್ನೆ ಇಫ್ ಯು ಹ್ಯಾವ್ ರಿಸೀವ್ಡ್ ಕಾಪಿ ಯು ಫೇರ್ಲಿ ಸಬ್ಮಿಟ್ ದಟ್ ಎಸ್ ಐ ಹ್ಯಾವ್ ರಿಸೀವ್ಡ್ ಕಾಪಿ ಬಟ್ ಐ ವಾಂಟ್ ಸಮ್ ಟೈಮ್ ಪ್ಲೀಸ್ ಏನು
Copy
ಬಂದಿದೆಯಾ
ಬಂದು.
ಆಲ್ ರೈಟ್ ಅಟ್ ದಿ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾವಾಗ ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀರಾ
2 weeks time.
ಫಾರ್ interim prayer you should be ready sir. What is the use of filing caveat then? Release this matter for a preliminary hearing on 10th of September, Tuesday. Yes.
Then R.B. Deshpande.
Is appearing for petitioner. This is a plaintiff's writ petition. The plaintiff filed a suit for permanent injunction. In that suit, IA order 39/192 is filed. The trial court on inquiry has granted interim order as paid for. Agreed by the same, the other side has preferred a appeal. Now the appellate court has
Suit for?
permanent injunction.
Ah,
The TI is granted as paid for by the trial court. Now that has been reversed by the first appellate court.
yes.
In this case, your lordship kindly see the survey number 69/10 measuring 38 guntas of Devikoppa village has jointly purchased by the father of the husband of the petitioner and Basavaraj. Joint on 28/2/2001.
ಇದು ಬಂದಿತ್ತಲ್ವಾ ಒಂದ್ಸ
ಅದು ಆ ಬ್ರದರ್ ತಾವೇ ಮಾಡಿ ನೋಟಿಸ್ ಸ್ಟೇ ಮಾಡಿದ್ವಿ ಮತ್ತೊಬ್ಬರು ಬ್ರದರ್
ಅಷ್ಟೇ ಹೇಳೋದಾಗಲ್ವಾ?
ಅಲ್ಲ ತಾವು ಸ್ವಲ್ಪ ಟ್ಯಾಕ್ಸ್ ಹೇಳಿ ಸುಳ್ಳಾಗಬಾರ್ದು ಅಂತ ಹೇಳಿದೆ.
No. You should have said
Please.
similar facts in
Please.
another case this court. ಯಾವ್ದು? Where is that?
WP number 21,587.
Same as WP number
21,587.
of 2024.
Please.
Yes.
7, Baburao M.
Petitioner is the specific performance pillar.
Huh?
Specific performance.
Huh?
The petitioner is the owner of the scheduled property, my lord. He entered into the agreement with the respondent one
Hmm.
in November 2018
Hmm.
agreement.
Hmm.
In 22, my lord, the respondent plaintiff filed suit
Hmm.
for specific performance.
Hmm.
Along with the two IAS, my lord, one is for not to alienate and one is for not to interfere with the position.
Huh.
And the trial court, my lord, passed the orders in favor of the respondent one and the agreement holder. And subsequently, my lord, the petitioner, defendant number one, owner, filed the MA, my lord. MA is dismissed. My lord. That is page number 94,
Yes.
my lord. Page number
Not to
94.
alienate,
Not to alienate one,
huh?
and not to interfere with the position.
Because you have given up possession, huh?
Yes, my lord. Yes.
In terms of the agreement, if you have given up
Agreement,
possession,
agreement,
then,
agreement.
huh?
But here, my lord, the purchaser is in the Hyderabad.
Hmm?
They are in Hyderabad.
Huh?
And now, my lord, after 3 years, they have filed the suit, my lord, on the expiry of the 3 months. 3 years. Now, my lord, that land is neither they are not coming or not cultivating. Since 1.5 to 2 years, my lord, it is lying vacant. And in so far as first prayer, my lord, that is EA, page number 55, my lord. Against the, there is a subsequent transaction took place sale. And insofar as first prayer, my lord, I don't have any grievance, my lord. Insofar as the second order, my lord, 1, 2, 3. Further, the defendants 1, 2, 3 or anybody claiming through them
Not to interfere.
restricted,
Ah.
restrained
Ah,
by way of temporary injunction
Ah.
from interfering with the peaceful
Hmm.
position of the enjoyment of the plaintiff. Admittedly, my lord, the agreement holder is in Hyderabad, my lord,
hmm.
and they are not interested, my lord. And the land is vacant, my lord, and it is not registered.
Settle ಮಾಡ್ಕೊಳ್ಳಿ.
And matter is pending, my lord, the OS is going, my lord, even now just issues are passed, just posted for the evidence, my lord. It takes years for there, my lord. And now land is lying vacant, my lord, without any this thing, my lord, only insofar as second prayer, my lord, the second order.
Issue notice to respond number one.
Seek lordships.
The petitioner is also permitted to serve a copy of the writ petition along with annexures on the learned counsel representing respondent number one. Next para, insofar as the other respondents are concerned, comma, learned counsel submits that the other respondents are co-defendants and no relief is claimed against them in the writ petition. Full stop.
Only insofar
Therefore,
as, my lord,
notice to the other respondents is dispensed with.
ಪೊಸಿಷನ್ ಯಾಕಂದ್ರೆ ಈಗ ಯಾರು ಮಾಡ್ತಾ ಇಲ್ಲ, ಈಗ ಮಳೆಕಾಲ ಇದಾಗಿದೆ.
ನೀವ್ ಹೆಂಗೋ ಮಾಡಿ ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ಇದರ್ ಸಮ್ ರೆಡಿ ಇದಾರೆ.
You will have to point out to any defect in the impugned order.
No, as per the
It's passed in taking into consideration all the relevant factors. Yes.
no doubt, my lord, 3 years are over, 3 years. And neither they are interested, my lord, nor they have come forward to this thing, my lord. That's why I'm not.
Very fact they are asking for specific performance
House.
shows that they are interested in.
That's why, my lord, that's why first prayer, my lord, first order, I'm not seeking, my lord, I'm seeking, I'm admittedly. Only in so
Let
far
us
as,
see,
my
let them
lord,
come.
Number 12,
that this thing I have started.
No, no.
Naveen Reddy MB.
And vacant ಆಗಿ ಬಿದ್ದಿದೆ, ಮಳೆಗಾಲ ಇದೆ, ರೈತರು.
Yes, sir. Next person, please.
12, Naveen Reddy.
Additional counsel.
Yes.
No, this is a suit filed for a partition.
Hmm.
So it is a second suit. The first suit was withdrawn unconditionally, then the suit is filed. I give 3 dates to your lordship consideration. 2/1/2003, the suit is filed, your lordship. The matter was posted for arguments on 30/6/2018, your lordship. Arguments, it is posted on 12/8/2017. The amendment application is filed on 30/6/2018. And in the application, I bring to your lordship consideration, the affidavit, they do not say what is the due diligence which made them to.
ಏನ್ ಕೇಳ್ತಾ ಇದಾರೆ? What is
ಅವರು
it?
ನನ್ನ ಹೆಂಡತಿಲಿ ಇರೋ ಪ್ರಾಪರ್ಟಿನ ಆಡ್ ಮಾಡ್ಬೇಕು.
ಹಾ?
ನನ್ನ ಹೆಂಡತಿ ಹೆಸರಲ್ಲಿ ಇರೋ ಪ್ರಾಪರ್ಟಿನ ಇವಾಗ ಆಡ್ ಮಾಡ್ಬೇಕು. See, not the part.
Hmm.
Therefore, your lordship will kindly say, the prerequisite is to show that due diligence is done. I am placing a Supreme Court decision on the point, your lordship.
Hmm. You would have said, I was not aware of it.
No, it is not enough.
Okay.
Your lordship will kindly say, before the
That
amendment,
she has purchased the property or that you have purchased the property in the name of your wife.
that question.
He was not aware.
Alla, that
And no sooner he has come to to know of it, he has.
Your lordship will kindly say, that's why I gave a dates to your lordship.
Yes.
Suit is filed on 2003.
ಆಯ್ತು.
And your lordship, they will kindly say,
Hmm.
it is posted for arguments on 12/8/2017. Afterwards, this application is made.
Sir, at any rate, all the properties belonging to the joint family have to be brought to the hotspot.
My lord, one thing, your lordship.
So if it is missed out also, even at appellate stage, he will say, I have come to know that there is one more property, so I will have to add it.
My
Be allowed.
humble submission, your lordship, is after 2002 amendment to the order 6/17, proviso is to be satisfied.
Yes,
That-
yes.
That is what the Supreme.
That is
Court
what I am saying. He would have said, I was not aware of this
It is
property.
not enough, your lordship, because
Ah.
2003 suit. He's my brother. 15 years he has gone on with the case.
Yes.
Now can he come and say that certain properties are in the name of my brother's wife that should be included?
Yes.
Your lordship, that has to be considered by your lordship, whether due diligence has been shown to file this application. That is why my submission, your lordship. Due diligence is shown.
ಅವರು ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಏನೇನಿದ್ರೆ ಪ್ರಾಪರ್ಟಿಗಳು ಹುಡುಕಿರ್ತಾರೆ.
ಅಲ್ಲ 15 ವರ್ಷ.
ನಿಮ್ಮ ಹೆಸರು ನಿಮ್ಮ ಹೆಂಡತಿ ಹೆಸರಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ
ಅಲ್ಲ.
ಅವ್ರಿಗೇನ್ ಗೊತ್ತಾಗ?
ಅಲ್ಲ 15 ವರ್ಷ. And added fact to this, your lordship will kindly say,
Yes.
1997, they say there was a settlement.
Anyway, no prejudice will be caused to you.
No, it will be caused because.
No. See, you will be permitted to say and bring evidence on record to say it is a property purchased by me out of my self-acquired property, or it is purchased by my wife only
My lord,
because she also had earnings.
My lord, if that is the case.
Matter of evidence.
Your lordship, if the matter of evidence, if my wife's properties are claimed, a decree is to pass, she should be made a party. She is not made a party. That is my sir. If they are made a party, then this application is filed, I understand. She is not made a party. Therefore, your lordship will kindly see the Supreme Court. I read to your lordship, then I leave your lordship. By reason of the Civil Procedure Code Amendment Act 2002, Parliament inter alia inserted a proviso to the Order 6/17 of the Code, which reads as under, provided that no application for amendment shall be allowed after the trial has commenced unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of the trial. It is coached in a mandatory forum. The court jurisdiction to allow such an application is taken away unless the condition precedent therefore are satisfied, namely, it must come to a conclusion that in spite of due diligence, the parties could not have raised the matter before the commencement. There is no due diligence. All that they say one word. Now I have come to know. That is not enough for due
ಅಲ್ಲ ಏನು ಡ್ಯೂ ಡಿಲಿಜೆನ್ಸ್ ಇದ್ರೆ?
Due diligence ಅಂದ್ರೆ, your lordship will kindly see, after suit is.
ನನ್ನ ಬ್ರದರ್ಸ್ ಸಿಸ್ಟರ್ಸ್ ಏನಾದ್ರು ಪ್ರಾಪರ್ಟಿ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರೆ
ಅಲ್ಲ
I
15
should bring it.
15 ವರ್ಷ. I understand your lordship, after suit is filed 1 year, 2 years or 3 years. After 15 years, and particularly facts of this case is in 1997, he says 97 there is a settlement. We are all living separately. All living separately, when it is accepted by him, that is what he has pleaded. Then your lordship acquiring the property after 1997 could not be a property of the joint family. And as he made a submission to your lordship is that the earlier suit is withdrawn without the permission of the court. One of the prayers sought by the plaintiff is, if your lordship may kind enough to take at page 41. Page 41 ತಗೊಂಡಿರ್ತಾವೆ. This is a second suit. 97, they themselves say in the plaint. There was
They
a
have
settlement.
relied upon a judgment of the Supreme Court, which I said,
Yes,
all properties have to be brought to the hotspot.
that is true,
Other-
that is true, your lordship. First of all, in this case, your lordship, earlier suit is filed and it is withdrawn. 41 ತಗೊಂಡಿರ್ತಾವೆ. Prayer of page 41. First prayer, grant permission to the plaintiff to institute the suit notwithstanding the withdrawal of earlier suit. Earlier suit in 96, he says in the plaint 97, there was a settlement. Once it is said it is a settlement, from that day onwards, we have all become a separated partner. Even if they have acquired the properties, it is our self-acquired property. Therefore, your lordship, the suit, basically the suit for partition is not maintained because once the plaint alleges that there is a settlement, then your lordship will kindly say, where is the joint family, your lordship?
No, that is not the consideration now.
No.
We are only concerned
Yes,
about
I
the
know.
present impugned order.
Your lordship.
Yes,
On the merits of the application, I cannot argue.
yes.
But it is relevant for the consideration of Order 6 Rule 17 that has to be considered. That is what my suggestion.
Issue notice to respond number 1. The petitioner is also permitted to serve copy of the writ petition along with annexures from the learned counsel representing respond number 1 before the trial court. insofar as the other respondents are concerned, comma, learned counsel submits that the other respondents are four defendants.
I
Along
file
with
an
the-
application dispensing notice for them.
Huh?
I'll file a memo.
Kodi has filed a memo seeking dispensation of notice on the ground that the other respondents are co-defendants along with the petitioner before the trial court.
Yes.
And no relief is sought against them in the writ petition.
Yes.
Full stop. Next para. The contention of the learned counsel for petitioner is that although an immovable property purchased by the petitioner's wife is sought to be included in the suit schedule by filing an application on the order 6 rule 17 is filed by the plaintiff and the same is allowed, comma, the petitioner's wife is not sought to be brought on record. Full stop. The learned counsel would therefore submit that the owner of the property who is not a party to the proceedings but her property is included as a part of the suit schedule in comma in a suit for partition, comma, great prejudice will be caused to the owner of the property. Full stop. Next para. Release this matter on 24th of September 2024. Full stop. The trial court, the learned 29th additional city civil and session judge from Bengaluru, bracket CCH 30, is hereby directed not to proceed with the suit in OS number 281 of 2003 till the next date of hearing.
Serial number 13. Shivani Shetty.
Your Lords, in April 2018, I had let out my apartment for rent to the respondents, Your Lords. Thereafter, in March 2021, they have stopped paying me rent completely. And then I issued legal notice for eviction, and thereafter I filed a suit for eviction, Your Lords, on 30/6/2022. Along with my suit for eviction, I had also filed an IA for deposit of interim rent in court, Your Lords. Your Lords, that said IA was heard on 30/6/2022 and then emergent notice was issued. Thereafter, Your Lords, the respondents didn't appear in the matter for about 6 months. Evidence of the plaintiff was taken on record, and after evidence was taken on record, they filed an application for recall and reopen, which was later allowed. However, Your Lords, despite that being allowed, they did not file any objections to my IA for deposit of interim rent, Your Lords. Your Lords, despite six to 7 months time given to them, they did not file any objections, and the court finally reserved the IA for interim rent for orders on 6/3/2023, Your Lords. Your Lords, thereafter, even after reserving it for orders, no order has been passed on the said IA, Your Lords. It has only been reserved for orders. Your Lords, because of this, I have lost out on rent for about 3 years, Your Lords, in the said property. and the defendants are still residing in the suit schedule property and they're not paying even a single penny in rent. They are only dragging the proceedings in the trial court, your lords. Your lords may peruse the order sheet, your lords.
Learned counsel for the petitioner submits that although the learned 26th additional city civil and session judge, bracketly CH-20, Mayo Hall, Bangalore, has heard IA number 1 of 2022 filed by the petitioner plaintiff under Order 39 Rule 10 of CPC for deposit of arrears of rents during the course of the proceedings, nevertheless, no orders have been passed till date, full stop. The learned counsel would therefore submit that necessary directions may be issued to the learned judge to pass orders on IA number 1 of 2022, full stop. Next paragraph. Having regard to the innocuous prayer made by the petitioner, this court is of the considered opinion that there is no need to issue notice to the respondent, full stop. Next paragraph. Consequently, the writ petition stands disposed of with the direction to the learned so-and-so judge to consider and dispose of IA number 1 of 2022 as expeditiously as possible and at any rate within a period of 6 weeks from the date of receipt of a copy of this order. Ordered accordingly.
14. HR Ananta Krishnamurthy.
Petition. Suit is for the permanent injunction. Issues have been framed. Thereafter, the defendant files an application here for seeking to
Suit for eviction.
injunction, bare injunction.
Bare injunction.
Bare injunction.
Ah.
Defendant files an application seeking to frame an additional issue stating whether the suit filed by the plaintiff is maintainable without seeking declaration. That has been allowed. The last time I turn to page 59, that has been allowed on July 24, page 59. Last time I turn to the schedule to the plaintiff.
There?
Page number. Page 21. Survey number 110, new 110/1. This is land in a KG village, Kayam Gutta village. Mysore Personal and Miscellaneous Finance Abolition Act applies. The plaintiff has been registered as an occupant of the land. That has become final. In respect of a land located in a KG village or a Jodi village, suit for declaration of title is barred. I cannot file a suit for declaration. My title is confirmed. Nobody else can question my title. My title is confirmed. Defendant has not made any application for conferment of occupancy right. He has no right to question my right. This is covered by a number of judgments. 2 judgments are only a Turn to para 24 and 25. Or the judgment. Got it?
No. Before going there, let us see the affidavit filed along with the application.
Page. Forty-nine. Application, affidavit. Page 50.
Yes, affidavit.
Affidavit, page 50. I state that this honorable court pleased to frame issues after the filing of the written statement on 17/4/2018. It is the settled rule of law that the issues must be framed in consonance with pleadings of the parties and on the admission of the plaintiff in the written statement. I state that the plaintiff is not the owner of the suit schedule property, as there is heavy cost load upon the title of the suit schedule property. I state that on careful reading of the arguments of the plaintiff in the plaint, it is clear that there is a dispute as to the ownership and identity of the suit schedule property. I state that the suit schedule property claimed by the defendant as absolute lawful owner. On the other hand, the plaintiff is claiming to be the owner of the suit schedule property on the basis of fraudulently created documents from fictitious owners. Further, I state that there existed heavy cloud on the title of the property. I state that it is just and necessary to recast the issues by framing additional issues as plates on. Whether the suit filed by the plaintiff is maintainable without seeking declaration. I state that the court at any stage of proceeding is having discretionary power for recasting the issue. I state this honorable court may kindly recast the additional issues as plate. I state that the issues already framed are required to be recasted and framed in the fashion mentioned above. If the issues are framed as proposed, no loss or prejudice will be cast to the other side. On the other hand, heavy loss will be cast to the plaintiff, applicant, first defendant. Under these circumstances, the plaintiff ought to file a suit for declaration and other consequential relief. Hence, the suit is not maintainable without seeking declaratory relief. Hence, it is just and proper necessary to recast the additional issues as per for in the accompanying application. I have been registered as an occupant. Question of filing a suit for declaration does not arise at all. Defendant has not even made an application for registration of occupancy rights, as is mandatorily enjoined under the Inam Sabhalishna. In para 3 of the plaint, I have clearly stated.
Para?
3 of the plaint.
Ah.
At page 4, I stated that I have been registered as an occupant.
Para 3.
Para 3 and 5. It is pertinent to note that on vesting para 5 at page 5.
It is
It is
submitted.
pertinent to note that on vesting of the scheduled land after the enforcement of Mysore personal inam about the snack.
Para 5, page number
Para
14.
5, page 5.
Page 14, 15.
Petition I am reading. I'll read the plaint.
ಅಲ್ಲ ಇದು annexure A is the plaint, isn't it?
Plaint, annexure A.
ಅದ್ರಲ್ಲಿ ಏನು ಎಲ್ಲಿ
Here. Page 16, para 7.
Yes, para 7.
It is submitted that after coming into force of the Mysore Personal and Miscellaneous Finance Abolition Act 1954, an application was made by plaintiff number 1, Srimati M.B. Sharadamma, in order to get registered herself as an occupant in respect land bearing survey number 110, now renumbered as survey number 1110/1. After inquiry, she has been registered as an occupant in respect of land bearing survey number 110/1, measuring 1 acre 18 guntas, by an order passed by the Special Deputy Commissioner of Finance in case number 15 of 56.
Yes. You are both. This judgment.
Judgment. Para 24 and 25. To consider this part of the question, we may briefly refer to the relevant provisions of the Inam Sabhalishna Act upon the notification issued by the state government in exercise of the powers conferred under section 1(4) Inams would stand abolished, and by section 3(1)B, the lands in the Inam villages will vest absolutely in the state. Section 4 provides for registration of Kadim tenant. It confers rights on every Kadim tenant of the Inam Bar to be registered as an occupant in respect of the land, which immediately before the date of vesting was properly included in its holding. Section 10 provides for determination of claims of applicants seeking registration of occupancy rights. Section 10A provides that after the determination of claims under section 10, the tribunal shall send the prescribed particulars of the decision to the officer maintaining the record of rights under the Karnataka Land Records Act 1958. Section 10A2 states that the officer concerned shall enter such particulars in the registered maintained under the Karnataka Land of Records of Rights Act 1958. Section 28 provides for appeal for from orders under section 10, so far as it relevant it provides now. Section 31 deals with the powers of the High Court and section 3 reads thus. Save as other provided in this act, an order passed by the Deputy Commissioner or by the special tribunal under this act shall be liable to be cancelled or modified except by the High Court as aforesaid or to be questioned in any court of law. To sum up, after the inams were abolished and the lands vested in the state government, the only right preserved to the parties to apply for registration of occupancy rights either as Kadim tenant, permanent tenant, or other tenants recognized under the law, when such is not. Who is the statutory authority constituted under the inams of this act, he is required to make an inquiry and grant relief. His order is appealable under section 28 of the Karnataka to the Karnataka Revenue of that tribunal, and the decision of the tribunal becomes final. Section 31(3) states that no order passed by the Deputy Commissioner or tribunal shall be liable to be cancelled or modified except by the High Court under section 31. The jurisdiction of the High Court under section 31 is however limited and confined only to orders determining compensation except those referred to in section 28. It is thus seen that the inams of this act attaches finality to the orders granting registration of occupancy right. What does it mean? Is it not an implied exclusion of jurisdiction of civil court? Is not the inams of this act a complete code by itself? Does it not provide machinery for adjudicating the rights of the parties without appellate forum to correct the errors the adjudicating authority? If that is so, could the civil court still exercise general jurisdiction over the same dispute? Had the legislature intended to provide dual remedies to parties or intended to establish two authorities to determine the same question? We think not. The grant of occupancy rights as Kadim tenants, permanent tenants, or any other tenant is within the exclusive jurisdiction of the special authority constituted under the norms of this act, which is a special enactment. Its order is appealable and to the prescribed authority, and it then becomes final. It is therefore legitimate to infer that by reason of the provisions of section 28 read with section 31(3) of the norms of this act, the adjudication as to the registration of occupancy right in respect of the land, which immediately before the date of vesting was properly included in holding of the applicant, becomes final and conclusive. The civil court has no jurisdiction to reopen that matter.
But no one is, see, the defendant is not asking for reopening that issue.
Then when my rights are concluded, the
Ah.
question of framing an issue, suit for declaration is not maintainable. It is only the special deputy commissioner that can go into that question. Now it is land tribunal. When he has not made an application, he is not my rival claimant. When my rights are concluded, when the civil court cannot say that the order passed is wrong. My title is confirmed. It can't go into my title. If it can go, it would be reopening the order passed by the deputy commissioner.
No, no, no.
Next also.
Yes.
Para 26. In referring to another judgment of this honorable court, we need not labor the point further. This court in Rangappa versus Chinnapaya, while referring to the earlier decision Kempanna versus Kempanna, has taken a similar view. Then there it was observed. So it becomes clear that the provision for an adjudication by the deputy commissioner under section 10 and for an appeal from his adjudication under subsection 1 of section 28 are by themselves more than sufficient to support the view that adjudication should be made only in the manner provided by the act and only by those tribunals entrusted with the power to make that adjudication and by no other. If the addition to subsection 1 of section 28 adds that the decision of the prescribed authority in appeal shall be final, the inference deducible from the fact is that there is complete machinery provided by the act for the adjudication of a claim, that the civil court shall not exercise jurisdiction for such adjudication and reinforced.
But you see, please see paragraph number.
Next para, the one. That, however, does not mean that the plaintiff's suit for declaration of title and consequential rectification of entries in the record of right is not maintainable. Raghavendra, so only consequential relief is declaration, record of rights rectification. Here, only injunction. Not
Sir, if the dispute sought to be raised by the defendant arises out of the Inams Abolition Act, then you are right. That is not the contention of the defendant.
Fine.
The defendant has set up a totally different title.
No,
He is
has not-
saying,
No, he has not set up any
you please
difference.
see
He-
the written statement.
He only did the work.
You please see, you please see the written statement.
He only work. The last-
Adhe, it has
Adu,
got nothing to
Bharat-
do with the Inams Abolition Act.
This honorable court, bench has not brought this to Kumar Judge. Last time, last time I turned to the last judgment. Last judgment. Writ appeal.
Karnataka State Board of Works.
Yes. They must also make an application for registration of occupancy right. If they do not make, they have no right. The contention was, last time I turned to 8 para 20. 21. Para 21. Para 20. From a reading of the entire document, it is clear the intention of the work was not to give these lands as a permanent dedication. What is given is the right to collect the revenue and spend the same towards expenses of Dargah. Therefore, it is clear from the aforesaid translation, there was no intention on the part of the work to dedicate the property to God. What is given under the said document is only right to collect the revenue from the land and spend it towards meeting the expenses of Dargah. In the translation provided by the petitioner, the word used in this is confirmed as Imam. When the document expressly states as Imam, it is also supported by the recitals read as a whole. It is not possible to accept the contention of the petitioner that it is not an Imam, but it is a work. Therefore, the land in question is an Imam land and not a work property. The Imam Abolition Act was enacted by the state legislature in public interest to provide for the abolition of religious charitable Imams in the Mysore area. It applies to religious Imams, including the Sringeri Jagir and charitable Imams. The explanation to subsection 3 of section 1 extends the meaning of the religious Imam or charitable Imam. It means a grant of a village, portion of a village or land entered in the register of Imams, quit register, rent register, alienation register, or any revenue account maintained by or under the authority of the government as Devadaya Imam or Dharmadaya Imam, as the case may be. Inamdar means a religious or charitable institution owning an Inam. Section 3 of the Act provides for consequences of vesting for an Inam in the state. It provides when the notification under subsection 4 of section 14 of in respect of any Inam has been published in the Mysore Gazette, then notwithstanding anything contained in any contract, grant or other instrument or in any other law for the time being enforced, with effect on and from the date of vesting, and save as otherwise expressly provided in this Act. The consequences which follow are enumerated. Clause 3B provides all rights, title, and interest vesting in the Inamdar, including those in all communal lands, cultivated lands, uncultivated lands, whether assessed or not, wasteland, pasture land, forests, mines, and minerals, quarries, rivers, and streams, tanks, and irrigation work, fisheries, and ferries shall cease and be vested absolutely in the state of Mysore, free from all encumbrances, and persons who are entitled to be registered as occupant are given an opportunity to make an application, and in the absence of any such claim from the occupant, Inamdar has been given right to seek for re-grant of the land in which there are no claims or claim compensation in respect to the lands which cannot be re-granted. From the material and record, it is clear, both from the sanad and also entries in the quit register, it is clear that land in question is entered as an Inam land. In para 7 of the petition, second petitioner claims to be an Inamdar of the land. Land in question is given as an Inam to the second petitioner, which is a religious and charitable institution. Therefore, section 3 of the Inam Abolition Act is attractive. And a notification was issued extending the provisions of the Act to the land in question. The said land vested with the state government free from all encumbrances. Neither the validity of the Act nor the notification extending the application of the Act was challenged by the petitioners for nearly 50 long years. Even now, what is challenged is the notification and not the validity of the Act. The notification is issued in pursuance of the Act. If the Act is applicable, the notification only extends application of the act. When the act is not challenged, the notification cannot be challenged. Even otherwise, as is clear from the statute of provision, the land in question being an Inam land and the second petitioner being the Inamdar, the said land vested with the government free from all encumbrances. Therefore, the Inam Abolition Act is applicable to the land in question and the land vested with the government free from all encumbrances. It is on record for the last 50 years. Tenants who are cultivating land applied under the provisions of the Inam Abolition Act for grant of land and have been granted occupancy right. Persons who are in occupation of land, who unauthorizedly applied for regularization of their occupation, accordingly they have also been granted land. Invitation entries are made in their favor. The appeal filed challenging those matters, the invitation entry by the petitioners have been dismissed. After expiry of the prohibited period, these guarantees are sold in the land in turn to third parties. The third
Who
party.
was the Inamdar in your case?
Yeah, Anthony Michael.
Huh?
Anthony Michael. Anthony Michael.
They are the permanent tenants.
They are permanent tenants. They have been registered as an occupant.
Perfect. Issue notice to the respondents. The petitioners are also permitted to serve copies of the writ petition along with annexures on the learned counsels representing the respondent before the trial court. Next, learned counsel for the petitioners submits that in a suit for permanent injunction filed by the petitioners, against the respondents here, an application was filed by the respondent defendants in IA number 10 under order 14 rule 5 read with section 151 of CPC to frame an additional issue regarding maintainability of the suit on the ground that a cloud is cast on the title of the plaintiff over the suit schedule property, and therefore an issue regarding the maintainability is required to be framed. Full stop. The respondent defendants sought for framing of issue as to whether the suit is maintainable without seeking the relief of declaration. Full stop. The trial court has accepted the contention of the respondent defendants and has proceeded to frame an issue accordingly. Full stop. Next para. Learned counsel, however, contended that in the the plaintiffs have clearly stated that an order was passed by the Special Deputy Commissioner of Inams in case number 15 of 1956-57 under the provisions of the Mysore personal and miscellaneous close bracket Inams Abolition Act 1954 conferring occupancy rights in favor of the first plaintiff, Srimati M.B. Sharadamma. Full stop. Thereafter, an order of conversion was also passed in the year 1974. Full stop. That being the position, it is submitted while pointing out to a judgment of the Honorable Division Bench of this court in the case of Karnataka State Board of Works and another versus State of Karnataka and others in writ appeal number 5591 of 2011 and connected matter dated 5/11/2012 that the division bench has clearly held when undoubtedly the land in question is an Inam land and orders are passed by the competent authority in favor of one party and the same is not questioned by the other, and if it is sought to be contended by the Karnataka State Board of Works that the act is not applicable and they challenge only the notification, comma, such a contention cannot be accepted. Full stop. It is also pointed out to another decision of a division bench in the case of Stump Shule and Somappa bracket P Limited versus Chandrappa, wherein it was held it was held that the civil court has no jurisdiction to reopen such matters. Full stop. The learned counsel would therefore submit that when the petitioner plaintiffs have clearly stated that they have acquired ownership over the suit scheduled property in terms of the orders passed by the competent authority under the Inam Abolition Act, 1954, question of framing an issue regarding the title of the plaintiff would not arise. Stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order. Dated 2/7/2024. ಅಷ್ಟಾದ್ರೆ ಸಾಕಲ್ಲ by stay of all further proceedings.
Not necessary.
Not necessary. Till the next date of hearing.
Number 15. Case Chandrahasa.
It's a plaintiff's writ petition wherein an application to strike off the defense has been filed by the plaintiff in an ejectment suit and huge arrears of rent is due. Is the case of the plaintiff that 75,000 is the rent payable from 2018, my lord, even as per the undertaking given by the,
It's before the commercial code.
yes, my lord.
Huh.
And in the, they have not, they took up a contention in the written statement stating that 50,000 is the rent. Thereafter, they filed a memo of calculation contrary to that. And even in the written statement at para 20, my lord, I have produced that. The arrears of rent which is held due is clearly seen. In 51 months, only 37 months rent is
Your application to strike
strike
out
of
the
the
pleadings
defense,
has been dismissed.
defense and direct him to pay the arrears of rent.
What interim order can be passed?
The
now?
interim order, I sought the stay of the impugned order only. I am not asking for the stay the further proceedings.
Stay ಆದ್ರೆ ಏನಾಗುತ್ತೆ?
ಅಂದ್ರೆ they should not, in the final disposal ನಲ್ಲಿ, you have not challenged this order and it has become final.
No, no, you have challenged the order. You have filed a writ petition.
Yes, ma'am.
Issue notice to the respondent. The petitioner is also permitted to serve a copy of the writ petition along with annexures on the learned counsel representing the respondent before the trial court.
16, Giridhar H.
Petitioners are for recalling of the attachment of his salary. And that came to be rejected, stating that by considering the earning of the petitioner out of the overtime allowance, stating that overtime allowance, in fact, the overtime allowance is not constant.
The Union Bank of India is the decree holder.
Yes, along with another two decrees have been now guarantor. He was a guarantor in two cases. In two decree, one is Bank of Baroda. Already, initially, the salary was attached.
You are a borrower?
No, guarantor.
You are a guarantor?
Yes, ma'am.
Who is the borrower?
The relative. One borrower is the wife. Here, the second respondent is the wife.
Wife is the borrower.
Wife is the.
You are the guarantor.
Yes.
And what is the purpose of your guarantee then?
My lord, my difficulty is my salary is being attached more than I am not against the attachment of salary. My grievance is one beyond 1/3. It is being attached out of two attachment order. One is 50 for 15,000. Another one is 27,000. Totally, out of my salary, 41,000 is being deducted. That is beyond 1/3. The trial court, the commercial court has come to a conclusion that if OT is taken into consideration, then it is not beyond 1/3. My OT is not constant. Sometimes I don't have the OT, and if it is goes beyond the 1/3 because of non-availability of the overtime allowance, I will be getting only 1/3 of the. That is my grievance.
Issue notice to respond number 1.
I sought for the same.
The petitioner is also permitted to serve a copy of the writ petition along with annexures on
My lord, it is in
counsel
Mangalore.
representing respondent number 1 before the trial court.
Mangalore.
Notice to respond number 2 is not necessary.
Dispense.
Since respond number 2 is the judgment debtor along with the petitioner. Release this matter.
My lord, stay
on 24th of September.
Till such time.
ಮಧ್ಯಾಹ್ನಕ್ಕೆ 2:30 ನಿಮಿಷ ತಗೊಳ್ತೀರಿ ಇದು ಕಂಟಿನ್ಯೂಷನ್ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಕಂಟಿನ್ಯೂಷನ್
48 matter.
Preliminary hearing ಆದ್ಮೇಲೆ
14868 and 24. ಇಲ್ಲ ಹೀಗೆ ನೋಟಿಸ್ ಆಗಿಲ್ಲ. ಅದೇನಾಗಿದೆ ಅಂದ್ರೆ ಇವರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ನೋಟಿಸ್ ಕೊಟ್ಟು ನೋಟಿಸ್ ಅಂದಿದೆ. ಇಲ್ಲ ಅಂದ್ರೆ ಪೋಸ್ಟ್ ಆಗಲ್ಲ. IFR ಅಲ್ಲಿ ಏರಿಂಗ್ ಹಾಕೊಳ್ಳಿ ಅಲಾಂಗ್ ಏನಿದೆ ಪೋಸ್ಟ್ ಇಲ್ಲೇ ಕಾಮನ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಪೆಂಡಿಂಗ್ ಹಂಗೆ ಪೋಸ್ಟ್ ಆಗುತ್ತೆ. ಬಟ್ ಅಲ್ಲಿ ಏರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ. ಯಾವಾಗ ಇಷ್ಟೇ ಬಟ್ ನಾವೇನು ರೀಚ್ ಕೊಟ್ಟಿಲ್ಲ ಕಟ್ಟಿಲ್ಲ ಪ್ರಪೋಸಲ್ಸ್ ನಾಟ್ ಪೇಡ್ ದಿ ಪ್ರೋಸೆಸ್ ಆಲ್ಸೋ. ಇದು ಹಾಗೇ ಇಲ್ಲ ಅಲ್ಲಿ ಆಫೀಸ್ ಅಲ್ಲಿ ನೋಡಿ ಆರ್ಡರ್ ನಲ್ಲಿ ಏನಿದೆ ಆಫೀಸ್ ಕನ್ಸೆಷನ್ ಫಾರ್ 1 week, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ 1 week ಅಂತಿದೆ. ಅದೇ ಬೈ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆಯೋ ಅಥವಾ ಏನಾಯ್ತು ಅಂತ ಗೊತ್ತಾಗಿಲ್ಲ. ಫೈಲಲ್ಲಿ ಅದೇ ಇದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಆರ್ಡರ್ ನಲ್ಲೂ ಇದೆ ನೋಡಿ, ಡೈಲಿ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್. ಅದಕ್ಕೋಸ್ಕರ ಮೆಮೊ ಕಳ್ಸಿದ್ರೆ ಇವ್ರು ಇದು ಮಾಡಿ ಕಳಿಸ್ತೀವಿ. ಅದಕ್ಕೆ 2-3 ಮೆಮೊ ಕೊಟ್ಟಿದ್ದು ಹಂಗೆ ಇದೆ ಹುಟ್ಟಿದೆ. ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ, ಕಳ್ಸ್ಕೊಟ್ಟಿಟ್ರೆ ಆಯ್ತು. ಬೆಳಿಗ್ಗೆನೂ ಕೊಟ್ಟಿದ್ದೀನಿ. ಇಲ್ಲ ಸರ್ ಹೋಗಿಲ್ಲ, ಅದಕ್ಕೆ ಅಲ್ಲಿ ಹೋಗಿ ಇಲ್ಲ ನಾನು ತೆಗೆದು ಫೈಲ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅವ್ರಿಗೆ, ಮೆಮೊ ತಂದ್ಬಿಡಿ ಸರ್ ಅಂತ. ಹಾಗಾಗಿ ಫೈಲ್ ನನ್ನ ನಾನು ಇಡ್ತಾ ಇರೋದು ಮೆಮೊನ ನೋಡಕ್ ಹೋಗಲ್ಲ, ನೋಟಿಸ್ ಅಂತ ಆಗ್ಬಿಟ್ಟಿದ್ರೆ ಸಂಗ್ರಹ ಬಿಡ್ತಾರೆ. ಇಲ್ಲ ಅಲ್ಲಿ ಹೋಗೇ ಇಲ್ಲ, ನಿಮ್ಮಲ್ಲೇ ಇದೆ. ಅದಕ್ಕೋಸ್ಕರ ಬರ್ದು ಕೊಟ್ರೆ ನಾನು ನೋಡಿ ಕೊಡ್ತೀನಿ. ಹೋಗಿಲ್ಲ
ಅದ್ಯಾರು ಹೇಳ್ತಾರೆ ಅಂತ
ಎಲ್ಲಿದೆ ಎತ್ಕೊಡು. ಇಲ್ಲ ಮೆಮೊ ಇದ್ರೆ ಕೊಡಿ ಇನ್ನೊಂದು ಕಾಪಿ. ಬರ್ಕೊಡಲ್ಲ ನಾಳೆ ಅಲ್ಲಲ್ಲ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಇಲ್ಲ ಸರ್, ಅಲ್ಲಿ ಬಂದಿಲ್ಲ ಅಂತಾರೆ. ಅದಕ್ಕೋಸ್ಕರ ಈಗ ಬೆಳಗ್ಗೆ ಇನ್ನೊಂದು ಮೆಮೊ ಕೊಡ್ಲಾ ನಿಮ್ಗೆ? ನೆನಪು ಮಾಡ್ಕೊಡಿ, ನೆನಪು ಮಾಡಿ ಕೊಡ್ತೀನಿ. ಆಯ್ತು ನಾನು ಬರ್ದಿರ್ತೀನಿ. ನೋಟಿಸ್ ಏನೋ ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಪೋಸ್ಟ್ ಮಾಡಿ ಅಂತ ಪೋಸ್ಟ್ ಮಾಡಿ ಬರೀ ಆಗ್ಬೋದು. ಅದು ಅಲ್ಲೇನು ಇದೆಯಾ ಸೈಡಲ್ಲಿ ಆ ಕಡೆ ಹಾಕಿದೆ ಅಲ್ಲ, ಅದ್ರಲ್ಲೇನು ಹುಡುಕ್ ನೋಡ್ಲಾ ಇದ್ರೆ ಬರ್ಸ್ಕೊಟ್ಬಿಡ ಅದರಲ್ಲಿ. ಅಲ್ಲ ಅವಕಾಶ ನೆನೆ ನೋಡಿದ್ರಿ ಎಲ್ಲೋಯ್ತಯ್ಯ ನಿನ್ ನೋಟಿಸು ನಿನ್ನ ಇಲ್ಲ ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದಿಲ್ಲ.
ಮಧ್ಯಾಹ್ನ 2:30 ಲಿಸ್ಟ್ ತಗೊಂಡು ಅಲ್ಲಿ ಬರ್ತಾರ ಯೂಶುವಲ್ ಮಧ್ಯಾಹ್ನ ಅಪ್ ಟು ಮುಗಿದ್ಮೇಲೆ
ಹೇಳಕ್ಕಾಗಲ್ಲ ಸಾಹೇಬ್ ಹೇಳ್ತಾರೆ. ನಿಮ್ಮಲ್ಲಿ ಬುಕ್ ಇದೆಯಲ್ಲ ಸಾ, ಬುಕ್ ಇದ್ರೆ ಕೊಡಿ ಒಂದ್ಸಲ ನೋಡ್ತಾ. ಬುಕ್ ಮಾಡ್ತಾ ಇಲ್ವಾ? ಸರಿ ಸರ್, ಓಕೆ ಬೆಳಗ್ಗೆ ತರ್ತೀನಿ.
ಸೊ 38 ಏನಾದ್ರು ಅಡ್ಜಸ್ಟ್ಮೆಂಟಿಂಗ್ ಅದೇ 15 ಮ್ಯಾಟ್ರ್ ಇದೆ ಅಲ್ಲ 230 ಅದು ಬಿಟ್ಟು ಇನ್ನೊಂದು ಇದೆಯಾ? ಯಾವ್ದು ಬಿ ಗ್ರೂಪ್? ಹಂಗ 230 ಅದ್ಯಾವ್ದು 230 ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟ್ರ್ ಯಾವ್ದು ಇತ್ತಲ್ಲ ಅದಿದೆಯಾ? ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಒಂದಿದೆ ಇನ್ನೊಂದು ನೋಡ್ದೆ ನಾನು ಒಂದು ಐಡಿಯಾ ತಗೊಳಕ್ಕೆ ಏನೇನಾಗುತ್ತೆ ಅಂತ. ಒಂದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ 230 ಇಲ್ಲ ಬಟ್
ಕಂಟಿನ್ಯೂ ಸರ್.
ಇನ್ನೊಂದು ಶಾರ್ಟ್ ಲಿಸ್ಟ್ ಇದೆಯಾ ಅದು ಬಿಟ್ಟು? 38 ಏನು ಅಡ್ಜನ್ ಆಗಿಲ್ಲಲ್ಲ? 38
ಎಷ್ಟು ಕೇಳಿದ್ರೆ ನೋಡಿ.
ಸಾರಿ ನಾವು ಒಂದು
ಇದೆ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಇದೆ ಅಲ್ಲ, ಬರ್ತಾರೆ ರೀಚ್ ಆಗುತ್ತೆ. ಕೈಯೇಗೂ ಹೋಗಿಲ್ಲ ರೀಚ್ ಆಗುತ್ತೆ.
16 ಹೋಗ್ತಾ ಇದೆ ಸರ್. ಈಗ 16 ಆಯ್ತಾ?
16 ಆಯ್ತು. 17 ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಏನ್ ಸೇರಿದೆ ಅದೆಲ್ಲ 10th ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ ಡೇಟ್. ಹೌದು 45 ವರೆಗೆಲ್ಲ ಹೋಗಲ್ಲ ಸರ್ 230 ಎಲ್ಲ ಆದ್ಮೇಲೆ ಆಮೇಲೆ ಲಾಸ್ಟಿಗೆ ಬರುತ್ತೆ. ಹಾ ಅಯ್ಯೇನಾ ಆಗಬಹುದೇ ಏನೋ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಅದು ನಿಮ್ಮ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗುತ್ತೆ ಸರ್, ನೀವು ಎಷ್ಟೊತ್ತು ಮಾಡ್ತೀರಾ ಅನ್ನೋದ್ರ ಮೇಲೆ. ಯಾವತ್ತಾಗಿದೆ ಲಾಸ್ಟ್ ಮಂತ್ ಇತ್ತ ನಂಬರ್ ಏನು 23 ಅಲೋ ಆಗಿದೆಯಾ ಅದು? ಯಾರು ಗೆ ತಗೊಂಡಿದ್ದಾರೆ ನೋಡಿ, ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಏನಪ್ಪ ನಾವು ಇಲ್ಲಿಂದ ಬಂದಿರೋ ಅಲ್ಲಿಗೆ ಕಳಿಸ್ತೀವಿ. ಆಗಲ್ಲ ಅಲ್ಲೇ ಅಲ್ಲಿಗೆ ಕಳಿಸಿರ್ತೀವಿ. ತಗೊಂಡಿದ್ದಾರೆ ನೋಡಿ 780.
ಆರ್ಡರ್ಸ್ ಯಾವ್ದು ಅಡ್ಜರ್ನ್ ಆಗಿಲ್ಲ? ಯಾವ್ದಾಗಿಲ್ಲ. ಅದರ್ ಸೈಡ್ ಇದ್ರೆ ಮಾತ್ರ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ಶಂಕರ್ ಎಚ್ ಎಸ್ ಬಂದಿದ್ದೀರಾ? ಶಂಕರ್ ಎಚ್ ಎಸ್.
ಯಾವ್ದು ಮಾಡ್ಕೊಂಡು ಯಾಕೆ?
ಅದ್ರದ್ದು ಮಾತ್ರ ಅದ್ರಲ್ಲಿ ನಿಮ್ಗೆ
ನಮಸ್ಕಾರ.
Continuation thing, admission. 21. 25 mention చేశారు. చేసినట్టు కదా డిస్మిస్ ఎలా అదే అఫర్ట్ ఏం కావాలా నాకు లీవ్ చేయండి రెస్పాండెంట్ నేను నాకు తెలియదు అటో క్లోజ్ అయిపోయింది మ్యాటర్ క్లోజ్ అయిపోయింది ఇంకేం ఇది అయిపోయింది సెకండ్ లిస్ట్ అంతా డిస్మిస్ అయిపోయింది అవంతా సెకండ్ అది అడ్మిషన్ మెన్షన్ ఇక్కడే వచ్చాయండి 1 month అయింది ಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಏನ್ ಮಾಡ್ತೀರಾ
ಪಾಸ್ ಓವರ್ ಏನಿದೆಯಾ? ಕರ್ಕೊಡಿ.
Lordship's kind indulgence. Lordship's kind. Item number 25, minutes. First list. By letter respondent advocate filed memo saying that the litigation before the court below has been closed. But I have not been ascertained the fact. I am the plaintiff before the court below. No order also has been produced. We will ascertain a week's time.
List number 2.
List number 1. Item number 25.
List number 1, still number 25, my lord.
Close ಆಗಿದೆ ಅಂತಾರೆ, but order copy.
Don't have copy.
It is my memo.
Correct. But
The original
order copy ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ?
No, I have asked the respondent to get the order copy. In the meanwhile, the suit itself has been.
ಅದೇ
Yes.
disposal.
I'll produce that order.
Serial number 25. At the request of learned counsel for the petitioner, release this matter on 11th of September. Yes.
List number 2, serial number 8, it become infructuous. Again, suit dismiss ಆಗಿದೆ.
You are for the petitioner.
I am for the petition.
You have a copy of that order?
Suit dismiss ಆಯ್ತು.
ಅದೇ disposal ಆಗಿರೋದು ಯಾವತ್ತು?
ಇನ್ನು ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ. ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ.
Date?
Date Monday last 27th.
I'll note order ಮಾಡ್ತೀನಿ. ನಮ್ಮಲ್ಲಿ ಇದೆ information.
My lord, serial number 13 in the second list.
For the
The
petition.
writ petition has become infructuous, my lord. The
13.
matter is settled between the parties.
13.
13.
The petitioner in that case, we are filing a withdrawal. 13, second, list 2, sir. The matter is settled between the parties amicably. Maybe withdrawn.
Memo filed by learned counsel for respondent.
We have also filed. Petitioner.
ನೀವು ಫೈಲ್ ಮಾಡಿದ್ದೀರಿ. All right. OS number 2363 of 2020.
Yes.
Has been settled before the Lok Adalat. On
7/8/2023.
7/8/2023.
23.
Disposed of. Yes.
Two serial number 3 is also become infructuous. The trial court has passed the final judgment. The appeal against the interim order may not survive. I'm filing a memo for withdrawal. List 2 serial number 3.
Memo filed by learned counsel for petitioner OS 3080 of 2022. Disposed of on 19/8/2024.
Yes, ma'am.
Yes.
Please, ma'am.
Yes.
Passed over matter, serial number 4. Mohammed Tair.
That should be called along with 19, isn't it?
Yes, lordship, along with 19 to be made.
Yes.
Continuation. Serial number 17. Manjunath Rao Bonsle.
And for the petitioners, my lord, the respondent here and filed a voice number 2002, my lord, seeking a position of the suit sort of property, the bearing number or door number 76 of Baskare village of Basavapatna village, my lord. Thereafter, after service of the summons, my lord, the petitioner has filed the detailed written statement contending that, my lord, they are not in possession of that particular property, and they are position in property number. They have mentioned the written statement, my lord. Kindly see the written statement.
What is the decree, sir?
Decree, my lord, madam. The decree, in fact, of evidence, my lord.
Where is the decree?
Decree, my lord, annexure. Annexure C, the D, the judgment, page number 47. The suit of the plaintiff hereby decreed with cause. The defendant are hereby directed to deliver the vacant position of the suit number bearing number 76, my lord. You have filed the, my lord, you have filed the written statement. You have stated, specifically stated that you are not in the suit settled property. You are not in the position of suit property. Then, my lord, they have filed the execution, my lord.
Yes.
In the execution, my lord, earlier execution filed with the dispute for default. They have not restored this, my lord. The present execution is not maintainable, my lord. Thereafter, my lord, the IA number 12 has been filed. Page number 78, my lord, annexure L. Seeking appointment of the AAA of PW department, my lord, as a court commissioner to measure and identify the suit settled property. The specifically stated, my lord, earlier occasions, several times, Amin has went there. They not in able to identify the suit settled property. Their suit settled property is door number 76. Ours is 77/1 P1. He has reported, my lord. Then, my lord, they have filed the IA number 12, and they have stated the affidavit, my lord. Adal affidavit page number 70 ಅಲ್ಲಿ ಸದರಿ ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಆದೇಶದಂತೆ
ಎಲ್ಲಿ
annexure L, my lord. Annexure L, IA number 12, page number 78, my lord.
That is the application.
Application IA number 12, my lord. ಅದ್ರಲ್ಲಿ ಕೇಳ್ತಾರೆ ದ ಸಹಾಯಕ ಕಾರ್ಯನಿರ್ವಾಹಕರು ಸಹಾಯಕ ಕಾರ್ಪೊರೇಟ್ ಇಂಜಿನಿಯರ್ ಅವರ ಕಚೇರಿ ಲೋಪಾಯುಕ್ತರ ವಿಭಾಗ ಚನ್ನಗಿರಿ ಇವರನ್ನು ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಆಗಿ ಅಪಾಯಿಂಟ್ ಮಾಡಿ ಅಂತ ಕೇಳ್ತಾರೆ. Then, madam, their reason, my lord, their reason stated for appointment of the court commission, my lord. The para 4th, my lord, for the affidavit, their affidavit. ಸದರಿ ಘನ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ತೀರ್ಪು ಋಣಿಗಳು ದಾವಾ ಆಸ್ತಿಯ ಸ್ವಾಧೀನವನ್ನು ನಮಗೆ ಬಿಟ್ಟು ಕೊಡದೇ ಇದ್ದುದರಿಂದ ನಾವು ತೀರ್ಪು ಋಣಿಗಳ ವಿರುದ್ಧ ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಡಿಕ್ರಿಯ ಆಧಾರದ ಮೇಲೆ ಅಮಲ್ಜಾರಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು ಸರಿಯಷ್ಟೇ. ಆ ನಂತರದಲ್ಲಿ ಸದರಿ ಅರ್ಜಿದಾರ ಅರ್ಜಿಯು ದಾವಣಗೆರೆಯಿಂದ ಚನ್ನಗಿರಿ ಮಾನ್ಯ ಘನ ನ್ಯಾಯಾಲಯಕ್ಕೆ ವರ್ಗಾವಣೆಗೊಂಡಿದ್ದು, ಆ ನಂತರದಲ್ಲಿ ನಾವುಗಳು ಸಾಕಷ್ಟು ಬಾರಿ ಸದರಿ ಸ್ವತ್ತಿನ ಸ್ವಾಧೀನವನ್ನು ಕೋರಿ ಹಲವಾರು ಬಾರಿ ಜಾರಿ ಕೇಳಿಕೊಂಡಿದ್ರು ಸಹ ಸದರಿ ಸಡಲ್ ಆಸ್ತಿಗೆ ಸಂಬಂಧಿಸಿದ ಚಕ್ಕುಬಂದಿಗಳು ಬದಲಾಗುತ್ತಾ ಬಂದುದರಿಂದ ಹಾಗೂ ತೀರ್ಪು ಋಣಿಗಳು ವಿನಾಕಾರಣ ಜಗಳ ಮತ್ತು ಗಲಾಟೆ ಮಾಡುತ್ತಾ ಬಂದಿರುವುದರಿಂದ ಸದರಿ ಸೆಡಲ್ ಸ್ವತ್ತಿನ ಸ್ವಾಧೀನವನ್ನು ಈ ತನಕ ಸಹ ನಾವು ಪಡೆದುಕೊಳ್ಳಲು ಆಗೋದಿಲ್ಲ. ಆದರೆ ಈ ನಂತರದಲ್ಲಿ ಸದರಿ ಸ್ವೆಟ್ಟು ಆಸ್ತಿ ಸಂಖ್ಯೆ 76ಕ್ಕೆ ಸಂಬಂಧಿಸದೆ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಅಮಲ್ಜಾರಿ ಸದರಿ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯ ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿನ ಸಂಬಂಧಿಸಿದಂತೆ ವಿಚಾರಿಸಿದಾಗ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿಯನ್ನು ಗುರುತಿಸಲು ಸಾಧ್ಯವಿಲ್ಲವೆಂದು ಹೇಳಿ ಪ್ರತಿ ಬಾರಿಯೂ ಚಕ್ಕುಬಂದಿ ಸರಿ ಇರುವುದಿಲ್ಲ ಎಂದು ವರದಿ ಸಲ್ಲಿಸಿದ ಮೇರೆಗೆ ನಾವುಗಳು ಹೊಸಕೆರೆ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರವನ್ನು ಸದರಿ ಸ್ವತ್ತಿನ ಆಸ್ತಿಯನ್ನು ಗುರುತಿಸಿ ಕೊಡಲು ಸಹಾಯ ಮಾಡುವಂತೆ ಕೋರಿದ್ದಿರುವ ಮೇರೆಗೆ ನ್ಯಾಯಾಲಯವು ಸಹ ಸದರಿ ಹೊಸಕೆರೆ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯ ಅಧಿಕಾರಿಗಳನ್ನು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಅಮಲ್ಜಾರಿ ವಾರಂಟ್ ಅನ್ನು ತೋರಿಸಿರುವಂತೆ ಅಮಲ್ಜಾರಿ ಮಾಡುವ ಸಮಯದಲ್ಲಿ ಹಾಜರಿದ್ದು ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿನ ತೋರಿಸಿ ಕೊಡುವಂತೆ ತಿಳಿಸಿದರ ಮೇರೆಗೆ ಸದರಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳು ಸಹ ಸದರಿ ಆಸ್ತಿಯ ನಂಬರ್ 76 ಗುರುತಿಸಿ ತೋರಿಸಿಕೊಡುವಂತೆ ನಿರ್ದೇಶಿಸಿದರ ಮೇರೆಗೆ ಸದರಿ PDO ಅವರು ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿನ ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ಪಂಚಾಯತಿ ದಾಖಲೆಗಳನ್ನು ಆಸ್ತಿಗಳನ್ನು ಸಂಬಂಧಿಸಿದಂತೆ ಚಕ್ಕುಬಂದಿ ನಮೂದು ಇಲ್ಲದ ಕಾರಣ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯನ್ನು ನಿಖರವಾಗಿ ಗುರುತಿಸಲು ಸಾಧ್ಯವಿಲ್ಲವೆಂದು ಹೇಳಿದರ ಮೇರೆಗೆ ನ್ಯಾಯಾಲಯವು ಸದರಿ PDO ಅವರನ್ನು ಕರೆಯಿಸಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಮಾಡ್ತಾರೆ ಮೇಲೆ. Yeah, my lord, the PW has been AEE of the PWD has been appointed as a court commissioner by allowing the IA number 12, my lord. In the IA number, my lord, annexure M, my lord. The SK advocate for DHR filed IA number 12 under section so and so to appoint the AEE PW Changiri as a court commissioner, measure on petitions of the property and fix the boundaries by submitting the report, my lord. He, my lord, thereafter he went. He submitted a report, my lord. The annexure A, my lord. It is in handwriting and typed copy is the annexure. The next page, my lord, page number 86. Changiri Hiria Civil Nayalada Asalu Dava execution number 17/16. OS number 353/2000 ಅಳತೆ ಮಾಡೋ ಬಗ್ಗೆ ಮೇಲ್ಕಂಡ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖದ ಚನ್ನಗಿರಿ ತಾಲೂಕು ಬಸವಪಟ್ಟಣ.
Oh, you are aggrieved of which order?
Aggrieved annexure 30, my lord.
Yes.
No, my lord, he has submitted report. There is no settled properties there, my lord. 1 second they filed the IA number 13, my lord. Appointing EO, my lord, executive officer of Taluk Panchayat.
Yes.
This report, madam, submitted along with the help of the PDO. He themselves stated that there is no such property. 1 second, my lord, they filed. Contrary to it is also restricted, my lord. Annexure A12 and A13 is one and the same. And thereafter, my lord, he submitted the report, AEE, annexure O kind missing.
They have to identify. Once there is a decree, they have to identify.
There is no such property. There is no such property.
You will have to file an appeal, sir. You can't contest like this in the execution petition.
No, we specifically contended in the written statement that, my lord.
To the respondent.
One more submission, madam. Earlier they filed the execution petition, my lord. They have transferred to Chennai court and dismissed. And they provision of the rule 20,
Yes, yes.
21 rule 16, my lord.
Yes.
There are kindly see, my lord.
Next matter, please.
Provision shall be kindly see, my lord. Provision. Order 21 rule
There is an
105.
appointment of a court commissioner. Let them do their duty. Let us see afterwards. Yes.
Notice may be issued, my lord.
Notice, yes.
Manivanan ji.
My lords, like to represent the petitioner, my lord.
Yes.
Plaintiff's writ petition, suit for declaration, filed an application for amendment, came to be dismissed. An application for amendment seeking an alternative relief for partition and for separate possession. The suit is one for declaration on the ground that there was an oral partition in which
Yes, it changes the very nature of the suit.
No, it doesn't change the nature of the. It doesn't change the nature of the suit as held by this honorable court as well as in the appellate court. In fact, on the last occasion when I made my submission, your lordship was pleased to direct any decision which could show that a suit for declaration could be converted into a suit for relief of partition. Firstly, my humble submission to your lordship is that, first of all, I'm not asking for substitution of the relief, my lords. I'm not asking for a relief that to delete the relief of declaration and seek for partition. My only relief in the amendment application is that insofar as if the court comes to the conclusion that there is no earlier partition, then I am asking for a relief of the court, their lordships, my lords, at para 12, my lords.
May I just please, my lords?
Yes.
May I ask my colleague?
Para 12, middle of the page.
Hmm.
The bottom of the 12th line from the bottom.
Hmm.
The trial court held that if amendment application is allowed, the very nature of the suit will be changed. Therefore, the application cannot be allowed. The trial court failed to notice that it was a specific case of the original plaintiff that the suit schedule property is her self-acquired property. It is the case of the defendant son that out of the joint family nucleus, the property was purchased in the name of the plaintiff and it is not exclusive property of the plaintiff. After the death of the plaintiff, except plaintiffs and defendant, there are no other legal representatives. When the defense in the return statement is that out of the joint family nucleus, the property was purchased in the name of the plaintiff, it clearly indicates that suit schedule property becomes the joint family property of the plaintiffs and defendant. The application for amendment can be allowed at any stage unless prejudice is caused to the other side. When the original plaintiff claims that the suit schedule property was her self-acquired property and the same was disputed by the defendant claiming that the property is in joint family property, prejudice here allowing the amendment application in a suit for partition will not prejudice the case of the defendant, since it is the case of defendant in the return statement that it is a joint family property purchased in the name of plaintiff by his father out of the joint family nucleus.
Here also, in this case also, if your lordship may kindly take up annexure E, written statement filed by the respondent number 1 defendant, my lords. Para 2 and para 3, my lords, wherein his contention is that this property, the suit property and other properties belongs to the joint family and each of them has got a share. If your lordship would come to page 44, para 3, my lords. I'm sorry, 44 starts with the page and 45, my lords, para 3. There where he contends that the suit for declaration under the provisions of specific relief act is not maintainable when an alternative relief of partition is sought for. Now, my humble submission to your lordship is that I have only sought that in the event if the court were to come to the conclusion that there is no division, that is oral division, then I seek for relief for partition. No prejudice. He himself contends that there should be a relief sought for partition. The other side also contends that an alternative relief is available to me to seek for partition.
What about cause of action?
Cause of action would be consequent to the, in fact, in the very same decision, the Honorable Supreme Court has holds the same thing, my lords.
Supreme Court.
In the very same, the coordinate bench in the decision.
Judgment of our court.
Yes.
Cause of action also would not change because it would be consequent to that relief.
What is the cause of action for a partition suit?
Partition suit, if the court comes to the conclusion that.
What is the cause of action for filing a partition suit?
Demand for partition and there is no
your demand.
Goes from the same cause of action.
Where is your demand?
That is my submission, my lords. What I made my submission is, I am not saying that to delete the relief of declaration and I'm
to seek partition. What should be the cause of action?
Please, my lords, I do agree, my lords. If I am to seek for a fresh suit for a relief for partition, then my cause of action would be that there should be a demand for partition and there should be a refusal.
Yes.
But here in this case, that is why
you have sought for a declaration.
I have sought for
that you are the owner of the property.
I claim that I am the owner of the property.
You have never stated anywhere that you have sought for your share, separate share, and there is refusal.
No, my share is.
Where is the cause of action for filing a partition suit?
No cause. No, that is what my. In fact, if I am not troubling your lordship may kindly take up the same decision, my lord, where their lordships holds that relying upon the decision of Nilava's case.
Is also permitted to serve copies of the writ petition along with annexures on the learned counsels representing the respondent before the trial court. Release this matter on 25th of September.
My lord, matter is on 13th for further evidence, my lord. Till then, let
Madi, evidence bleed. What is there?
Yes. Document mark it will. Previous fact, my lord. Yesterday is what the execution is there. It is for urgent on the 18th, my lord. Hand summons may be ordered, my lord, on 16, my lord.
No.
Because, my lord, Otherwise, my lord,
I have directed you permitted you to serve a copy on the learned counsels. You
Allah,
please
date
serve.
will be given, my lord, otherwise I will not be posted.
No.
Date will be
Serial
given.
number
No, sir.
19.
18th is there, my lord, 18th exhibition yesterday was there.
Yes.
And 18th is there.
Serial number 19.
My lord, I have sought for a stay because matter is
I
for.
have given a date. Let it come, we'll see. Yes,
13th is the case, my lord. If may I request your lordship
I
to
have
have
given
it
a date, sir. 25th of September, please come. Yes.
Date could be from the other.
No, sir.
13th next.
Exhibitionally, there is no such.
Please don't make the submissions like this. Once your matter is over, you please keep away. Yes.
What is posted on the 18th, my lord, that is the.
Please call the next matter.
Serial number 19, Mama Tayyir.
Yes. ಇದು serial number 4 ಕೊಡಿ.
4 lots.
Yes.
Relying on judgment lordship. The Honorable Apex Court held that interim relief cannot be granted if it is like akin to final relief lordship.
ಏನಿದೆ, what is it?
Interim relief cannot be granted if it is akin to final relief lordship.
You are the defendant in the suit filed by the respondent.
Yes, lordship. Suit for eviction lordship. And they file application for the deposit of rents of entire areas of the rents lordship. So that relief was granted. That was the main relief. If they were sought for the deposit of rent, then I would not have the case. They sought for the deposit of the entire areas of the rent, which have piled up over the period of time.
To vacate and deliver vacant possession of the suit schedule property.
And
that is the main relief.
yes, Lord. And vacate, and there is also
Direct the
payment of,
defendants to pay.
pay the areas.
So and so, yes.
Now, Lord, you kindly take the application which they have filed it before the trial. Application on page number 31, Lord. Annexure D.
Yes.
For the reasons shown in the accompanied affidavit, it must respectively pray
For direction to deposit
arrears of the rent, 1,67,000. So it is also one of the main rent. If they sought for the payment of rent, deposit of payment of regular payment of rent, I would not have a case at all. Because I would not have a case to agitate before this honorable court, the questioning the interim relief of deposit of rent. They sought for the deposit of entire areas of rent. Here we are disputing the relationship, and from the 91 onwards, we are in the property, and property originally belongs to my family. I am in the property, and I never given handed over the position to the.
What is it that you have brought now?
Now, Lordship, the judgment is the 2024, Honorable Apex Court held that page number. Next page, Lordship. It's part from second para. An order of interim relief may or may not be reason one. Second para, Lordship. Second para of the second page, Lordship. An order of interim relief. 2004, Lordship. 4 SCC 697.
But you have given me something else.
Devraj versus Sorry. It's another judgment, Lordship. This 2022 judgment where Supreme Court held that rent has to be paid during the pendency of the petition, Lordship. 2024 4 SCC 697. Second page. Second page, second party name Devraj versus State of Maharashtra. An order of interim relief may or may not be reason one, but the factor of prima facie case, irreparable injury and the balance of convenience do work at the back of the mind of the one who passes an order of interim nature.
No, I didn't get. Where are you reading?
Second para, page of syllabus, second para. Allowing the appeal after that, held. Second page, Lordship. Page number 63. Page number 2. Second para, Lordship. An order of interim relief. May or may not be reason one, but the factor of prima facie case, the irreparable injury and balance of convenience do work at the back of the mind of the one who passes the order of interim nature. Ordinarily, the court is inclined to maintain status quo as obtained on the date of the commencement of the proceeding. However, there is a few cases which call the court for leaning not in the favor of maintaining the status quo until lesser in percentage are the cases are when an order of tantamount to the mandamus is required to be issued when an interim stage. There is a matter of significance and of a movements posing themselves as a moment of truth. Such case do cause dilemma and put the wits of any judge to test. Situation emerges when the granting of interim relief would tantamount to the granting of final relief itself. And then there may be a converse cases when without withholding of any interim relief would tantamount to the dismissal of main petition itself.
This is not applicable, sir. This is not the judgments that are applicable to you. You should have found out whether the provision under which the application is filed can be entertained to such an extent that if you don't comply with that one, you are
File under 151 lordship.
yes.
There is no provision for
Then
people.
ಬೇರೆ judgment ಗಳು ಸಿಕ್ಲಿಲ್ವಾ?
I may request for one more day, lordship. I'll just assist.
How do you prepare the writ petitions or the pleadings?
Prepare this because there was a very limited scope for this particular petition or for that way.
At the request of learned counsel for the petitioner, release this matter on 11th of September for preliminary hearing. Yes. Yes, what about this 19? Same thing, huh?
No, not this different petition.
Yes.
Here the petitioner is a judge and debtor lordship, and the suit was decreed against him, and it was decreed on the ground by setting aside his defense. So we filed the appeal that we have not succeeded in appeal, but we have handed over the positions lordship. And there is a main dispute of the arrears of the rent. During the pendency of the suit.
Execution proceedings.
Execution proceedings. During the proceeding of the suit, we paid around 12.5 lakh rupees. Our contention is that.
So suit was filed for?
Suit was filed for eviction and arrears of the rent lordship. And our suit was dismissed against us, decreed against us by striking out our defense. Striking out our defense. During the pendency of the petition, the original suit, they have filed the application for the arrears of rent. The court has adjudicated in their favor, and court has granted it limit certain times to pay the arrears. We could not comply that. We could not meet that date, and our defense was struck down on that ground. No, our defense was not considered that. But the amount which they have pleaded in the petition, even they filed it in a memo, and more than that amount was ordered. Amount was ordered. Though we have agitated in appeal also, we will not succeed. Appeal also will dismiss against us. Execution was filed. We have already handed over the possession to them. So there is no dispute of possession. We already possession is handed over. We filed a section 47 application to calculate the arrears of rent in a fresh. That application was not taken on record. Though objection is filed by the other side. Application was not taken on record. The court has said that we will already consent with the decree. We will not consent with any other issue. So that in respect of that, no order was passed. Then subsequently, what has happened? The matter was posted for Lok Adalat. During Lok Adalat, there is some discussion happened between the parties for the payment, settling the amount one shot payment. But finally, it was not finalized. The next date of hearing, court has insisted to comply with the discussion what is happening, transpired in the Lok Adalat. At one stage, first at the outset, the one who was appearing on that day, he was a junior colleague of the main counsel. He resisted it, but court insisted that you file a memo. He filed a memo that we pay the 2 lakh rupees, which was discussed in Lok Adalat. If he filed a memo, court has passed the order they need to pay. Very next day, when he realized that any discussion in the Lok Adalat will not be binding on the party until it is not finalized. So we filed the same counsel with the affidavit filed a recall application. That recall application was dismissed, Lordship. Lordship can find the recall application and memo on page number 49, Lordship. Page number 49, this is the recall application filed by the junior counsel.
19/7/2024.
Yes, sir. 19/7/2024.
19/7/2024. Where is that order?
The order is on
page number 18.
Yes, sir. 18, Lordship. Page number 18, Lordship. The Council of JDR, the Council of JDR filed a memo stating that JDR ready to pay amount rupees 2.5 lakh along with the key and suitable property. So within 10 days. This is small amount and also hand over the key of the premises not required 10 days. Hence JDR is directed to hand over the key and also rent the 2,50,000 rupees. The case in the next date, Lordship. The case advanced today, filed application in section 150 of CPC to recall the dated 94 in the para number 4 affidavit, the ground of the recall of the order. Any negotiation with the party is not binding the court and it is not enforceable under the law. The court can enforce only decree passed by this court, not for the oral transaction between the parties. Hence, the application filed with the JDR is dismissed. By making this observation, this application was dismissed, Lordship. Lordship can file this application in annexure D. No. Annexure E, Lordship, page number 49. This is the application which is filed on that day to recall the order dated 19/7/2024. Para number 3, page number 50, Lordship, in our complaint affidavit. I state that on the last date of hearing, JDI informed to my senior that he is ready to, it's affidavit.
What is the decree passed against you? For what
The
amount?
eviction and the arrears.
What amount?
Amount was 6 lakh rupees, Lordship. 6,12,000 rupees. It is there on operating patient page number 38.
So after the judgment and decree was passed,
Yes, Lordship.
have you made any payment?
No, we have not made payment.
Ah.
We have not made a payment. And according to us, only 1 lakh rupees was pending on that, as on that day.
Ah.
Only 1 lakh rupees was pending. Then we filed a section 47 application. That application was not taken on record, but objection was filed by the other side.
Contention was raised even before the appellate court.
Appellate court was raised, Lordship.
It was rejected.
It was rejected.
How can you contend like this
Section
before the
47, Lordship.
executing court?
But section 47, this contention of disputed amount.
And despite that, what has been agreed to be paid is only 2,50,000.
2,50,000.
Then you don't want to pay that also.
But the 1 lakh was pending. According to this, 1 lakh is pending.
Sir, that argument was rejected before the appellate court. What is the use of contending like that before the executing court?
The appeal was set aside, was dismissed on the ground that being a tenant,
To the respondent. The petitioners are also permitted to serve copies of the petition along with annexures on the learned counsel representing the respondent before the trial court. Yes.
Say number 20, HR Ananta Krishnamurthy.
Time permission on this matter, defendant number 6 and 7. Today's matter is listed before the trial court. My learned friend has been informed. I'll take notice on 6 and 7.
I'll furnish copies.
Learned counsel Shri
Akki
Manjunath Gowda undertakes to appear for
6 and 7.
Response number 6 and 7.
I'm the contesting defendant before the trial court.
New matrana?
Now, nane application file made before the trial court. On the basis of application today, sub-registrar also lead the evidence.
Learned counsel further submits that defendants number 6 and 7
Yes,
are the only contesting respondents before this court.
Yes, ma'am. It's not other, and defendant number 11 also is contesting. Nah,
ಇಲ್ಲ ಬಿಡಿ ಅದು ತೆಗ್ದಾಕ್ಬಿಡಿ ಆ ಸೆಕೆಂಡ್ ಸೆಂಟೆನ್ಸ್ ತೆಗ್ದ್ಬಿಡಿ learned counsel submits that the matter has been listed before the trial court today.
Today, ma'am.
The learned counsel would therefore seek for a short accommodation to secure instructions and make submissions.
Yes.
Release this matter for preliminary hearing on 11th of September.
I'll furnish copies.
Learned counsel for the petitioner is requested to serve a copy of the petition along with annexures on the learned counsel. Yes.
21, Abhinav Ramanande.
Respondents in this case today,
Huh?
on this matter is paid, along with other 3 matters.
There are 2 other
connected.
matters. All the matters could be taken up together.
Yavudu?
WP number 23099 of 2024, 23385 of 2024.
These matters have already come up for preliminary.
No, has not come up. This has also come up for the first time.
Learned counsel Shri
GVP Das,
GVP Das undertakes to appear for,
filed wakalat for respondents.
submits that he has filed wakalat for
Respondents, all respondents.
all the respondents.
Only 3 respondents are there.
for all the respondents. Next para. Office is directed to show the name of the learned counsel in the cause list. Full stop. List this matter along with WP number Barkondra on 11th of September
Grateful.
for preliminary hearing.
Preliminary.
Yes.
Shortlist. Shankar HS. Shankar HS.
Correct.
List number 2. Serial number 1. Muzaffar Ahmad.
Counsel for the petitioner, my lord, requesting the court to grant 1 week of time.
The execution case in 1188 of 2015 was settled before the Lok Adalat on 16/8/2023. Disposed of.
2. Sachin BS.
Hearing for petitioner, my lords.
Hmm.
Petition has been disposed of. It has become infructuous.
A regular appeal.
Yes, my
Regular
lords.
appeal. Huh?
It has
Regular
been dis-
appeal.
Yes, my lords.
6 of 2017.
Yes, my lords. It has been
It was
disposed
dismissed on 26/8/2023.
Yes, my lords.
Yes, disposed of.
Serial number 3 order passed. Serial number 4. Manu Shankar SS.
Execution case 175 of 2021 was settled before the Lok Adalat on 19/7/2024. Disposed of.
5. G. Balakrishna Shastri, withdrawal.
Learned counsel for respond number 2 has filed a memo dated 16/11/2022. Stating that OS number 112 of 2021, from which the presented petition arises, was dismissed as withdrawn by order date 13/10/2022. And therefore, the prayer made in the petition has become infructuous. Disposed of.
6. Rupesha B.
That suit itself came to be decreed on 12/3/2024.
Learned counsel for the petitioner submits OS 568 of 2021 was decreed on 12/3/2024. Disposed of.
Serial number 7. Virupakshaya PH.
Round ಮಾಡಿದ ಇವಾಗಲೇ Learned counsel for the petitioner submits ಅಂತಾನೆ ಹಾಕೊಳ್ಳಿ. Execution case 839 of 2020 was closed on 6/3/2023.
Serial number 8. Serial number 8 order pass. Serial number 9 order pass. Serial number 10. Manjunatha P.
8.
Serial number 8.
ಇದಕ್ಕೆ ಅವ್ರು ಬಂದಿತ್ತು. OS 9601 of 2014 was dismissed on 7/8/2024.
Nine order pass, serial number 10, Manjunath P. Connected matter along with.
OS 105 of 2017 was decreed on 2/2/2023. Disposed of. Both the writ petitions ನೋಡ್ಕೊಳ್ಳಿ.
11, Prasad BS.
OS 8 of 2018 was dismissed on 19/4/2023.
Serial number 12, Prince Isaac.
I am for the petitioner, Lordship. Lordship, I am seeking a week's time may be granted for.
My lord, one submission, my lord. The suit disposed on 134 OS 134 of 2015 on 10th August 2023.
Yes. Submission made by learned counsel for respondent.
Responding.
Disposed of. Yes.
13 order pass, serial number 14, Prakash Reddy.
Execution case 3 of 2019. Was dismissed on 22/7/2024.
Serial number 15, B Ramesh.
OS 1257 of 2014. Was dismissed on 9/2/2023.
Shortlist. Serial number 1, Shankar HS.
Lords, in relation to the Karnataka Rajya Vakaligiri Sangha.
Have you paid the court fee?
Yes, minutes. Court fees is paid.
When?
It's paid, minutes. May just. It's paid. Paid.
Yes.
Lords, Karnataka Rajya Vakaligiri Sangha will have 34 directors. Lords, amongst the directors, office bearers will be elected. Then bylaw number 17 provides the procedure, 16 provides the procedure for the purpose of expressing no confidence against the existing office bearers. Lords, a motion was made expressing the no confidence by the requisite numbers on 18/7/2024. Lords, then the president says, no, I will not call the meeting. It's mandatory under the bylaw that he should call for the meeting. Bylaw also addresses it. If he doesn't call for the meeting, then the executive committee members who had expressed the no confidence, the requisite number, they themselves can call for the meeting. Notice what happens on 30/8/2024, they call for the meeting. issue notices to all the 34 directors, convening the meeting on 2/9/2024. Now, what these office bearers do is, on 31/8/2024, my meeting notice is dated 38. On 31/8/2024, they generate an order saying that one amongst the persons who has expressed no confidence was involved in certain things. Therefore, we are suspending him from membership. So the numbers will not be there. So this is an order which he wanted to pass, and this was communicated to us on 2/9. 31/8, they put it on post, 2/9, I received it. Then I filed a suit. Notice in the suit, the secretary in his personal capacity had filed the caveat. If your lordships were to see, I have produced the caveat petition
You
here.
filed suit for what?
Suit for a declaration that the suspension is non-existent, it is void. Because there is no power of suspension under the scheme of the bylaws.
Where is that plaint?
Lord's plaint, your lordships will find at
Annexure L.
Annexure L, page 56. The prayer is at page 62. But now,
This is a society
this is a society.
registered under
The Societies Registration Act 1960.
Society Registration Act.
So therefore, we went to the civil court. Now, once we said, if your lordships were to see the cost title, my lords, who has filed the respondents is the Rajya Ukaligri Sangha by its secretary. But the caveat is not filed by the secretary. If your lordships were to see the caveat at page numbers, no. Caveat is at page number 72. Lordships may kindly see page 72.
General Secretary.
Yes. Then page 75, this is a caveat filed on 31/8. Now we filed the suit and brought to the notice of the court that I should not be prevented from participating in the executive committee meeting, which is scheduled on 9/9/2024. Therefore, we requested for an order. We made the same submissions before the court. Lordships may kindly take Annexure A, page 23. This is the order. Even then, we have served it on him. We informed him, he doesn't come. OS number so-and-so, learned counsel for plaintiff present, files a memo acknowledgement, caveat number so-and-so is pending. Heard learned counsel for plaintiff on IN number 1, peruse documents. Learned counsel for plaintiff submits that caveat is not the defendant in this case, and in spite he has served the copy on the advocate caveator. Notice dated so-and-so is the subject matter of the caveat. Though the caveat is different, in view of the subject matter, interim orders cannot be passed. Learned counsel for plaintiff requests for issuance of hand summons without filing necessary application for substituted service. Hence, this prayer is rejected. Issue emergent notice post on 12/9. My suit itself will be rendered infructuous by 12/9. The relief which I had sought for minutes is at page number 64.
There is no other alternative remedy for you.
There is no alternative remedy. Lords, that suit is the only remedy, my lord, so far as a member. Now, your lords may kindly take the bylaws. At page number 29, bylaw number 6. Lords, this entire exercise is to circumvent the possible no confidence motion. Bylaw number 6, bottom of the page. Second one, bylaw number 6.2. ಯಾವ ಸದಸ್ಯರಾದರೂ ಈ ಸಂಸ್ಥೆಯ ಉದ್ದೇಶಗಳಿಗೆ ಭಂಗ ತರುವಂತೆ ಕಾರ್ಯಗಳಲ್ಲಿ ಆಸಕ್ತರಾಗುವಂತೆ ಕಂಡು ಬಂದಲ್ಲಿ ಅಂತಹವರನ್ನು ಸದಸ್ಯತ್ವದಿಂದ ತೆಗೆದುಹಾಕುವ ಹಕ್ಕನ್ನು ಕಾರ್ಯಕಾರಿ ಸಮಿತಿಗೆ ಇರತಕ್ಕದ್ದು. ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ಕೈಗೊಳ್ಳುವ ಈ ಬಗೆಯ ತೀರ್ಮಾನವು ಸರ್ವ ಸದಸ್ಯರ ಸಭೆಯ ಒಪ್ಪಿಗೆ ಪಡೆದು ಮಾತ್ರ ಊರ್ಜಿತವಾಗತಕ್ಕದ್ದು. Notice the powers to suspend may be read because there are contravening judgments which says that sometimes it can be read, but sometimes it cannot be read. More particularly in the nature of memberships and all, it cannot be read. Even then, the power of dismissal is only in the general body. Decision has to be approved by the general body, then it comes into force. Here, there is no general body which is coming to existence. Only it is alleged. Not further, what happens is, they say that
Is
the,
that what you read out just now?
not bylaw number 62,
Page?
page 29. Bottom of the page, Vinod.
This is for removal of.
Removal. Suspension power illa.
Power illa.
Ilve illa. Now, what further, Milords, I wanted to reiterate is that they are referring to the proceedings dated 8/8/2024. That in those proceedings, we have caused an order of suspension. Entry now participate ಮಾಡಿದ್ದು ಇವೆಲ್ಲ ಏನು ಚರ್ಚೆ ತಗೊಂಡಿರಲಿಲ್ಲ. Kindly have a look at annexure E page 40. I'm sorry, Milords. Annexure, yes. Annexure G page 47. These are the agendas. On 8/8/2024, suspension is not the agenda. But suspension of membership is one thing, but suspension in a manner that a person elected director is not permitted to discharge his duties is another thing. And the present facts which is now presented before your lordships will clearly indicate the only attempt is to ensure that the numbers are meddled with. It's a mala fide exercise. But the trial court, Milords, is not abreast of this and
Ninth.
ninth.
Issue notice to the respondent. Ali innu they have not entered appearance.
No, Milords, caveat, we have served it on that caveat or whoever has served.
The petitioner is also permitted to serve a copy of the petition along with annexures on the learned counsel representing the respondent before the trial court. Please, next para. Learned senior counsel Shri D.R. Ravi Shankar appearing for the petitioner submits. That the executive committee nadu ಏನದು
Executive committee.
executive committee that ಏನದು majority na what is the requirement?
That's majority. Under clause 16A, clause 7(3), I just point out later. Clause 7(3). 7(3) tana? Seventeen or 16 or 16. 16(3). 16(3) at page number 33 and
submit that the requisite number of members of the executive committee of the respondent society in issued notice.
Issued notice.
Issued notice for
expressing no confidence against the existing office bearers.
expressing no confidence motion against the
Existing office bearers
existing office bearers
on 18/7/24.
on 18/7/2024.
The secretary refused to call for the meeting on 22/7/24.
The secretary of the Sangha refused to call for meeting to consider the no confidence motion. However, in terms of
Bylaw number 60.
bylaw 16(3),
Please.
since it is permissible for the members of the executive committee who have issued notice calling for no confidence motion to call for meeting also, if the secretary does not call for meeting, steps were taken to call for meeting of the executive committee on
By a notice dated 38/2024. 38/24.
38/2024, indicating the date for the meeting as
9/9/24.
9/9/2024. Full stop. However, clandestinely, action was sought to be taken against the petitioner by suspending him on the ground that a decision was taken. Where is that?
Lord's order is at page 38, at page 39. ಎಂಟು 24 ನಡೆದ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ಸಭೆಯ ನಿರ್ಣಯದಂತೆ
On the ground that in a meeting of the managing committee held on 8/8/2024, decision is taken to suspend the petitioner from the membership of the society, and further to take action to remove the petitioner from the society. Full stop. Learned Senior Counsel submits that the action of suspending is directed towards the meeting that is to be convened on 9/9/2024 to consider the motion of no confidence. Full stop. The petitioner filed a suit in OS number 25865 of 2024. Seeking a declaration that the said order dated 29/8/2024 suspending the petitioner from the membership of the respondent Sangha is null and void. Full stop. An interlocutory application was also filed by the petitioner along with the plaint. Under Order 39, Rule 1 and 2. Seeking an ad interim order of temporary injunction restraining the defendant Sangha from interfering into the participation of the plaintiff, including exercising his voting rights in the executive committee meeting. Full stop. However, the trial court has only directed notice in spite of the fact that copy of the plaint was served on the caveator defendant. Full stop. Next para, learned senior counsel submits that in the agenda of the meeting,
Page 47.
meeting notice issued on 31/7/2024. In respect of the meeting to be, which was to be held on 8/8/2024, no such subject is found to take action against the petitioner. Full stop. The learned senior counsel would therefore submit that the action of the respondent Sangha, more particularly the members of the managing committee,
The existing office bearers.
the existing office bearers, is directed towards the action sought to be taken by the majority of the executive committee members seeking no confidence against the existing members,
Existing office bearers.
office bearers. Full stop. Even otherwise, no prejudice will be caused to the respondents if the petitioner is permitted to take part in the meeting scheduled to be held on 9/9/2024. Full stop. Next para. Consequently, there shall be an interim order directing the respondent Sangha to permit the petitioner to participate in the meeting to be held on 9/9/2024 for considering the no confidence motion against the
Existing office bearers.
existing office bearers.
Participate and vote, your lordships may observe this. Participate and vote.
Participate and vote.
Please,
Yes.
may I request for a hand delivery, my lords?
Yes.
Please, great.
List number 1. For orders. Hero number 22, PD Surana.
Matters called out. There is no representation for either of the parties. Full stop. Even on the previous occasion, there was no representation for the petitioner. Full stop. release this matter on 11th of September. Full stop. If there is no representation for the petitioners on the next date of hearing, the writ petition will be dismissed.
Serial number 23.
I appear for the petitioner.
For a respondent.
Filed the amended cost title minutes today in the registry. If your lordship sir to permit minutes, I'll carry out the amendment minutes in the original copy. Minutes insofar as A number 4 of 23 is concerned, minutes that.
You know, non-taking of draft paper publication.
Minutes, an application was made minutes for substituted service by way of paper publication minutes in respect of respondent number 8 to 12. Minutes, when we went to collect the draft minutes, we were informed that respondent number 8 minutes had already entered appearance. I checked with the petitioners minutes, they informed that the other respondents minutes were also served. And respondent number, counsel representing respondent number 12 before the trial court minutes had intimated that he would file his power. For that reason, minutes, it could not be taken. Now, minutes, the respondent number 8 to 12 minutes have not resisted minutes the application that was filed minutes by the petitioner before the trial court. Minutes, your lordship may kindly permit me to minutes dispense notice as against respondent number 8 to 12. 9 to 12 minutes, 8 has entered appearance, 9 to 12.
You filed an impleading application.
Impleading application minutes is rejected.
Who resisted your application?
Plaintiff resisted minutes. Plaintiff minute now he is before
Only
your lordship.
plaintiff.
Only plaintiff.
In the lower court, that order one rule, under order one rule, 10 application has been filed by the defendant number 12. Sorry, defendant number 13 as an impleading application, and is got on the merits only the application has got rejected, my lord. Based on that, they have filed an appeal, but even though if the honorable court is directed for a lower court to consider the same application, okay, let them.
Defendant number 13 filed the application.
No minutes, they were to be added as defendant number 13.
Even though if the application is allowed, okay, the matter can be contested in the lower court only, because already the remaining respondent, already they sold the property in favor of third party. And we cannot seek the any injunction order also in the lower court. my lord.
Minutes, suit for
It's a suit
declaration.
for
and
declaration.
Declaration. Minutes,
Declaration. I am the plaintiff over there and I only filed.
Minutes, the only grievance minutes of the impleading applicants is that minutes, the suit schedule property minutes boundary on the southern side of the suit schedule property minutes is not correctly shown. Minutes, the boundary minutes on the boundary on the southern side of the suit schedule property minutes is shown as Gram Tana land. Now, there is a Gram Tana road minutes between the land of the impleading applicants and that of the plaintiff. Now, instead of showing the southern boundary as Gram Tana road, minutes, she has shown it as Gram Tana land. Minutes, if that boundary is considered, minutes, my land also minutes would come within the suit schedule property.
No. Your land will become the boundary. Your land will become the boundary.
Beyond
but, it should have been, the boundary should have been road.
Yes, minutes. Yes. In fact, minutes, the plaintiffs are claiming minutes under the partition deed. In the partition deed also minutes on the southern side, the boundary is shown as Gram Tana road.
Resisting the application then.
No, we filed a normal objection and we heard the matter, and finally the honorable lower court has considered that the proposed defendant has not having any interest over the social property and they are utter strangers. So that is the reason the
impugned order.
The A8 got rejected.
62 minutes is the reasoning of the learned trial judge minutes, 62, page number 62.
Even the lower court also given the liberty to to file a fresh suit for the defendant number 30, to file a fresh suit for.
Where is your application?
That's page 52 minutes is the affidavit minutes supporting the application.
ಏನಂತ ಹೇಳಿದೀರಾ ನೀವು?
Minutes, para number 6 onwards minutes I have explained. I submit that in the alleged partition deed, the plaintiff was claiming to be executed between himself and his brother, and that land in survey number 1/2 is the suit property had fallen to the share of the plaintiff. The boundary towards the land in survey number 1/2 is shown as road. I submit that plaintiff is now claiming 2 tamarind trees along with area of land and around the tamarind trees as his own, and the boundary shown in the suit schedule property towards the southern side encompasses bit of land comprising the tamarind trees as well. The southern boundary of the suit schedule property, it should have been road and not land. I submit that not only my property, even Kaneshwari number 55, which was earlier survey number 12/1, also included in the southern boundary of the suit property. My grievance is that, minutes. Now, encompassing minutes bit of land which belongs to me, the suit schedule property is shown. Now, the trial court holds that, minutes, that any judgment that would be passed in the suit, minutes, will not bind me. Now, assuming that, minutes, the suit is decreed. Now, tomorrow, minutes, on the basis of this, if any execution were to be filed, minutes, at that point of time, minutes, again I'll have to file an abstract or application. Inquiry will have to be held. To avoid all that, minutes, if this application minutes is allowed, minutes, I will be able to demonstrate before the court, minutes, that the boundary is only till Gramtana Road. Just before institution of the suit, minutes, the 11th defendant, minutes, has alienated the property, minutes, in favor of 12th defendant. The sale deed also, minutes, shows Gramtana Road, minutes, on the southern side. All the documents, minutes, show that on the southern side there is a Gramtana Road.
Even the 12th defendant also sold the property in favor of that person's mail. Now we cannot implead for an subsequent purchaser also due to the stay proceedings.
Two acres, 27 guntas.
Yes, madam.
The total entire scheduled property, my lord. Out of 2 acres, 27 guntas, the proposed defendant number 12 means the present petitioner is seeking 5 guntas. Out of 5 guntas, only 2 guntas of land which is comes to road. That's what is contention.
Anyway, you have also not filed a case against him.
No, my lord.
Recognizing the fact that his property is on the southern side. But his only grievance is that since there is a road between his property and your property, you should have shown it as road on the southern side.
No, it is not a
road anta torsidre avaru tonde irliಲ್ಲ.
Adu road alla swami adu. That property is belongs to the in previous suit the plaintiff only. Al road ante yavadu illa. Even the survey sketch also it does not show that it is a road. That is adjacent land to plaintiff and defendant number 1213. And even the survey sketch or a village map, there is no road at all.
In which one are you saying there is a road shown?
Minutes,
in sale deed.
Sale deed, minutes, in addition to that, minutes, when the stay was granted, minutes, when interim order was granted, minutes, had also, minutes, in the partition deed itself, minutes, it's a road.
Absolute sale deed.
Yes, minutes. On the last page, minutes, there is a schedule. Minutes, 11th defendant, minutes, has sold the property in favor of defendant number 12. Suit schedule property, minutes, is already conveyed before suit could be instituted. On the southern side, minutes, road is shown. In fact, minutes, they claim that, minutes, there is a partition deed. In the partition deed also, minutes, on the southern side, Gramtana Road is shown. The copy of the minutes, partition deed, minutes, had pointed out from the partition deed, minutes, earlier when stay was granted. Today, minutes, I don't have that copy. If your lordship want to peruse that copy of the partition deed, minutes, your lordship may kindly call it on Monday.
Partition. Even though if our grievance for considering this application in the lower court, it can be direct to the lower court to consider the application. Let them contest in the lower court only.
In a time bound manner,
trial court, let them decide the matter.
So the application can be allowed.
Can be allowed, my lord.
ಬರ್ಕೊಳ್ಳಿ.
Because ಏನಾಗುತ್ತೆ ಇಲ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟೇ ಇರೋದ್ರಿಂದ ಇಟ್ಸ್ ಡ್ಯೂರಿಂಗ್ ದ ಆರ್ಗ್ಯುಮೆಂಟಲ್ ಸ್ಟೇಜ್ ದ ಗಾಟ್
He also doesn't want the matter to be stayed. The petitioners who had filed an impleading application to implead themselves in the suit filed at the hands of respondent number 1 herein, are aggrieved on the rejection of the application. Full stop. It is the contention of the petitioners that towards the southern boundary of the suitable property, there exists a road, and thereafter the petitioners have their property.
Yes.
Measuring 5 guntas.
Yes, my lord.
Full stop. However, in the schedule to the plaint, the southern boundary is shown as Gramtana land instead of showing it as Gramtana land and road.
No, it is not a road, my lord.
Gramtana
It's
road.
adjacent.
Kara.
Gramtana road, my lords.
See, the entire extent of 2 acres, 27 guntas on the southern side, there is a road.
Yes,
No.
my lords. Around the entire village, my lords, there is a road. It continues, my
So
lords.
southern side, entire portion is road.
Yes, yes.
ಏನಂತ ಹೇಳಿದೆ ನಾನು? As a road, as Gramtana road.
Yes, my lords.
Gram Panchayat road. Gram
Gram
Panchayat
yes.
road. Full stop. It is the apprehension of the petitioners that despite their contention and the rejection of their application, if eventually the suit is decreed, the plaintiff will seek to execute the decree against the petitioners also. Full stop. Next para. At this juncture, learned counsel for the for respondent number 1 plaintiff
Yes, my lord.
submits that this court may proceed to allow the application and permit the impleadment of the petitioners. Full stop. Next para. Accordingly, the writ petition is allowed. The impugned order dated 8/7/2022, passed on IA number 8 in OS number 265 of 2011 is hereby quashed and set aside. Full stop. The application in IA number 8 filed by the petitioners is allowed. The trial court may proceed while permitting the amendment in the cost title.
Yes.
And issuing directions consequent to the amendment and impleadment of the petitioners. Full stop. Ordered accordingly.
Notice to 9 to 12 make.
Huh?
Notice minutes to 9 to 12 minutes.
Starting ಅಲ್ಲಿ
ಅವ್ರು ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಬರ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ, ಹಾಗಾಗಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿಸ್ಬೋದು ಸ್ವಾಮಿ.
since the first respondent plaintiff is the only contesting respondent, having objected to the application filed by the petitioners, notice to the other respondents is dispensed with.
It's amended cost title is filed. So lots of permit minutes in the original file also, I'll carry out the amendment minutes. Plaintiff died. LR application minutes is allowed. I have already filed the amended cost title minutes. The original petition is to be amended. So lots of to permit now minutes, I'll amend it.
ಇಲ್ಲಿ ಸ್ವಾಮಿ, ಇಲ್ಲಿ
Rital ತೀರ್ಕೊಂಡ್ರು. LR application ಹಾಕಿ that is allowed minutes. He is representing the LRs.
There is no orders for carrying out the amendment.
There was an order minutes. It was.
Let's do it then.
If your lordship may kindly.
The learned counsel for petitioner is permitted to amend the cost title. in terms of order dated 25/7/2024. Yes. Obliged.
24, Rajana, JD.
Preparing for petitioner lordship.
Yes.
Respondent number 2 on died on 8/10/2021 lordship.
You have not filed any application.
I know about lordship, but in trial court records, their party is there, same has to be.
ಏನಮ್ಮ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಪಾರ್ಟಿ ಆಗಿದ್ರು ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಇಲ್ಲೂ ಪಾರ್ಟಿ ಮಾಡಿದ್ವಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2, ಶಿ ಈಸ್ ಎ ಮದರ್ ಆಫ್ ದ ಪಿಟಿಷನರ್, ಸೊ ದಟ್ ಐ ಮೇಡ್ ಎ ಪಾರ್ಟಿ ಹಿಯರ್.
In view of the order dated 27/10/2022, since no application is filed to bring the legal representatives of deceased respondent number 2 on record, the petition stands dismissed insofar as respondent number 2 is concerned. Yes.
Serial number 25 order passed, 26. And then Rajaras.
Respondent. Suit is for my lord possession.
You have filed the application.
Yes, my lord. Copies are served. That was only the objection. It was served 2 hearings back itself, my lord, in the open court, and it is, he has received it. And RPID is also sent. The suit is for, my lord, the possession filed by the respondent in respect.
Not recorded, sir.
But not recorded. He has received it.
Matter is called out. There is no representation for the petitioners. Full stop. Learned counsel. For respondent number 1, who was filed IA number 1 of 2024.
And
two, that a copy of the application has been served on the learned counsel for petitioners.
Yes, ma'am.
Full stop. Next para. Release this matter on 11th of September.
Much.
27. Matsudan Adiga B.
I appear for the petition, my lord. But I appear for the respondent numbers. Respondents number 1 to 10 are served.
I've got the respondent number 1 and 2.
My lords could kindly see the order dated on the previous occasion. Lord, a submission was made that, my lord, they are not necessary parties because the application which was purported to have been filed in under order 1 rule 10. My lord, it's a partition suit and the petitioner herein is a third party. And that being the case, my lord, it is not required that, my lord, all should be heard in the matter.
You are the contesting respondent.
Yes, my lord, we both are contesting.
I am contesting.
Which is the impugned order?
Impugned order.
Annexure A.
Annexure A.
Page 16.
1/6. Annexure A. There is a suit for partition. The respondents 1 to 12 are.
Impleading applicant.
Yes.
You filed an impleading application.
Impleading application.
That application was rejected. The plaintiffs contested the application.
Yes, ma'am.
Only plaintiffs.
Plaintiff and defendant number 2 to 5 also contested. My lord, our primary ground was, my lord, in respect of one item of the property.
Suit for partition.
In a suit for partition. I'll submit. It's a suit for partition. One item belongs to me. I am a total stranger to that family. I mean, no way connected. It is my property. That has been included in their suit schedule properties.
It was sold by one of the members of the
Not
family?
sold. Not at all sold.
Then?
They have included in their suit schedule.
No. From whom did you get the property?
I have purchased it from someone else. It is
So that property does not belong to the family?
Not at all.
According to you?
Yes, my lord. It is my property. They have included it in their schedule. So to clear the matter, I filed an impleading application. That is rejected, stating that this cannot be a title suit.
All right.
My lord, now may I make one submission?
Yes.
In respect of that particular property, he has filed an independent suit against me in the very same court. That is pending adjudication.
That's all right, sir. But if you are saying he has filed a suit, but without impleading him, you want that property to be shared amongst yourselves.
No. That is not the case. My lord,
both properties are different. My property is survey number 126, my family properties.
Yes.
They are claiming the rights in survey number 47P19.
Yes.
Still, it is existing in the name of the petitioner.
Yes.
They are exercising the rights by executing the separate documents.
No, madam.
Both properties are different.
No.
Now, the 126 survey number, my property, my family property has been acquired in year 2018 by the KIDB and passed the award. Subsequently, recently in 2021, the property of the petitioner has been also notified. Both kindly see, my lord, the documents.
Why is that property in the schedule?
No, schedule. Survey number
It is not there in the schedule.
It is there, but schedule
Let
number.
us see, let us see the,
Survey
let us see this.
Item number 5 of the schedule, my lord. Page number
My lord, kindly
31.
see,
Page 31, your lordship, may kindly go to page 31.
I'm furnishing the RTC and also other documents.
1 minute.
Item number?
Item number 5, my lord.
Five.
126 survey number.
Hmm.
Earlier, it was a part of the larger survey number 47, which was more than
4
420.
acres.
4 acres.
Ah.
Earlier, it was 47 Gomala, 420 acres. Then subdivided 47/P19. Then later it was given 126. And that is my property. 47/P19 earlier, then 126. Now they are telling it is their property. And I have got all documents to show that it is my property. Sale, registered sale deed, all documents. And I have filed this suit for declaring that only one defendant. Other defendants are not there. Now there will be two conflicting judgments, my lord. One judgment says that you are entitled for partition. Another judgment says it is my property. There will be conflicting judgments. So to set right, I filed an impleading application.
My lord, furnishing the documents and RTC and other documents. Still, the survey number both are different. And moreover.
RTC is produced ಮಾಡಿದ್ದೀರಾ?
No,
I
I am
am
furnishing. Now I am
produce RTC. That is my case, my lord. They have got mischievously included their name in the RTC. That is also under challenge. They have got their name included in the RTC, which is my property.
My lord,
That is also under challenge.
in reason of the application, in support of the application.
No, there is no harm if I am included there.
It shows that both properties are different.
No.
They are purchased the property as per their affidavit in the year on sale deed dated 7/7/2007. My lord, kindly
So
see the.
you are arrayed as dependents in his suit?
No, I am the plaintiff.
I am arrayed as defendant.
In his suit?
In his suit,
He
I
is
am
also
arrayed as
filed one
defendant.
suit?
Yes, my lord.
Only the plaintiffs are arrayed as defendants?
No.
They
Defendant
have
number,
not met-
defendant number 2 to 5 have been arrayed as defendants in his suit. My
What
lord,
is your contention in that suit?
in that contention, my lord, that property is altogether different. It has got nothing to do so far as my property
you
is concerned.
said?
Yes, I have said so.
Huh?
I have said so. And apart from that.
If you had said that, then the suit itself would have been decreed on admission.
No, that is not the case, my lord. He is showing altogether wrong property. And apart from that, he is not claiming any right over the property. His suit was, my lord, the subject matter of this property is the subject matter of acquisition by the KIDB. My lord, there will be a deposit by the KIDB before the competent court. My lord, he has got every option to make a claim there. Instead of he coming and making an application in a partition suit or maintaining another suit does not arise at all. In that suit also, we have taken up that contention. My lord, in a partition suit, a third party cannot come and agitate his right. It is always open for him to seek a declaration first, prove that it is his property at first instance. And then he can, even at the stage of FDP also, my lord, he can come and claim that. And moreover, it is a subject matter of acquisition. LIC matter al bandu avaru objection hakbodu, claim ಮಾಡಬಹುದು.
My lord, as
How is it that you have filed a suit then?
I have not filed this suit.
No. This suit. In this suit.
This suit is filed. This suit is between us, my lord.
Correct.
It is, we are contesting this thing.
Even between yourselves.
Yes.
If the property is already acquired.
Yes.
According to you, it is acquired.
Acquired.
How is it that you have again made it a part of the suit schedule?
No, it is acquired after filing of the partition suit.
2021 is the.
2016 is the suit.
2016.
16 is the suit.
That
My lord,
time-
acquisition is the during the 2018. And for that reason, my lord, and apart from that, even this honorable court in respect of that partition suit also has clearly held that, my lord, since majority of the lands are subject matter of acquisition, it can take its own course under the provisions of Land Acquisition Act.
Now for the same remedy is available to him also. If at all, my lord, there is a deposit by the land acquisition officer, it will be made a reference to the civil code. He can always make an application there. His right will be protected there. If at all he has got any right over the property.
So in respect of the same property. you
Same
have filed a
property.
suit.
No,
In respect of the same property, you have filed a suit.
I have filed a suit in that all these parties are not parties there.
All right.
There are only some parties.
Yes.
That this land, which is not their land, they are trying to mislead KADB, all those are not in the picture, my lord. KADB acquisition is there, they say you go and settle in this.
Yes.
They say you get a decree from here.
All right.
So they're confusing the issue by bringing out KADB or non-relevant issues. Here,
Your lands are not acquired.
no, this is, that is my land, it is also subject to acquisition.
According to you.
126 is my land, survey number 126
This
is
is
my land.
only one land.
Yes.
The same survey number is there.
Yes,
These are not different.
not different.
It has been acquired.
Acquired. Acquired is still process, not finalized. Not finalized, my lord.
Allah, final notification has been issued.
Final notification.
Yes, ma'am.
In preliminary notification, whose name is shown?
My name is shown.
My lord.
My name is shown.
In respect of survey.
Your name is shown.
Yes.
My lord.
Because he has got the RTC entry say mysteriously entered in his name.
First you rectify that. So far as that ಮಾಡ್ಕೊಳ್ಳಿ first, then you cannot complete.
He has not mysteriously entered the RTC in his name, and that is under challenge now pending before the DC. It is pending before the DC. Orders have to be passed. I have challenged there. I have filed a suit for declaration stating that 126 is my land. That is pending. Here, meanwhile, the partition suit, they have included this land.
All right. You
There is
take,
conflicting decrees, my lord.
you take advantage of this order. That despite you trying to implead yourself in the suit, they have registered and they have got the application dismissed. You take advantage of that. You tell the same thing during the course of the argument there.
In which case, my lord?
In your suit,
My suit.
you say, despite you trying to implead in the suit filed by them, they
Still
said
in
no,
the
no.
preliminary stage, but still issues on it will take its own time, long time.
ಆಗ್ಲಿ, ತೊಂದ್ರೆ ಇಲ್ಲ.
But conflicting judgments ಬರುತ್ತೆ ಅದಕ್ಕೋಸ್ಕರ ಅಲ್ಲಿ ನಾನು ಇಂಪ್ಲೀಡ್ ಮಾಡಿ ನಾನು ತೋರಿಸಿದ್ರೆ ಇದು ಇವ್ರ ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲ ಅಂತ ಅಲ್ಲ if I am able
But
to
if he is not
demonstrate,
party to
it
the
will
suit,
cause
how will
issue.
it bind
They
it?
want to complicate the issue, keep the matter pending so that I'll compromise and pay them and have some money. That is all their intention.
No, that is the other way
Their
around.
intention.
It is other way around, my lord. It is not
It's
the
all their
case.
intention. They have not got a single document. They have one document, land was allotted to them and they have sold it and they're claiming one more land by getting the, they will not all documents, they are doing it. So that I pay ransom money and compromise. Then they send feelers. You settle it. That is all their issue. Conflicting judgments is there. If this impleted, I can demonstrate and show that it is not their property. That's all my submission.
My lord, in the affidavit itself clearly shows that both properties are different. In support of the application, Order 1 Rule 10, they filed the affidavit. In para 8 and 9, 10 clearly shows that both properties are different.
Sir, as I said in the beginning, if that was your contention, you could have filed a written statement there saying, no, this is not a
They have
property
not
belonging
made
to us. But you are not doing, you are not prepared to do that.
They have not made the plaintiffs as a parties to their suit.
Yes, I have, my lord, I have disputed
I am
very
for the
claim of his.
That is what?
I have disputed
That
his
is the
claim.
problem.
ಈಗ
There also you will dispute. Here also you will dispute.
My lord, that is not the situation here. I'll, if my lords could kindly for a moment. My lord, he claims a right in respect of a altogether a different property. Indicating that, my lord.
You should have said in the written statement.
Yes, we have said.
Look here, my property is different.
Yes. That
It
is
has
what
got
my written
so-and-so
statement
boundary.
is.
It has been notified and acquired.
Yes.
And this property which he is claiming, I have got nothing to do with it. And you can proceed to pass a decree.
In that suit, the
You are not ready to do that.
survey number shown is.
You are not ready to do that.
My lord, what he has done is,
Yes.
my lord, with regard to the history of the property, initially he indicates that, my lord, it is some other survey number. Thereafter, my lord, he gives certain flow of title which is very illusionary. And finally, he comes to say that, my lord, this particular property and that are one and the same. That aspect has been disputed by me by filing a detailed written statement. And apart from that, my lord, his so far as his suit is concerned, he files the suit when the property was notified for acquisition. And the prayer in his suit is that seeking a declaration that the compensation which is yet to be deposited belongs to him. That is his suit. My lord, in fact, my lord, that suit which has been filed by him is not at all maintainable for the simple reason that there is no assessment as on today by the land acquisition officer, no deposit as such, but still he files a suit stating that he is alone is entitled for the compensation which is yet to be deposited. That is his suit. We have filed a written
Suit, my lord.
declaration suit. That's what. Thereafter,
That
my lord,
declare it as my property.
thereafter, we have filed a written statement stating that he has right to play a mischief on the court by bringing in different survey numbers. And so far as my land is concerned, it doesn't belong to him. I have resisted such suit. Now, my lord, as on today, that suit issues are not framed, it is pending adjudication. Now, so far as his claim in respect of the properties are concerned, my lord, majority of the portion of the land in so far as the schedule in this suit, which is the subject matter of this writ petition, and the suit which is filed by him are subject matter of acquisition. My lord, whenever there is an acquisition, land acquisition officer passes an order of award. My lord, then if there is any dispute, it will be deposited before the civil court. In that, my lord, he has got every option to come and resist the claim or make a claim in that property. That would be the simple aspect, my lord, which he can do. Instead of that, in a partition suit, if he comes and impleads, now his contention is two divergent decrees will be part. My lord, if at all he is not party to that suit, it will not bind him. If he is not a party, if there are any decrees passed, it will not bind him.
That is the observation of the trial
Yes,
court also.
that is what, that is what, my lord. So unnecessarily, my lord, he has come all the way here.
All right. That's why I said you take advantage of it.
My lordship may permit me to read paragraph 3, my lord, of my affidavit, page 37.
We'll make the same observation. You take advantage of it.
Anyway, permit me.
They should not come and seek to execute the decree, even if it is passed. It shall not be executed against you.
What's what?
Purple.
Lord, that should be subject to the result of the suit, because if at all, my lord, he fails in his suit, with regard to the declaration, my lord, then he should not come and say, no, Honorable High Court has passed an order.
Decree passed in this suit,
Please.
will not bind him and it cannot
Yes,
be
that-
executed
that-
against
That would,
him. Yes.
that would be, my lord.
The petitioner who had filed an impleading application in the suit filed at the ends of response number 1 and 2 herein is before this court aggrieved of the rejection of the application. Next para. It is the contention of the petitioner that suit item number 5 bearing survey number 126 situated at Polanahalli, Chandrayapatna Hubli, Devnalli Taluk, measuring 4 acres, belongs to the petitioner. Stop. It is also the contention of the petitioner that the said land has been notified for acquisition at the hands of the Karnataka Industry Areas Development Board. Full stop. The petitioner has also filed OS number
454/2020, my lord.
454 of 2020
Please.
against
Against the defendant number,
Respondent no 4 and 5.
respondents number 4 and 5.
4 and 5.
4 and 5.
Herein seeking declaration.
Declaration to declare that, my lord, the compensation yet to be deposited, he alone is
I am the
entitled.
absolute owner of this food schedule property.
No, that is not your prayer. You filed the plaint in that suit.
Yes, you don't see the, you don't see, you don't have a paper and you are submitting without a paper.
I don't require paper from me. I will.
I have filed it.
Tell me that. Where is the plaint?
Where is the plaint?
That 454.
They have not produced.
They have not produced.
That plaint I have not produced. In that I saw declaration that it is my property.
Seeking declaration that the petitioner is the absolute owner
Yes,
of the
ma'am.
suit schedule property and that the petitioner alone is entitled for compensation
Yes, ma'am.
that would be awarded by the Special Land Acquisition Officer of the KADB.
Yes.
Full stop. However, after coming to know that respondents number 1 and 2 have also filed a suit in OS number 638 of 2016 seeking partition and separate possession, and item number 5 of the schedule is the property belonging to the petitioner, namely survey number 126, the petitioner filed an application to implead herself and defend her title to the suit. Her title to item number 5 of the suit schedule property. Full stop. Nevertheless, the application has been rejected on the ground. Where is that order?
That order, my lord.
Order annexure A.
Page number, your lordship may kindly go to page number
Operative
21.
question 19.
Page number 21, my lord,
19.
the reasons.
Reason.
If the same is ordered, the present suit will change its nature. It is clearly appearing that the impleading applicant is neither a necessary nor a proper party. Page number 21, my lord.
On the ground that the impleadment of the petitioner will change the nature of the suit. Full stop. Moreover, since the petitioner is also has already filed a suit seeking declaration, the petitioner need not be impleaded and heard in this suit. Full stop. Learned counsel for the petitioner, however, submits that the petitioner was only worried that if she is not impleaded in the suit, there may be conflicting opinions. Full stop. Next para. On hearing the learned counsel for the petitioner and the learned counsel for the respondents, and on perusing the petition papers, this court is of the considered opinion that since the petitioner has already filed a suit seeking declaration of title, even if the suit filed at the hands of response number 1 and 2 herein in OS number 638 of 2016 is allowed. However, insofar as the suit filed by the petitioner in respect of item number 5 will protect the interest of the petitioner. Full stop. The if the suit filed by the petitioner in OS number 454 of 2020 is decreed in favor of the petitioner, then the judgment and any judgment and decree passed in OS number 638 of 2016, insofar as item number 5 is concerned, shall not be binding on the petitioner. Full stop. The court, considering OS number 454 of 2020, filed by the petitioner, shall also take note of the fact that the impleading application filed by the petitioner in OS number 638 of 2016 was dismissed. Full stop. Next para. With these observations, the writ petition stands disposed of.
Lord, may I make one request? Since the suit is of the year 2016, that there be time bound order.
ಅದಕ್ಕೂ ನಿಮ್ಗೆ ಸಂಬಂಧ ಇಲ್ಲ ಹೋಗ್ರಿ.
ಆದ್ರೂ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಅನುಕೂಲ.
No, no.
Compensation ತಗೊಳ್ಬಾರ್ದು.
Yes.
ಅವ್ರದ್ದು ಇಂಟ್ರೆಸ್ಟ್ ಕಂಪನ್ಸೇಷನ್.
Number 28.
I appeal to the respondents in this matter, my lords.
I will comply with that observation, my lord. It's very minor. Partly I have complied. It may be called in the next week. I'm ready for argument.
No, I object, my lords. My learned
Interim order may
friend
kindly be extended.
has taken time. Ground also he has raised stating that there's alternate remedy and he'll file an MFA and that interim order, you kindly see the interim order dated 21/3/2024. He is due 16 lakhs rent, my lords, arrears of rent from last 4 years. Kindly see the order dated 21/3/2024. And
Not
paragraph
regarding
7
that,
of
my
the
lord.
para 7 of the writ petition, he has said that MFA is
Yes.
maintainable and he is fine. He is conducting a luxury litigation. Para 7 of the writ petition also, my lords. MFA is maintainable ಅಂತ ಅವರೇ ಹೇಳಿದ್ದಾರೆ.
Yes, really. What is your submission?
My lords, para 7.
Turn to page 78, my lords. There's clear arbitration clause. He suppressed that, takes an ex parte decree.
Huh?
I'm evicted. He is holding my deposit. He doesn't take that refunded deposit.
Para 7 of
At
the
the same
petition.
time, he claims it as damage, filed a surprise execution for a recovery of the amount.
You are a judgment debtor.
I am the judgment debtor. I have questioned the very execution of the decree itself, not based on Chaman Paswan case, my lord. When there is an arbitration clause, he suppressed from the court, takes the execution of in the commercial premises. I am thrown out. Thereafter, he retains my furniture there, and my deposit of rupees 11 lakh rupees is there. He doesn't even adjust that. He takes an arrest warrant against me when the decree is not executable.
My lord, kindly see.
Let him file objections, my lord. I'll argue the matter finally next week.
So
Kindly
you have
see-
not participated in the proceedings.
Pardon, my lord?
You did not participate in the
No, it
proceedings.
was an ex parte decree.
Ex parte decree.
Yes.
And miscellaneous
And
Act.
Leonard Judge says a double jeopardy. How can judge jeopardy apply to the civil proceedings, my lord?
My lords, kindly see para 7 of the writ petition. Para 7 of the writ petition. ಅವರೇ ಹೇಳ್ತಾರೆ against that order MFA ಹಾಕ್ಬೇಕು. I am just filing writ petition today ಅಂತ. Kindly see, the petitioners have not filed any other writ or so and so challenging the impugned order as assailed under the and are filing MFA against orders. ಅವತ್ತು ಹೇಳಿರೋದು. And ex parte interim order ತಗೊಂಡಿದ್ದಾರೆ. And he knows about the order in 2022. In 2024, he files miscellaneous petition, making false assertions. And the interim order was strictly granted only on that ground that he will file it immediately. And ex parte.
You will not file then.
I'll make my submission, my lord. Let him file his thing. I will argue it on the next week, my lord.
No, no, no. It was granted only for the limited purpose.
Please, your lordship, I kindly, I will place because I thought, let me comply with the objection first, my lord. Your lordship, kindly turn to page 78.
Sir,
No,
you
he
have
can't
got
argue
an
on merits, my lord.
There is arbitration clause.
You have got an interim order on 21/3/2024.
Pardon, my lord?
This interim order was passed on 21/3/2024. And you are not complied with the office objection.
No, that was in a miscellaneous petition, my lord, which they directed me I should deposit the entire amount. Then I requested I'll deposit 20%. the court did not grant it, but the entire civil misdemeanor is dismissed. That is one issue as against independent proceedings, my lord.
No. In this writ petition,
Ah.
interim orders were passed on 21/3/2024.
Yes.
And you are not
It
compliant.
was
with the
again
office
continued on
objections.
15/4/24.
Huh?
15/4/24, it was continued.
That's what, sir. On 21/3/24, only for the limited purpose, you were
Yeah,
heard.
It was
And
granted.
interim order is passed. You have not complied with the office objections.
15/4, my lord.
You have not complied with the office objections.
No, because.
Although the
no, no.
interim orders were passed in the
What
month
does,
of March.
what does, my lord, when the matter was.
And if you have said that
when
the
matter was-
MFA,
no, no,
MFA is
please, my
maintainable.
lord. When the matter was posted, I had complied with all the objections. Subsequently, it was informed, my lord, I'll comply. That's the reason, within 1 week, I'll comply. I'll argue the matter finally.
Sir, you have said in your
And that
petition
there was a
itself.
deficit 100 rupees court fee, my lord, deposit that. And regard the other one is page 83 should be numbered as a separate annexure, they say.
My lord,
That
so
I will comply with, my lord. The other one is I will have to produce a copy of the eviction petition. That I will produce it.
office objection is
These
not.
are the minor office objections which are later noticed.
MFA
See,
ಆಗ್ತದೆ.
in the memorandum of writ petition itself, in paragraph number 7, you have said MFA should have been filed.
What, my lord?
In paragraph number 7 of your writ petition.
Petitioner not filed any other challenge the impudent assault in or MFA filing against the, because under com miscellaneous I'll have to file a MFA.
Then
That is independent, my lord, regarding the ex parte decree that has been passed. This is filed in the execution petition where he is trying to recover the amount, and I have objected to it that the decree is inexecutable. These are two independent proceedings.
have you filed MFA?
That I'll check up, my lord. My colleague, I will this thing, my lord. Because she was handling it, I look into it. I'm asking only for 1 week time to ascertain and this thing, my lord.
You please come before the court, sir.
Please, my lords,
We will
please.
give a date. You please come before the court. We'll dispose of the matter next date.
I'm sorry, my lords, I'm sorry.
Learned counsel for the respondent points out from paragraph number 7 of the writ petition that the petitioners have themselves stated that a miscellaneous first appeal is required to be filed against the orders passed by the commercial court. And it is also a fact that interim orders were passed by this court on 21/3/2024 for the limited purpose of enabling the petitioner to challenge the order dated 17/2/2024 passed in commercial miscellaneous 8 of 2024. Full stop. It is also pointed out that the office objections have not been complied despite the interim orders passed by this court. Full stop. Next para. Release this matter on 11th of September 2024. Full stop. The matter will be heard and disposed of on the next date of hearing.
Interim order may kindly be continued.
Interim order granted earlier stands extended till the next date of hearing.
I'm sorry, my lords.
A.V. Amarnathan.
Respect to office objection, I filed a memo dated 31/8 furnishing the partnership deed, my lordship, registered partnership deed.
You have furnished in the office.
Yes, my lords. On 31/8 itself, I furnished in the office.
Office objection not complied anta baritar matte.
Yeah, that is with respect to
31/8.
31/8.
Learned counsel for the petitioner submits that he has furnished a copy of the registration
Registered
certificate.
partnership deed.
Huh?
Partnership deed.
Copy of the partnership deed in the office on 31/8/2024.
Yes,
Full stop. Office to verify. This has to be listed for preliminary hearing.
yes, ma'am. Notice, ma'am, notice of it.
Only notice.
It is a suit for injunction, my lordship. I am for the plaintiff.
Next para. Issue notice to the respondents. Yes.
13. Why are ready?
In this case, the petitioner is defendant in the word. The respondent is the plaintiff.
Here interim prayer.
Interim prayer is great suspect.
Huh?
To stay the further reason, because
there is agreement of sale in favor of my vendor Azan 6/5/1998 as per annexed F. Miller. There is power of attorney coupled with the affidavit. In that, the plaintiff herein was the witness to the said annexed F. Later, the plaintiff obtained the release civil on 1/7/1994,
Office objection is
including
over.
my property.
Office objection is overruled. ಹೇಳಿ.
On 1/7/94.
Respondent has filed a suit for
bare injunction, then conversion, declaration of title and injunction.
declaration.
Declaration. Where I have filed detailed retention. My previous vendor obtained GP as per annex F dated 6/5/1998 from Chaudamma and her foster son A. Krishnappa in favor of on Chandrasekhar. Annex F, sir.
You are agreed of which order?
The plaintiff filed.
You are agreed of which order?
IS6. That is, the plaintiff filed up to 13 under 3 Rule 2 to examine as a power of attorney holder of.
The plaintiff is permitted to prosecute the case through her power of attorney.
Power of attorney.
You are agreed of that order.
Agreed, because of the reason is, the plaintiff was the signature as a witness to my document as per Exhibit P, as per F. Leela. She has filed the same suit. They want to give evidence through their power of attorney. My submission is to prove title or evidence is necessary to confirm the signature which she put a signature in the annex F. They have stated it's a matter of evidence. It can be decided out of time of final argument. And the further stated, you can prove that in the other mode of it. With great respect, this is a crucial document, declaration of title. I also stated in my affidavit, clear objections in my objection, that she says she is suffering from illness.
Will
She could not able to. I have also stated in my objection
Notice to the respondent.
let she be.
The petitioner is also permitted to serve a copy of the petition along with annexures on the learned counsel representing the respondent before the trial court.
I have
Read
felt
this matter on 25th of September. Yes.
31, G. Balakrishna Shastri.
Officers, yes, objection that type copy of Annexure C is to be filed, my lords. The relevant portion of Annexure C, my lords, that is order dated 6/1/2010 and 8/4/2007 are in the type portion, my lords. It's page 146 and page 158, my lords.
Yes, office objection is overruled.
The second objection is that, my lords, there is no preamble portion for Annexure C and C.
That's all right. I said office objections are over. Yes. You want this matter to be listed for preliminary hearing?
Please.
List this matter for preliminary hearing on 10th of September, Tuesday. Yes.
Great.
32. I'm seeking dispensation of notice, my lords, respondent number 1 to 67, 69 and 70, my lords. The contesting respondent is only 68, different numbers.
You filed a memo.
I am filing memo.
1 to 37 and 39 and 70.
69 to 70, my lords.
Learned counsel for petitioner has filed a memo seeking dispensation of notice to response number 1 to 67, 69 and 70.
70.
On the ground that
Plus, this respondent number 68 is the only contesting party to this application.
respondent number
68, my lords.
68 is the only contesting respondent to these proceedings. And no claim is made against the other respondents. Full stop. At the risk of the petitioners, notice to response number so and so is dispensed. Yes.
Start for my lord, in this case, may I make one submission, my lord? Now the matter is processed for judgment.
Not now, not.
Notice has been ordered, my lord, 68, respondent 68 is served. My lord, I filed application to examine the 68, respondent number, defendant number 68, my lord. He is the custodian of the documents to prove my case, my lord. My application is came to be dismissed. Now the matter is processed for, my lord, judgment. I am start for further proceedings of stay, my lord. Application consideration.
When the matter comes up of preliminary hearing,
Notice has been ordered.
court will consider your prayer for your interim prayer. If no interim prayer is granted at that time,
The notice was
we
ordered.
can't
my lord.
consider again, sir.
Respondent is already served, my lord. He is not representing.
Why do we order only notice
That
instead
time,
of granting a interim prayer?
notice was ordered, my lord, till the, my lord's appearance of respondents, my lord.
Yes,
May I make one request, my lord?
yes.
Tuesday or Wednesday, it may be have it, my lord, for preliminary hearing, my lord, it may be disposed of.
Release this matter on
Tuesday, my lord,
18th of September.
for preliminary hearing, my lord.
Huh?
For preliminary hearing.
Yes.
33, MK.
The office has raised objections to producing the miscellaneous petition copy, my lord. In fact, filed a application for 39 Rule 2A application. That application came to be converted a miscellaneous petition. The office has raised objection to produce the miscellaneous petition. Application also produced page 34, my lord. The office raised objections. ಅದನ್ನೇ ಕನ್ವರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅವರು ಮಿಸ್ಲೇಟ್ ಏನೇ 39 Rule 2A ಮಿಸ್ಲೇಟ್ ಪಿಟಿಷನ್ ಆಗಿ ಕನ್ವರ್ಟ್ ಮಾಡಿ ಸಪರೇಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತ ಇನಿಷಿಯೇಟ್ ಮಾಡಿ. That has been produced before this court in page 34, 39 application.
Order 39 Rule 2A.
A application ನ ಕನ್ವರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಮಿಸ್ಲೇನಿಯಸ್ ಆಗಿ ಕನ್ವರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಸಪರೇಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
Nature of respondent number 45,
45 ಅಂತ ಕೇಳಿದ್ರೆ ಅದು ಡೆವಲಪರ್ ಐ ಆಮ್ ನಾಟ್ ರಿಲೀಫ್ ಸಾಟ್ ಓನ್ಲಿ ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಐ ಆಮ್ ಸೀಕಿಂಗ್ ಫಾರ್ ಓನ್ಲಿ ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಆಫ್ ದಿ contempt petition before the trial court. In the year 2018, I filed a contempt, convert the contempt application. That application, one or the other reasons to adjourn the matter. Now they already PW examined. Then subsequently, one or the other matter were adjourned. Only I am seek relief only to speedy disposal of the contempt petition. My prayer is only.
Office objections are overruled. Next para. Learned counsel for the petitioner submits that the petitioner plaintiff before the trial court filed an application under Order 39 Rule 2A of the CPC to pass an order to detain the legal representatives of defendant number 16, 17, 18 and 25 in civil prison for willful disobedience of the orders passed by the trial court, passed by this court.
Also by this court. Passed by this court. ಇಲ್ಲಿ MAP ಆಗಿ ಪಾಸ್ ಆಗಿ ಅಲ್ಲಿ ಹೋಗಿತ್ತು.
On 6/4/2011 in MFA number 969 of 2011 and further to attach their properties. Full stop. The prayer in this writ petition is to direct the learned 22nd Additional City Civil and Session Judge CCH-7 to consider and dispose of the said application which has been converted into miscellaneous number 809 of 2018, comma, within a time frame. Full stop. Next para. Having regard to the innocuous prayer made by the petitioner, comma, the writ petition stands disposed of with a direction to the learned so and so judge to consider and dispose of miscellaneous number 809 of 2018, which in fact arises from the application filed by the petitioner plaintiff under Order 39 Rule 2A of the CPC on 18/2/2017, comma, as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order, ordered accordingly. Your CCS 7. For that purpose, this court also deems it fit not to issue notice to the respondents.
34. Ranjit Shekhar V, maintainability.
Matters called out. There is no representation for the petitioner. Release this matter on 11th of September. If there is no representation for the petitioner on the next date of hearing, the writ petition will be dismissed.
35. Ravi Shankara.
Appealing for the petitioner, my lords.
Yes.
Lord, for the respondent, I filed power this morning, my lord. My name may be shown. I
Learned
need
counsel,
instructions. Vijay Kumar Prakash.
Vijay Kumar Prakash.
Prakash.
Submits that he has filed wakalat.
Yes, my lord.
For
This
all the
one,
respondents.
all 4 respondents.
Full stop. Office
I
to
have-
verify and show the name of the learned counsel
Yes,
in the.
I have a small
cause list.
submission to make. It appears, my lord, I'm not sure that written statement and objections were filed before the trial court. The subject matter of this writ petition is that ex parte interim injunction was denied to them. In the meantime, objections and written statements have been filed, I believe. And plaintiff has also addressed his arguments. It is posted for arguments of the defendant. And whether this writ petition would survive, because that is already concluding, and it will be open to him to urge all the grounds, my lord, before the trial court. And if he were to fail there, MFA, the option of MFA is also open to him. So that is my submission. This is what I was told this morning, my
What
lord.
is
I
the
do
prayer-
not know
what
if
is the
my-
prayer in the writ
My
petition?
lord,
the prayer in the writ petition is challenging the order dated 19/7, wherein the honorable
That is
trial
only
court-
when only notice was issued.
only notice was issued, my lords. My lords,
Learned counsel for the respondents further submits that the petitioner plaintiff was aggrieved of issuance of notice
Was it argued?
without considering the prayer for issuance of ad interim temporary injunction
Ex parte injunction.
before hearing the defendants.
Please.
Under order 39, rule 1 and 2. Full stop. However, subsequently, the respondents, defendants have
Defendants
appeared
appeared.
before the trial court.
Yes, my lord.
They have filed a written statement
And objections.
and objections to the applications filed by the petitioner.
they have
Full
filed a
stop.
memo adopting the written statement as objections.
Next para. The learned counsel for petitioner is therefore required to secure instructions and make submission.
Please, my lords,
Full
one
stop.
humble submission.
Release this matter on 11th of
I have
September.
a humble
Lord,
submission.
13th,
my
my
lords.
lord, 11th, I'm out of station, 13th, if you're
Lord,
lordship.
13th.
Please.
I have a humble submission, my lords. On 22/8, my lords had permitted me to serve on the respondent counsel before the trial court. I had subsequently to comply with the order,
They
tried
already-
to
No,
serve.
I've already filed
There was a
power.
different counsel over there, according to,
That's all right, sir. Not
That's okay.
necessary. Yes,
please, my lord.
6.
yes.
Rajesh A.
Lord, in this matter, my lord, I fix for 10 days' time. I'll file wakalat for other respondents and I'll
All the other respondents.
all the other respondents.
Learned
Two-
counsel Shri
2 weeks
K.R.
time,
Ramesh
please.
submits that he will appear for the other respondents who have remained unserved.
Please.
Full stop. A week's time is granted to the learned counsel to do the needful.
2 weeks. Okay.
2 weeks, yes.
The interim direction may be.
Interim order granted earlier stands. extended
Also,
till
this
next date of
Honorable
hearing.
Court has directed me to punish them on citation, my lord. I'm on that.
Not now, yes.
7. Deepak Bhaskar.
I'm appearing on behalf of the petitioner, my lords. There is an office objection which raises the issue of maintainability of this writ petition due to section 96.
Yes.
Now, my lords, the order that is, that we've sought to set aside is an order in respect of an interlocutory application filed under section 8 of Arbitration and Conciliation Act, which is in respect of the power to refer the parties to arbitration where there is an arbitration agreement. Now, had this application been dismissed before the trial court, then there is an appeal under section 39 of the act. But the said application has been allowed and we are aggrieved by the
That's been
same.
rejected.
No, it has been allowed and
Ah.
we are aggrieved by the same. Therefore, this writ petition is maintainable and similar petitions have been heard before High Court of Karnataka. I have a judgment. The said objection may be.
No use simply saying other petitions have been considered. If this question is raised and answered, you please show.
In this judgment, no, my lords. But this is a writ petition under
That is not the way
227
of
seeking to.
contending that office objection has to be overruled. If an office objection is raised
Yes,
and
my
if an
lords.
issue is raised,
Yes,
you will
my
have to
lords.
answer that.
Yes, my lords.
If there is a decided case, you will have to point out.
Yes, my lords.
No use saying other petitions are being considered by this court.
Yes, my lords.
So that is not the way. at the request of learned counsel for petitioner release this matter to hear on office objections regarding maintainability of the writ petition,
Maintainability.
comma, on 10th of September. Yes.
Much obliged.
Lord, I appear for the respondents, my lord. My apologies, my lord, I had to file wakalat. The respondents were arrived only yesterday, my lord. Now, Khalid is ready, I will file this, my lord.
Learned counsel, Shri Chandan K.
For respond number 1 to
that,
3, my lord.
the wakalat is ready.
Ready, my lord.
And the same will be filed in the office by tomorrow.
Yes, my lord.
Yes.
My lord, may
There is-
please to have it on 11th or
There is
12th.
an interim arrangement that may be ordered to be continued. Interim measure.
Release this matter on
11th.
11th of September.
Much obliged.
Interim directions given earlier shall continue till the next date of sale.
Yeah,
Much obliged.
next time.
May I mention item 42? Serial number 49, serial number.
All matters next week.
Date.
ಕೊಡಕ್ ಬರೋದಿಲ್ಲ ಸರ್ ಎಲ್ಲ matters next week ಬರುತ್ತೆ.
ಅಲ್ಲ 48 ನಂದು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕಾಗಿತ್ತು.
As it is ಹಾಗೆ ಇರುತ್ತೆ. Previous ಮಾಡಿ interim order ಇದೆ, it holds good the same as it is.
As it is.
Extended, sir.
Subsisting list.
Date ಕೊಡೋದಿಲ್ಲ.
Date will be.
Sir, all interim orders will be as good as in the today's further also. ಸರ್ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್, ಡೇಟ್ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ ಸರ್. ಈಗ ನೋಡ್ತಾ ಇದಾರಲ್ಲ ಪೊಸಿಷನ್ ಮಾಡಿ ಸರ್, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
Court officer, sir.
ಯಾವಾಗ ಬರುತ್ತೆ ಸರ್? 30
ಸರ್ ಹೇಳಕ್ ಬರೋದಿಲ್ಲ ಮೇಡಮ್ ಅದನ್ನ.
Sir, court officer, sir.
serial number 38 last date
11/9
Sir, court officer, sir.
next week.
Sir, serial number 58 ಯಾವ್ದಾರ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
Next week.
Sir, serial number 58 B group ಯಾವಾಗ ಬರುತ್ತೆ ಸರ್?
Serial number
58 sir, B group first matter.
next week.
Next week sir?
Second list, serial number 4.
Court of sir. Item 47 first interim order.
All interim order will be extended. Same will be as it is. Date ಕೊಡಕ್ ಬರಲ್ಲ ಮೇಡಮ್. No date, same thing will be repeated next time.
ಈಗ ಎಕ್ಸಾಮ್ ಫೈನಲ್ ಎಕ್ಸಾಮ್ ಬರೀತಾರೆ.
Address ಜಾಸ್ತಿ ಇದೆ. Full board ತುಂಬಿದೆ, ಬೆಳಗ್ಗೆ ನೋಡ್ತಾ ಇದ್ದೀರಿ ತಾನೇ.
ಒಂದ್ಸರಿ ಕೇಳ್ದೆ 2 ಸರಿ ಕೇಳೋದಿಲ್ಲ. ಪ್ರೆಷರ್ ಬೇಡ ಯಾರು
ಗೊತ್ತಲ್ಲ
ಸರ್. ಕೌನ್ಸಿಲ್ ಬಂದಿದ್ದಾರೆ, ಅವ್ರ ಅಪಿಯರೆನ್ಸ್ ಬರುತ್ತಾ? ಬರ್ಕೊಡು.
ಇವಾಗ ಬರೋದಿಲ್ಲ
ಬರಲ್ಲ.
ಇಲ್ಲಿ ಒಂದು ಮ್ಯಾಟರ್ ರೀಚಸ್.
ಓಕೆ ಡಾ.
47 ಅದು ಫಸ್ಟ್ ಐಟಮ್ ಅಲ್ಲಿ ಅಷ್ಟೇ ಎಂಟ್ರಿ ಮಾಡಿರೋದು.
ಹಾ ಅಷ್ಟೇ ಸರ್.
ಒಂದೇ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತಲ್ಲ.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಪ್ರೀವಿಯಸ್ as it is ಏನಿದೆ ಹಾಗೆ ಇರುತ್ತೆ. ಡೇಟ್ ಕೊಡಕ್ ಬರಲ್ಲ ಸರ್ ನಿಮ್ಗೆ. ನೀವು ಕೇಳ್ಕೊಂಡ್ಬಿಟ್ರೆ ಆಗತ್ತೆ ಅಷ್ಟೇ.
ಅದಕ್ಕೆ
ಮಾಡಕ್ಕಾಗಲ್ಲ.
ನಾವು ಏನಾರ ವ್ಯತ್ಯಾಸ ಆಯ್ತದೇನೋ ಪಾಪ ತಪ್ಪು ತಿಳ್ಕೊತಾರೆ ಕೇಳಿದ್ರಿ.
ಏನ್ ತಪ್ಪು ತಿಳ್ಕೊಳೋದಿಲ್ಲ ಸರ್.
ಅದಕ್ಕೆ ಈ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್
ಇದೆ, ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಹೇಳ್ತಾವ್ರೆ ನೆಕ್ಸ್ಟ್ 2:30 ಮಾಡ್ಬಿಡೋಣ ನೆಕ್ಸ್ಟ್.
ಆತರ ಆದ್ರೂ ಮಾಡ್ಕೊಳ್ಳಿ. ಆತರ ಕೇಳಿ ಅವತ್ತು ಹಂಗೆ ಕೇಳಿದ್ರಿ, ಬೇಕು ಅಂತ ಹೇಳಿದ್ರಿ, ಅದಕ್ಕೋಸ್ಕರ.
ಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಅದೇ ತರ ಇನ್ನೊಂದ್ಸಲ ಕೇಳ್ಕೊಳ್ಳಿ ಆಸ್ ಯು ವಿಶ್. ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ಮೆಮೊ ಕೊಡ್ತೀನಿ.
ನೀವು ಚಾನ್ಸ್ ತಗೊಂಡಂಗಿದ್ರೆ ನೋಡಿ ಹೇಳ್ಬೋದು. ಅಂದ್ರೆ 17ನೇ ತಾರೀಕು ಮೇಲೆ
ಯಾವಾಗ
17th ಅದು ಹೇಳಕ್ಕಾಗಲ್ಲ ಸರ್. ಬೋರ್ಡ್ ಮ್ಯಾಟ್ರಸ್ ಬೇರೆ ಅದೇ.
MCPC ಹೆವಿ.
ಹಾ ಅದು ಇಯರ್ ಮಾಡ್ದೆ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅದು ಏನ್ ಮಾಡ್ತಾರೆ
ಬೇರೆ ಸಬ್ಜೆಕ್ಟ್ ಆಗಿದ್ದು.
ಬೇರೆ ಸರ್ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ ಅದು ಮ್ಯಾಟ್ರ್. ಇಲ್ಲಿ ಎಲ್ಲಾ ಕಡೆ ಏನೇನೋ ಹಾಕ್ಬಿಟ್ಟಿರ್ತಾರೆ, ಏನೋ ಮಾಡಿರ್ತಾರೆ. ಕೇಳಲೇಬೇಕಾದ್ರೆ ಗೊತ್ತಿರುತ್ತೆ, ಆದ್ರೂ ಕೇಳಲೇಬೇಕಾದ್ರೆ. ಆಯ್ತು.
ಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಏನಾಯ್ತು ಸರ್?
ನಾಳೆಗೆ ಅಂತ.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲ
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆ ಮೇಡಮ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಸರ್ ಡಿಸ್ಪೋಸ್ ಆಗಿತ್ತಾ?
List number 2, all matters has been disposed of matters because of influxes.
ಹೌದಾ? ಅಲ್ಲ ಆರ್ಡರ್ ಸೀರಿಯಲ್
ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ.
ಆಗಿದಾ? ಓಕೆ ಓಕೆ. ಮೆಮೊ ಹಾಕಿದಾರಾ? ಓಕೆ ಓಕೆ
ಹಾಕಿದ್ದಾರೆ.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಸರ್